My lord, kind permission. Matter for vacating entry model, my lord. The RA kindly posted for.
ಕೊಡಿ ಕೊಡಿ ಸರ್ವ್ ಮಾಡಿದಾರಾ
First,
ಅದರ್ ಸೈಡ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಾರಾ ವೆಕೇಟಿಂಗ್ ಗೆ
I am the proxy.
ಆಯ್ತು ತಗೊಳ್ಳಿ.
fresh matter, Your Lordship. Based on the impugned order, the respondents are trying to interfere with the peaceful possession, Your Lordship. Therefore,
ಕೊಡಿ 24 ಮ್ಯಾಟರ್
yes, Your Lordship.
24.
My lord, regular settlement of fresh matter, my lord. My lord.
What is the urgency? What is the urgency?
They filed existing and they
Yes.
filed demolition, my
Yes,
lord.
yes. Okay.
Kindly have it, my lord.
ಹಿಂಗೆ ತಗೊಳ್ಳಿ. Saturday.
Admission, new matter admission.
Yes, you can give.
That's a fresh
Fresh
matter.
matters, my lord, for admission.
Urgency ಏನು ಇದೆ?
The property which is being.
It will come in usual course.
That's a
ನೋಡಿ
fresh-
ಮೇಡಮ್ ಎಷ್ಟೆಷ್ಟು ಮೆಮೊ ಕೊಡ್ತಾರ ಎಲ್ಲ ಹಾಕ್ಸ್ಕೊಂಡ್ ಬನ್ನಿ ಪ್ರಪೋಸ್.
Admission.
Fresh matter, Lordship. There are precipitating with FDP proceedings have been filed in respect of the RA which has been allowed. Suit is one for partition, Lordship. So any
ಯಾವ ಇಯರ್ದು?
2023, Lordship.
23 ಆಯ್ತು ತಗೊಳ್ಳಿ.
Great.
Serial number? Council no mentioning for orders, only mentioning for admission and final hearing. Whatever it may be, council admission and final hearing itre matra mention ಮಾಡಿ. When the matter called, you make a mention.
Seventy
70 to 77.
77, my lord. In this matter, my lord, the appellant is dead on 39/2019, my lord. Necessary application.
2019.
39/2019 ಹೋಗಿದ್ದಾರೆ ನಂಗೆ ಈಗ ಗೊತ್ತಾಯ್ತು ಈಗ.
Appellant counsel submits that appellant is no more and hence seeks 2 weeks time to bring the LRs of appellant. And hence list this matter on 4/7.
My lord, sir, 44, I missed it. 1 week's time.
44 orders ಅಲ್ಲಿ ಇದೆಯಾ? Orders ಅಲ್ಲಿ ಇದ್ರೆ no mentioning. Orders 70 ಮ್ಯಾಟರ್ ಇರುತ್ತೆ, ಎಲ್ಲಾನು ತಳ್ತಾ ಕೂತ್ಕೊಳ್ಳೋಕಲ್ಲ. RSA 40 of 2018. Office objection raised on memo for withdrawal of appeal.
I have forgotten sign ಮಾಡಿದ್ವಿ.
ಕೊಡಿ ಸೈನ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. ಕೊಡಿ ಸೈನ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ.
So party ಮಾಡಿದ್ದಾರೆ, ನಾವು ಮಾಡ್ಲಿ. ನಾವು ಮಾಡ್ಲಿ.
ಪಾರ್ಟಿ ಮಾಡಿದ್ರು ನೀವು ಮಾಡ್ಬೇಕಲ್ಲ. You have to identify. ನೋಡಿ, counsel for the appellant has filed memo. ಏನ್ withdrawal reason ಏನು?
Family settlement, partition suit,
ಆಲ್ರೆಡಿ ಸೆಟ್ಲ್ ಆಗಿದೆ.
amicable settlement.
To put an end to litigation.
ಆಯ್ತು ಆಯ್ತು ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ. Withdrawal of appeal stating that family members have come to amicable settlement and hence seeks permission of the court to withdraw and hence permitted to withdraw for the reasons stated in the appeal. Memo. Issue notice to R6 for second time. Ilva? 2018, non-filing of acknowledgement for having served hand summons. ಆಮೇಲೆ ತೋಳಿ ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿರುತ್ತೆ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ತೋಳಿ ದ ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಆಬ್ಸೆಂಟ್ ಅಂಡ್ ಆರ್ಡರ್ ವಾಸ್ ಪಾಸ್ ಟು ಸರ್ವ್ ದಿ ಸಮನ್ಸ್ ಬೈ ಹ್ಯಾಂಡ್ and the said order was passed on 13/8/2018 until date not filed. The acknowledgement for having served the hand summons and apart from that, sorry, notice issued against R6 was returned. ಯಾವಾಗ ನೋಡಿ ವಾಪಸ್ ಬಂದಿರೋದು ಆಯ್ತು ಆಮೇಲೆ ಬಂದೇ ಇಲ್ವಾ ಮ್ಯಾಟ್ರೇ ಬಂದೇ ಇಲ್ವಾ ಆಗಿಂದಲೂ ಬಂದಿಲ್ಲ 2018 ಇಂದ and hence 1 week time granted to pay PF. If PF paid, issue notice against R6. If PF not paid, appeal against R6 is dismissed.
Appearing for the petition.
Hmm.
Needful done.
PFO correct address of R3 to be furnished.
Needful ಮಾಡಿದೆ ಅದು ನೇಮ್ ಅಂಡ್ ಅಡ್ರೆಸ್ ನ ತಗೊಂಡು
Needful
needful done.
ಯಾವಾಗ
Morning.
morning. Council submits that needful is done today and hence issue notice against R1 and R3.
ಇದರಲ್ಲಿ NOC ವಕಾಲತ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಮೇನ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಹಾಕಿದ್ರೆ ಇದ್ರಲ್ಲಿ ತಮ್ಮ ಇಂಪ್ರೆಷನ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿ ಆ ಫೈಲ್ ನೆಸರಿ ಅಫಿಡವಿಟ್ ಮೇಲೆ ಎರಡು ಒಬ್ಬರು ಅಫಿಡವಿಟ್ ಫೈಲ್ ಮಾಡಿ ಇಬ್ಬರದು ಒಂದೇ ಸಿಗ್ನೇಚರ್ ಮತ್ತೆ ತಮ್ಮ ಇಂಪ್ರೆಷನ್
ಹಾಕಿದ್ದೀರಾ affidavit?
ಇಲ್ಲ 1 week ಟೈಮ್
The council seeks 1 week time to file affidavit with regard to the office objections on wakalat. And hence 1 week time granted. List this matter on ಯಾವ ತರ ಒಂದು date ಕೊಡಿ ಮೇಡಮ್
ಮಚ್
28/6. ಇನ್ನೊಂದೇನೋ permission to come
ಅದು
on record.
8 and 9 ಇದೆ.
ಹಾ.
ಐ ಆಮ್ ನಾಟ್ ರೆಪ್ರೆಸೆಂಟಿಂಗ್ 8 and 9.
ಮತ್ತೆ ನೀವು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋದು ಯಾರಿಗೆ?
ಓನ್ಲಿ ಅಪಲೆಂಟ್ ನಂಬರ್ 1 to 7.
1 to
7.
1 to 7.
ಹೌದು.
ಮತ್ತೆ ಇದಾರ ಅಪ್ಲಿಕೇಶನ್ ಅವರೇ ಹಾಕೊಂಡು
8 and 9 ಅವರ ಅಪ್ಲಿಕೇಶನ್
ವಾಲಂಟರಿಲಿ ಹಾಕೊಂಡು
ವಾಲಂಟರಿ
ನಿಮ್ದೇನಾದ್ರು ತಕರಾರು ಇದೆಯಾ? ಅವ್ರ ಹೆಸರು ತೋರ್ಸಾ ಇಲ್ಲ ವಾಲಂಟರಿಲಿ ಹಾಕೊಂಡವ್ರದ್ದು?
ಕಾಪಿ ಅಂತ ಸರ್ವ್ ಆಗಿಲ್ಲ ನನಗೆ ವಿಲ್ ವೆರಿಫೈ. ಕಾಪಿ ಸರ್ವ್ ಆಗಿಲ್ಲ ನನಗೆ ವಿಲ್ ವೆರಿಫೈ.
ಸರ್ವ್ ಆಗಿಲ್ವಾ?
NOC ವಕಾಲತ್
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತವ್ರ ಹೆಸರು ತೋರ್ಸ್ಬೇಕಲ್ಲ ಮೇಡಮ್. ಅವ್ರಿಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗ್ಬೇಕು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತವ್ರದ ಕೌನ್ಸಿಲ್ಗೆ? So the registry is directed to show the name of the council who had filed IA 1/18 seeking permission to come on record in the cause list. First, 28/6. Furnishing of correct address issue notice to R1. Ilva Somashekara KM. Appellant counsel is absent, 1 week time granted to pay the PF. To issue notice against R1 and if paid within 1 week, issue notice against R1. If not paid, appeal against R1 is dismissed. Objections filed by advocate for R2 to A, that is copy not served.
ಅಪ್ಲೆಂಟ್ ಸೆಟ್
ಏನ್ರಿ? Objections ನೀವು ಹಾಕಿರೋದು ಯಾರು?
ಅವ್ರು ಹಾಕಿರೋದು
IA 1/18 ಗೆ
ಅವ್ರು ಹಾಕಿರೋದು ಸ್ವಲ್ಪ ಕಾಪಿ ಸರ್ವ್ ಆಗಿಲ್ಲ
IA ನೀವ್ ಹಾಕಿದ್ದೀರಾ? ಅವ್ರು ಹಾಕಿರೋದಲ್ರಿ, ನೀವ್ ಹಾಕಿರೋದು. ನೀವ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ತಾನೆ?
ಅಪ್ಲೆಂಟ್ ಸೆಟ್
ನೀವ್ ಅಪಲೆಂಟ್ ಗ
ಹೌದು ಸರ್.
ಅಲ್ಲ ಯಾಕೆ ಹೋಗಿದ್ರಿ? ಈ ಕಡೆ ಬನ್ನಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಭಾರತಿ ಆರ್ for R2 na counsel Bharti R is directed to comply with office objections within 1 week. If the same is not complied, objections filed to IA 1/18 will not be taken on record. List this matter for admission. Ideno IA 1 more condonation of delay. Admission on date kodi 4/7. Compliance of office objection raised on IA 1/23. for TI. Copies serve ಮಾಡಿಲ್ಲ. 1 week time granted to comply with office objections if office objection not complied on IA 1/23, IA 1/23 will be dismissed. This matter on 28/6.
Respondent.
Needful done, my lord.
Sufficiency of service of notice in respect refused R10. Notice issued against R10 was returned with an endorsement refused and hence held sufficient against R10. Needful done na?
Done, my lord.
Council submits that needful is done and hence issue notice against R1 and R12. ಮತ್ತೆ office objections raised on wakalat filed by the Anandeshwara.
Your Lordship, my kind permitted. me to
Signature ಹಾಕಿಲ್ವಾ?
signature. Executant ಹಾಕಿದೀನಿ, acceptance ಹಾಕಿಲ್ಲ. So I will now, now
The
itself. I
council
will
is
come.
permitted to make signature on the wakalat.
Please.
Perusal of postal sara in respect of R9 as unclaimed.
We will take fresh steps, my lord.
Hmm?
We will take fresh steps.
My
No,
lord,
no,
are
ಏನಿದೆ? There is no any shara that intimation is delivered and hence not sufficient,
Well-
directed to take steps within 4 days.
Please.
And if we have paid, issue notice against R9.
And paper book,
Non-filing of paper book.
2 weeks time, madam.
my lord, a date will be given,
Non-filing of paper book order ಆಗಿರೋದು ಯಾವಾಗ?
19.
19,
19.
8 weeks ಆಮೇಲೆ? ಅದ್ರ ಬಗ್ಗೆ ಏನಿಲ್ವಾ?
ಇಲ್ಲ
Paper book ಬಗ್ಗೆ ಇಲ್ಲ. Our appeal was admitted in 2019 and 8 weeks time was granted and not filed at the paper book. In spite of matter was listed twice. ಎರಡ್ ಸರಿ ಅಲ್ಲ?
Yes, my lord.
Matter was listed before the court and hence on cost of rupees 2,000 another 4 weeks time granted to file the paper book. And cost is payable at registry. Issue notice to R1 and R2.
Appellant, please.
For R4 and R5, madam.
PF today. I paid the PF today, madam.
Council submits that he has paid the PF today in the office and hence issue notice against R1 and R2. Memo retirement filed by the Naveed Ahmad advocate for appellant. Appellant ಗೆ ನೀವಿದ್ದೀರಿ ಈಗ?
ನಾನು
ಮತ್ತಿಲ್ಲ ನವೀದ್ ಅಹಮದ್ ಅಂತಿದೆ ಮತ್ತೆ? ರಿಟೈರ್ಮೆಂಟ್.
ಅವ್ರು ರಿಟೈರ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ.
ಅವ್ರ ಆದ್ಮೇಲೆ ಇವ್ರು ಹಾಕಿರೋದ ವಿತ್ NOC ಹಾಕಿದಿರ ನೀವು?
ಪ್ಲೀಸ್ ಇಲ್ಲ.
ಹಾ?
ಹೌದು ಸ್ವಾಮಿ. ಇಲ್ಲ, ನಾನು ಅಪ್ಪಲೆಂಟಿಗೆ ಇರೋದು ಸ್ವಾಮಿ.
ರಿಟೈರ್ಮೆಂಟ್ ಹಾಕಿದಾರ್ರಿ ನವೀದ್ ಅಹಮದ್ ಅವ್ರೇನ ನಿಮ್ಗೆ NOC ಕೊಟ್ಟಿದಾರ ಅಂತ ಕೇಳಿದೆ.
ಅಲ್ಲ, ನವೀದ್ ಅಹಮದ್ ಫೈಲ್ಡ್ ಫಾರ್, ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದಿ NOC.
ಎಷ್ಟು ಹೇಳಕ್ಕೆ ಎಷ್ಟು ಸರಿ ಕೇಳ್ಬೇಕು.
ಐ ಆಮ್ ಸಾರಿ.
Council Naveed Ahmad permitted to retire since Council PM Sidnalpa has filed wakalat. Next, compliance of office objections on IA 1/24 for impleading proposed.
ಅದು ಫುಲ್
Applicant-
ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಐ ಆಮ್ ನಾಟ್ ಫೈಲ್ಡ್, ಪ್ಲೀಸ್ ಲಾಸ್ಟ್. ಐ ವಿಲ್ ಫೈಲ್ ಅನ್ necessary.
Impleading
cost.
ನೀವು ಹಾಕಿರೋದು?
ಹೌದು ಸ್ವಾಮಿ, ನಾನು ಫೈಲ್ ಮಾಡಿರೋದು.
One
ಐ
week
ನಾಟ್
time-
ಫೈಲ್ಡ್ ದಿ
one-
ಫುಲ್ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್.
1 week time granted to comply with office objections on IA 1/24.
For R4 and R5.
R4 ನೀವಾ?
R4 and R5.
Council is present. R4 and 5
Yes, please, madam.
is present.
ಗ್ರೇಟ್ಫುಲ್.
LCR call, madam.
ಏನಿದೆ?
My lord,
So ಇನ್ನು ಏನೋ ಬೇರೆ ಬೇರೆ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಇದೆಯಲ್ಲ?
ಎಲ್ಲಾಸ್ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಸ್ವಾಮಿ.
ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ, ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ.
ಎಲ್ಲಾಸ್ ಅಪ್ಲಿಕೇಶನ್ IA 2/22, IA 3/22.
ಇದ್ರ ಮೇಲೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ?
ಇಲ್ಲ,
ದಿಸ್ ಇಸ್ D1 ನಂಜಪ್ಪ ಅಂತಿದೆ. D1 ಹೆಂಗ್ರಿ ಬರ್ತದ?
ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ, ಇದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲೇ ತೀರ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು.
ಹಾ.
It was filed, he has died before the trial court itself. They have not brought the legal aid. ಇಲ್ಲ
ಯಾಕೆ ಈಗ ಹಾಕಿದೀರಾ?
ಇಲ್ಲ ಹಾಕಿದ್ದಾರೆ.
ಇಲ್ಲ ಹಾಕಿದ್ರೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ?
sir, R4 and R5 can be dispensed, my lords. I am appearing for R4 and R5. Nanjundappa.
ಮೆಮೊ ಹಾಕಿರೋದು. The memo filed for dispensation of notice to R4, R5 doesn't arise since council has represented
Please, my lords.
for R4 and R5 and hence memo is rejected. ಏನ್ ಮೇಡಮ್ ಅದು? ಯಾರು ಹಾಕಿರೋದು ಇದು? ಆಯ್ತು ಆಯ್ತು. ಪರ್ಮಿಷನ್ ಇರ್ಬೇಕದು. ಪರ್ಮಿಷನ್ ಹಾಕೋಬೇಕಿತ್ತು ಅವರು. ನೀವೇ ಹಾಕಿರೋದು ಅದು ಅಪ್ಲಿಕೇಶನ್?
ಪ್ಲೀಸ್, ನಾವೇ
ಹಾ?
ನಾವು ಫೈಲ್ ಮಾಡಿರೋ ಎಲ್ಲಾಸ್ ಅಪ್ಲಿಕೇಶನ್ ನಾವೇ.
ನೀವೇನ?
ಹೌದು. ಆಕ್ಚುಲಿ
ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಅಪಲೆಂಟ್ ಅಂತಿದ್ಯಾ?
the matter has to be remand back to the trial court. The judgment filed against the death person, please.
ಅದಾದ್ಮೇಲೆ ನೋಡೋಣ ತಗೊಳ್ಳಿ. Heard on IA 1/22 and there is a delay in filing the application to bring the LRs of deceased R1 on record. And also setting aside the abatement, IA number 2 of 22 is filed and IA number 3 of 22 is filed for bringing LRs of deceased defendant number 1 and for the reasons stated in the accompanying application and affidavit, and also the LRs were not brought on before the first appellate court, even though the first defendant passed away during the pendency of the appeal, and hence the appeals applications are allowed. Permitted already ಮಾಡಿದಿರಲ್ಲ ಪಾರ್ಟಿನ,
ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
and hence permission is granted to bring them on record by setting aside the abatement and condoning delay.
My lords, LCR call.
LCR
Call ಆಗಿಲ್ಲ.
LCR ಬೇಕಿದ್ರೆ ಮಾಡೋಣ, ಇನ್ನು ಅಡ್ಮಿಷನ್ ಬಂದಿಲ್ಲ ನೋಡ್.
Please, my lords.
ಮಂಜುನಾಥ್ ಜಿ ಕಡ್ಡೇಕರ್, ವಕಾಲತ್ ಫೈಲ್
Respondent number 4.
ಯಾರ ರಾಹುಲ್ ರೆಡ್ಡಿ ಅಂತ ಯಾರೋ ವಕಾಲತ್ ಹಾಕಿದಾರಲ್ರಿ.
Respondents, my lords, week time will be granted for compliance of office objection.
Council is given 1 week time to comply with office objections with regard to ವಕಾಲತ್.
As well as caveat petition also an objection.
ಕೇವೇಟ್ ಯಾರು ಹಾಕಿರೋದು?
My lords, NS Ashok Kumar has filed caveat, my lords, wherein I had to take NOC Wakalat and filed a fresh Wakalat for the respondent number 1, 3 and 4, my
1, 3
lords.
and 4.
Please.
What about 2?
2 I have not filed.
2
my
already
lords.
served.
Sir, it
2
is.
already served, that's all.
Please,
Only they have to comply, that's
Yeah.
all.
please,
If office objections complied, post the matter for admission
please,
Much obliged.
on 4/7.
please.
Compliance of office objection raised on IA 1 of 19 for recalling the order dated 29/5/2019 and IA 2 for paper
Yes, I am appearing
publication.
for the appellant, my lord. Appeal may be
Not
dismissed. I file
served
my
on other side.
memo for dismissal, my lord.
Now you are not pressing the appeal.
Yes, yes.
Third. Counsel for the appellant has filed memo praying this court to dismiss the
Appeal
appeal.
has not pressed.
Already dismiss ಆಗಿದೆಯಲ್ರಿ, ಮತ್ತೆ
ಅಲ್ಲ.
dismissal ಕೇಳ್ತಾ ಅಯ್ಯ ಮಾತ್ರ dismissal
Appeal is dismissed.
settled the dispute out of the court, hence appeal may be dismissed. Appeal already not dismissed ಅಂತ ಆಗಿದೆ already.
ಅಲ್ಲ, against 2 and 3 ಮಾತ್ರ ಸ್ವಾಮಿ.
Huh?
Against 2 and 3 ಮಾತ್ರ dismiss
Aga-
ಆಗಿತ್ತು.
ಹೌದಾ?
ಹೌದೌದು.
Against Milad, yes, PF was not paid, against 2 and 3 was dismissed.
ಹೌದೌದು ಸ್ವಾಮಿ. Against 2 and 3 was dismissed. 1 to
ಒಟ್ಟು
One to-
5 ಅಂತಿದೆ.
ಇಲ್ಲ.
ಬೇರೆಯವ್ರು ಇನ್ನಾರು ಇದಾರಾ?
1 to 3 ಸ್ವಾಮಿ. Already 5 are represented already
Four to-
5.
4 to 7, offer for 4 to 7.
Finally, 4 weeks time granted to do the needful, failing which appeal against respondent number 1 to 5 shall stand dismissed ಅಂತ ಆರ್ಡರ್ ಇದೆ already.
ಆಯ್ತು ಸ್ವಾಮಿ.
That is
ಅದಾದ್ಮೇಲೆ
the order you called filed an application for recalling.
ರೀಕಾಲಿಂಗು ಫೈಲ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ.
ಆಯ್ತು.
ಅದಾದ್ಮೇಲೆ ಅವ್ರು ವಕಾಲತ್ ಆಲ್ಸೋ
ಮೂರ್ ಜನ ಇದಾರಾ? ಬೇರೆಯವ್ರಿಗೇನು?
Offer for respondent number 4 to 7, Milad.
ಇವ್ರು ಅಪೇರ್ ಆಗ್ತಾರಲ್ಲ.
ಹೌದು ಸ್ವಾಮಿ.
ಆಯ್ತು.
4 to 7 and also representing R2 ಗೂ represent ಮಾಡ್ತಾ ಇದ್ರು ಸ್ವಾಮಿ.
The counsel for the appellant has filed memo to dismiss the appeal as not pressed in view of settlement ordered between the parties and hence dismissed as not pressed
Yes, sir.
Grateful.
in terms of the memo. Compliance of office objection raised on IA 1 of 23. Condonation of delay and recalling the order dated. Compliance ಇದೆಯಲ್ರಿ? First of all dismiss ಆಗಿದೆ. ಅದ್ರ recall ಮಾಡಕ್ application ಹಾಕೋತೀರಿ, ಅದ್ರ ಮೇಲೂ compliance. ಕಾಪಿ ಶುರು ಮಾಡಿಲ್ಲ. Death certificate ತೊಗೊಳ್ಳಿ. 1 week time granted to comply with office objections on IA 1 of 23 and IA 2 of 23. And list this matter on 28/6. Lord Mariappa.
Vector paper appellant, my lord.
Has not claimed.
Not claim ಅಂತ ಆಗಿದೆ ಸ್ವಾಮಿ, sufficient ಅಂತ ಹೇಳಿ.
ನೋಡೋಣ, intimation ಏನೋ ಡೆಲಿವರಿ ಆಗಿದ್ರೆ sufficient ಅಂತ ಮಾಡೋಣ. Council ಆಗಿದೆಯಾ? The notice issued against R5 was returned with an endorsement not claimed and on perusal of the postal shara intimation is also delivered and hence held sufficient against R5. Post the matter for admission on 28/6.
ಸ್ವಾಮಿ, first week ಅಲ್ಲಿ ಸ್ವಾಮಿ, 5ನೇ ತಾರೀಕು.
Respondent.
ಅಲ್ಲ 4/6 ಆಯ್ತು, 4/6. Sorry, 4/7.
ಸ್ವಾಮಿ 4 ಇನ್ನೊಂದ್ ಮ್ಯಾಟ್ ತಾವೇ ಹಾಕಿದ್ರೆ 5ಕ್ಕೆ ಹಾಕ್ಲಿ ಸ್ವಾಮಿ.
ಆಯ್ತು, ಇನ್ನೊಂದಾದ್ರೆ ಇದು ಒಂದ್ ಜೊತೆಗಿರುತ್ತೆ ಅಷ್ಟೇನೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಕೋರ್ಟ್ ಕ್ಯಾನ್ ರೀಡ್ 40 ಅಡ್ಮಿಷನ್ಸ್, ನಿಮ್ಗೆ 1-2 ಓದಕ್ಕಾಗಲ್ವಾ?
5ನೇ ತಾರೀಕು ಸ್ವಾಮಿ.
28ಕ್ಕೆ ಹಾಕಿದ್ರು ನಿಮ್ಗೆ ಆಗಲ್ಲ, 4ಕ್ಕೆ ಹಾಕಿದ್ರು ಆಗಲ್ಲ.
ಆಯ್ತು ಸ್ವಾಮಿ, ಆಯ್ತು.
ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ perusal of postal shara of R4 shown as not claimed. ನೋಡಿ ಮೇಡಮ್, Intimation, same order, madam. Intimation delivered held sufficient.
It
Post
may
the
be
matter
called,
for-
my lord, along with
Post the matter for admission.
1570/2018.
ಇನ್ನೊಂದು ಇದೆಯಾ?
ಹೌದು,
1518.
70/2018.
The appellant counsel submits that another RSA 1570 of 18 is also pending and hence list this matter along with the other appeal for admission on 4/7.
Obliged.
Hmm.
In this case, for appellant,
Hmm.
I filed the last application.
Non-filing of application by the counsel for.
I filed
appellant for
please,
bringing the
R1, appellant number 1 and appellant number 4.
ಹಾಕಿದೀರಾ?
ಹಾಕಿದೆ.
ಯಾವಾಗ ಹಾಕಿದಿರಿ?
Ivat today morning.
Counsel submits that he has filed an application and hence put up the same and list this matter on 28/6. Compliance of officer 2 of 19 for recalling the order dated.
Yes.
Recall.
Against the appellant number 8 is dismissed.
One week time granted to comply with office objections on A 2 of 19.
Please.
Murli on non-taking of steps by counsel for appellant in respect of deceased R1. ಯಾವಾಗಿಂದ ತಗೊಂಡಿಲ್ಲ ನೋಡಿ. ಹಾ, ರಿಪೋರ್ಟ್ ಆಗಿದೆ. The death of R1 was reported on 27/23 and the council sought accommodation to verify and take necessary steps in the matter. ಆಮೇಲೆ ಇಷ್ಟ ಆಗಿಲ್ವಾ? And till date not taken any steps. However, in the ends of justice, another 2 weeks time is granted to take necessary steps. And if steps not taken another within 2 weeks. ಬೇರೆಲ್ಲ ಅಪಿಯರ್ ಆಗಿದಾರ? ಅಪೀಲ್ against R1 is abated. Acceptance of cost of rupees 500 paid but tax of stipulated time of 2 weeks as per the order. Accepted. Discrepancy in the alias name of appellant differs with OS and RA judgment and
His
Wakala.
name is Mrutyunjayappa.
Huh?
His appellant first name is Mrutyunjayappa. But in the suit, his name is given Jayanna alias Shamyana Jayanna.
Jayanna alias?
Shamyana Jayanna.
Huh.
But his true name is Mrutyunjayappa. He used to sign.
ಆಯ್ತು, ಅದನ್ನ ಈಗ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಹೇಳಿದಿರಾ?
ಅದನ್ನ ಇಲ್ಲಿ ಹೇಳಿದ್ರು.
Submission ಅಲ್ಲಿ ಹೇಳಿದಿರಿ.
ಹೌದು.
The counsel appearing for the appellant would submit that the name of the appellant.
First appellant.
First appellant is Mrutyunjaya.
Mrutyunjaya.
But wrongly mentioned his name as Jayanna.
Alias Shamyana Jayanna.
Shamyana
Jayanna.
Jayanna. ಆಯ್ತು.
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ
ಅಡಿಷನ್ ಆಗಿದೆ ಅಷ್ಟೇನೆ. And hence the council submission is accepted. ಅದು ಇದೆ, ಇದು ಇದೆ ಹೆಸರು.
ಹೌದು.
ಎರಡು ಎಲ್ಲ
ಎರಡು ಇದೆ.
ಮೂರು ನಿಮ್ದೇ ಹೆಸರು.
ಎಲ್ಲ ನಮ್ದೇನೆ.
ಆಯ್ತು. Hence council submission is accepted. ಬೇರೆ ಏನೇನಿದೆಯಾ ಮೇಡಮ್?
ಬೇರೆ ಏನೇನು?
Office has raised objection, CP ಅನ್ನ postal acknowledgement.
ಅದನ್ನ
ಅದು ಅವ್ರದ್ದು ನಿಮ್ದಲ್ಲ. ಆಯ್ತು, post the matter for admission on 4/7. Memo dated 14/2 acceptance of paper book with regard to office objection raised on paper.
Officer raised an objection.
Appellant along with office objection raised on paper book. ಏನ್
The depositions are filed, the xerox copies are filed. They directed me to file a typed copies of the deposition.
ಮಾಡಿದಿರೋದು?
ಇಲ್ಲ ಮಾಡ್ತೀನಿ.
ಹಾ.
ಮಾಡಿಬಿಟ್ಟು ಆಮೇಲೆ then I will complete.
ಇದ್ ಮತ್ ಮೆಮೋ ಏನಿದು?
ಮೆಮೋ ಅದನ್ನೇ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿ ಬಿಕಾಸ್ ಇಟ್ಸ್ ರೀಡೇಬಲ್ ಅಂತ ಹಾಕಿದ್ದೆ ನಾನು. That the markings ಎಲ್ಲ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
ರೀಡಬಲ್ ಇದ್ರೆ
ರೀಡೇಬಲ್ ಇದೆ. That certain xerox copies of the certificate copies ಹಾಕಿದೀವಿ.
ಓದ್ಬೋದು. ಲೆಜಿಬಲ್ ಆಗಿದೆಯಾ?
Legible ಇದೆ. That's the memo I have filed.
The council has filed memo that stating that the depositions are readable. And office has raised the objections to file the typed copy. And on perusal of the xerox copies of depositions and the same are readable. And the same is also even typed copy before the concerned judge. And when such being the material available on record, office objection is overruled. ಅದೊಂದೇನಾ?
ಅದೊಂದೇ.
ಬೇರೆ ಏನಿಲ್ವಾ?
Other that I will serve the copy on the other side, I will serve it.
Other side, respondent,
I'll serve the copy.
Copy serve ಮಾಡಿಲ್ವಾ?
Court, ಯಾಕಂದ್ರೆ
And council is directed to serve the copy of the paper
Paper
book
book,
within 1 week.
please.
List this matter for final hearing on 4/7.
My lord, I am filing a memo reporting the death of the appellant, ma'am.
Appellant ತೀರ್ಕೊಂಡಿದ್ದಾರಾ?
Sole appellant.
21 ತಾನೆ ನಿಮ್ದು? ಅದ್ರಲ್ಲಿ ಏನೋ ನೋಟಿಸ್ ಟು R1 ಏನೋ ಇದೆ?
But ಅವರು ತೀರೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Death of appellant. ಏನ್ steps ತಗೊಳ್ತೀರಾ ಏನು?
Yes, I will take steps, madam.
The appellant counsel reported the death of appellant and seeks time to bring the LRs and hence 2 weeks time granted. List this matter on 4/7.
No, kindly give me a slightly more than.
Emergent notice R1 ಗೂ PF ಕೊಡ್ಬೇಕಲ್ಲ?
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು ಸರ್, ಅವರು ಅಪ್ಲೆಂಟ್ ಎಲ್ಲರೂ
ಅಂದ್ಮೇಲೆ ಕೊಡ್ತೀರಾ? ಆಯ್ತು. And counsel also seeks time to pay the PF to issue notice against R1. List this 4/7.
No, ಸ್ವಲ್ಪ ಒಂದು
2 weeks ಕೊಟ್ಟಿದ್ದೀನಿ. 2018 matter ಇನ್ನೇನು? Perusala postal hara in respect of R1 shown as addressee death. HM Basuraj. ಹೇಳಿ.
I will take necessary steps, my lord.
Council seeks 2 weeks time to take the steps against R1.
Please.
Appeal copy not served.
This matter on 4/7.
Appeal copy not served.
ಸರ್ವ್ ಆಗಿಲ್ಲ?
Notice ಜೊತೆ
ನೀವ್ ಯಾರಿಗೆ?
Respond number 2.
ಏನ್ ಸರ್ವ್ ಮಾಡಿಲ್ಲ?
Appeal copy serve ಆಗಿದೆ.
ಅಪೀಲ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಲ್ಲಿ ನೀವ್ ಹೆಂಗ್ ಅಪಿಯರ್ ಆದ್ರಿ?
ಬರೀ ನೋಟಿಸ್ ಮಾತ್ರ ಬನ್ನಿ ಸರ್.
ಬರೀ ನೋಟಿಸ್ ಹೆಂಗ್ರಿ ಮಾಡ್ತಾರೆ ಆಫೀಸ್ನವರು? ಕಾಪೀಸ್ ಕೊಡ್ದಲೇನೆ? ಕಾಪೀಸ್ ಕೊಡ್ದವ್ರು ತಕರಾರು ಹಾಕಿಟ್ಟಿರ್ತಾರೆ.
I will furnish one more.
ಕಾಪಿ ಕೊಡಿ ಹೋಗ್ಲಿ.
Please.
ಆಯ್ತು. Counsel for R2 submit that note appeal copy is not furnished and hence appellant counsel is directed to furnish one more copy.
Please.
23. Compliance of office objection raised on IA1, IA2
For responding.
for bringing LRs of deceased sole appellant.
Please.
ಸರ್ವ್ ಮಾಡಿದಿರಾ ಈಗ?
ಅಲ್ಲ ರ್ಯಾಂಕ್ ಅಪ್ ದ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. 2 weeks time granted madam.
Copy not served on the other side.
Copy ಕೊಟ್ಟಿದ್ದೀನಿ.
Wakalat for proposed LR Lakshmi Priya is not forthcoming. Ranking of the proposed LRs is clearly not mentioned. Several office objections.
2 weeks
The
time
council is given 1 week time to comply with the office objections.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ.
List this matter. Copy serve ಮಾಡಿದಿರಾ? And council also submits that copy is served on the other side. ನೋಡ್ಕೊಂಡು ಹೇಳಿ next time ಏನಾದ್ರು ತಕರಾರು ಇದ್ರೆ ನಿಮ್ದು. 28/6. Memo of complaints report
Bill for
submitted
the
by the
appellant in this
appellant as
matter.
per order dated 10. ಏನದು complaints?
My lords, while admitting the matter, this honorable court has directed the appellants to deposit 50% of arrears, my lords, before the executing court, and on that condition, interim order was granted.
ಆಯ್ತು.
Subsequently, I have filed the memo for the complaints of the same order, my lords.
The memo is taken on record and the same with regard to the complaints of earlier order dated 14/7/21. Non-filing of paper book.
My lords, as the file frame, admitting the matter, this honorable court has framed the question of law only with respect to the legal aspect in that, my lords. I may request to dispense.
Substantive question of law ಅಂದ್ರೆ ಅದೇನೆ.
It doesn't involve any evidence of the parties in the question of law frame.
ಆಗ್ಲೇ ಹೇಳ್ಬೇಕಿತ್ತು ನೀವು. ಪೇಪರ್ ಬುಕ್ ನಾಟ್ ನೆಸರಿ ಅಂತ ಡೈರೆಕ್ಷನ್ಸ್ ಇದೆಯಲ್ಲ ಪೇಪರ್ ಬುಕ್ ಈಗ ನೋಡಿ ಮೇಡಮ್. ಇಲ್ಲ ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ ಮಾಡ್ಬೇಕು ಅಂತಿಲ್ವಾ? ಬೇಕೇನ್ರಿ?
ಬೇಡ ಬೇಡ.
ಬೇಕಾಗಿಲ್ಲ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ಬೋದಾ?
Please, my
Filing of paper book is dispensed. List this matter for hearing on 4/7.
Please, my lords, may I request on 5th, my lords, 4th one, Moornak matter further.
Aye, fifth.
Please, my lords.
Memo dated 10/7/23 filed by counsel for respondent reporting death of R1.
They have to take steps, my lord.
ಬಾಲಸುಬ್ರಹ್ಮಣ್ಯ ಯಾರು ಇಲ್ವಾ?
Last 2 dates ಅಲ್ಲೂ ಮೂವ್ ಮಾಡ್ತಾರೆ ಬಂದಿದೆ.
ತೀರ್ಕೊಂಡಿದ್ದು R1.
R1
ಆಫೀಸರ್ ಮಾಡಿದೀರಾ 10/7/23 ನಲ್ಲಿ ನೀವು ಅದರ್
ಅಲ್ಲ, I filed it the office ಮಾಡಿ ರಿಪೋರ್ಟ್ ಮಾಡಿ ಆಫೀಸಲ್ಲಿ ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದೀನಿ. ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ 2 ಸಾರಿ ಡೇಟ್ ಬಂದಿತ್ತು ಅದು. He knows very well, my lord. Objections also filed to the IA firm, IA 1 of 18, my lord.
None appears for the appellant despite moving the matter for urgent hearing.
He died on 5/9/21, my lord.
ಎಮ್ಮ ನೋಡಿ ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಕಾಪಿ ಶುರು ಮಾಡೋರು ನೋಡಿ ಅವತ್ತು ಅವ್ರ ಬಂದಿದಾರ ರಿಪೋರ್ಟ್ ಮಾಡಿದಾಗ ಡೆತ್.
Subsequently, my lord, I have given the copy next date of hearing ಅಲ್ಲಿ with
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಿ?
all the particulars also, my lord. I have given. ಯಾರ್ಯಾರು ಎಲ್ಲಾರ್ಸು ಅವ್ರದ್ದು ಇದೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅಡ್ರೆಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ. ಆಮೇಲೆ 2 ಡೇಟ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿತ್ತು.
Counsel further submit that respond number 1 is dead. ನೀವು ಕಾಪಿ ಶುರು ಮಾಡಿಲ್ಲ ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ನೋಡಿ ಅದ್ರ ಮೇಲೆ. ತಗೊಳ್ಳಿ counsel for respondent reported the death of R1.
Yes, ma'am.
Before the court on 6/7/23. And
16th, ma'am.
appellant counsel was absent on 6/7/23. And also absent on 26 to 24. Note steps is taken to bring the LRs of R1 and hence appeal against R1 is abated. ಬೇರೆ ಯಾರ ಇದಾರ?
ಇಲ್ಲ ಇಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಲ್ರೆಡಿ ಫೈಲ್
R2 and R3 ನೀವ್ ಹಾಕಿರೋದಾ? R1 ಗೆ ಅಬೇಟ್ ಆಯ್ತು ಅಷ್ಟೇ. ಏನ್
IA 1/18 is pending from beginning, my lord. I already filed objections.
1/18
ಒಂದು injunction ಕೇಳ್ತಾರದು.
Injunction. List this matter for admission on 4/7. If counsel doesn't appear for the appellant. On that day, appeal will be dismissed for
90% 5/7, my lord.
Non-prosecution. Huh?
5/7, my lord, please.
5/7. ಅವ್ರು ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರ್ರಿ ಬರೀಯಾ? ಎರಡಿಲ್ಲ ಅಂತಲ್ಲ, ಒಂದೇ ಇರೋದಂತ. ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಮಾತ್ರ ಇದೆ ಅಂತ. ಅದಾಯ್ತು ಬಿಡಿ, ನೋಡೋಣ ಅವ್ರು ಬರ್ಲಿ, ಅಡ್ಮಿಷನ್ ಬಂದಾಗ ನೋಡೋಣ. Filing of paper book wide order dated 8/4/2000. 8 weeks time was granted for filing of paper book.
My lord, I appear for the appellant and request for 2 weeks time, my lord.
Madam, matter was admitted in 2019.
I know, my lord, we just missed it out, my lord.
ಆಮೇಲೆ ಎಷ್ಟು ಸರಿ ಬಂದಿದೆ ನೋಡಿ ಮೇಡಮ್.
My lord, just 2 weeks time, my lord.
Aditya Venugopal, learned counsel in respect of R4 as per order dated. ಇವ್ರೇನು ಆದಿತ್ಯ ವೇಣುಗೋಪಾಲ್ ಏನು ಅಂಡರ್ಟೇಕ್ ಮಾಡಿದಾರ ಏನ್ ನೋಡಿ ಮೇಡಮ್. CGC for R3. 2 ಗೆ dispensed with 1 ಗೆ ಏನಾಗಿದೆ ನೋಡಿ. ಇವ್ರು ಆದಿತ್ಯ ವೇಣುಗೋಪಾಲ್ ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡಿದಾರ ಅವ್ರೇನೆ. ತಗೊಳ್ಳಿ. The counsel ಆದಿತ್ಯ ವೇಣುಗೋಪಾಲನ್ undertaken to file wakalat for R4. ಯಾವಾಗದು? On 8/4/2019 for a period of 5 years.
My lord, because then matter never came up and like we just missed it out, my lord. My apology for that. Within 2 weeks, my lord, we will finally, my lord. Within
Madam,
2 weeks, even 1 week.
You are appearing for R4?
No, my lord, I appear for appellant, my lord.
Appellant?
Yes, my lord. So we'll file the paper book.
Why you are interfering while dictating orders, madam?
Sorry.
I am not passing any orders against you.
My apology, my lord.
On 8/4/2019 and for a period of 5 years, wakalat not filed and hence held sufficient against R4. R1 ಗೆ ಏನಾಗಿದೆ ಮೇಡಮ್? BM ಸಿದ್ದಪ್ಪ ಇದ್ದಾರೆ. ಏನಾಗ್ಬೇಕು ಮತ್ತೆ ಇದು ನೆಕ್ಸ್ಟ್? ಆಮೇಲೆ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರಲ್ಲ. 4 weeks time granted to file paper book finally.
Highly obliged.
If paper book not filed within 4 weeks, appeal is dismissed without reference to the bench.
Obliged.
Next, 27. Copy ಏನ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಸರ್ವಾಗಿಲ್ಲ ಅಂತೇನ ಇದೆಯಲ್ರಿ?
On my lord, the 18/10/19, my lord, this honorable court passed an order to serve the copy. 21/10/19 we have served the copy.
ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇದೆಯಾ?
Acknowledgement file ಮಾಡಿದೀನಿ.
ಯಾವಾಗ ಮಾಡಿದಿರಿ? ಕೊಡಿ.
My lord, the
ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಅಂತ ಇದೆ.
I'm sorry, my lord, it has been served on 21/10/19, but it has been filed today.
The council submits that the copies are served on 21/10/2019 to government advocate.
ಹೌದು.
ಇದಾರಲ್ಲ AG ಇಲ್ವಾ ಇಲ್ಲಿ?
ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಆಫೀಸ್ ಅಲ್ಲೇ ಕೊಟ್ಟು ಸೀಲ್ ಹಾಕ್ಸ್ಕೊಂಡು ಅಂಡ್ ಒರಿಜಿನಲ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
And showed the copy of service of notice against the AGA and hence AGA is directed to take notice for R1 and R2. SV Prakash idaralla. So list this matter for admission on 4/7. Dilraj Rohit Sikwera, non-compliance of office objections for 5th time. Non-payment of cost of rupees 500. ಏನಾಯ್ತು?
2 weeks time ಕೊಡಿ ಸರ್. 2 weeks time ಕೊಡಿ ಸರ್.
ಏನ?
2 weeks time ಕೊಡಿ ಸರ್.
ಎಷ್ಟು ಸರಿ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕು ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಗೆ? ಈ ಡಿಸ್ಮಿಸಲ್ ಆಲ್ರೆಡಿ ಇದೆಯಾ ಆರ್ಡರ್? ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಅಂತ ಮಾಡಿದೆ. ಅದ್ರ ಮೇಲೂ ಮಾಡ್ಲಿಲ್ವಾ? This appeal was dismissed on this court wide order dated 9/10/23. pending consideration of IA number 1 of 23 and 2 of 23, 2 weeks time is granted to comply with office objections. And also made it clear that if the office objections are not complied within 2 weeks, list the matter for dismissal once again on 30/10/23. And this matter, ಆಮೇಲೆ ಇಷ್ಟ ಆಗ್ಲಿಲ್ವಾ 30/10 ಗೆ again listed on 24/11/23 and finally 4 weeks time granted for compliance of office objections. And once again listed on 7/3/24 and 2 weeks time granted comply with office objections subject to payment of cost of rupees 500 payable to the Advocates Association Bangalore Library Fund. In spite of it, not complied the office objections and and cost also not paid and not complied, and hence IAS are also dismissed. IAS are also dismissed. Non-filing of further details of LRs of deceased.
I appear for appellant, my lord, in this case.
Huh?
There are two more brothers, apart from this proposed LR of the appellant. Two more, they are all residing at Bangalore, that's all, my lord. Or they are not interested in the subject matter of the
Who
case.
filed an application for
The son of this appellant,
appellant?
appellant only.
And there was an order on 22/4/24 to give full details.
Yes, sir, please, my lord. In the morning, he has told me, giving the details of his two brothers.
Council seeks another 1 week time to furnish the further details of LRs of deceased appellant as per the order dated 22/4/24 and hence 1 week time granted. List this matter on 28/6.
Much obliged.
If not complied, it will be dismissed in the next state of hearing.
Much obliged.
Perusal of unserved cover in respect of R2 and R3 returned with postal Sara expired.
2 weeks time.
Appellant counsel given 2 weeks time to bring the LRs of R2 and R4. This matter on 4/7. Memo for reporting death of sole respondent. Compliance of office.
Not respondent, my lord, appellant is only dead. Respondent. I made an application.
Memo ಹಾಕಿರೋದು ಯಾರು?
Memo, I filed a memo with the application also, bring the LRs.
ಮೆಮೋನಲ್ಲಿ ಯಾರು ಸತ್ತೋಗಿದ್ದಾನೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Appellants ಅಂತಾನೆ ಇದೆ.
ಮತ್ತೆ ಯಾಕೆ ಇವ್ರು ಸೋಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ತೋರಿಸಿದ್ರು?
My lord, some.
The appellant Lingegowda died on 22/6/21, leaving behind his wife and children.
ಏನು IA 1 of 22 ಏನೋ?
Sir, that is a bring the LRs on.
LRs of?
Appellants.
LRs of appellant only?
House. And paper book is also filed. 13/1/22.
1 week time granted to comply with office objections on IA 1 of 22.
Paper book is filed and also served.
Copy ಕೊಡ್ತಿದ್ದೀರಾ? The appellant counsel submits ಕೋಟಿ ಕೊಟ್ಟಿದ್ದೀರಾ paper book ನ?
Court got it.
The counsel submits that paper book is already filed and 1 copy is served on the other side before the court. Clear, madam? Who moved this courtal memo?
I think other side maybe.
Courtal memo.
I'm a
Who
proxy
put-
counsel for respondent in this
Proxy
case, my
counsel.
lord.
ತಪ್ಪಾಕಿರೋದು ಯಾರು ಇದ್ರವ್ರ ಆಫೀಸ್ ಅವರು ತೊಳಿ ಆಯ್ತು ಕಂಪ್ಲೈನ್ಸ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 28/6 ಕಂಪ್ಲೈ ಮಾಡಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ರಾಜಾ ಇಲ್ವಾ ಅಪ್ಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಆಬ್ಸೆಂಟ್ 1 week time granted to pay the PF and if PF paid within 1 week issue notice against the respondents. ಮತ್ತಿಲ್ಲಾರ ಏನೋ ತೀರ್ಕೊಂಡಂಗಿದಾರೆ ಮೇಡಮ್. ಬ್ರಿಂಗಿಂಗ್ LRs of deceased ಶಿವಣ್ಣ. ಯಾರಿದು deceased ಶಿವಣ್ಣ ಅಂದ್ರೆ? deceased ಶಿವಣ್ಣ ಅಂತಾರೆ ಎಲ್ಲ ಕಡೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಅದು. And if paid PF within 1 week issue notice against the respondents ಅಷ್ಟೇ. If not paid the PF, list this matter for dismissal on 28/6. ಯಾರಾಗ್ಲಿ ಬಿಡಿ PF ಕೊಡ್ಲಿ ಅವ್ರು. 33. Memo reporting, retirement at flag A filed by the council for appellant. Service ಆಗಿದೆಯಾ?
My lord,
Memo retirement memo ನಲ್ಲಿ
he
service
himself,
ಆಗಿದೆಯಾ?
he himself, my lord, taken the file.
ತಗೊಂಡಿದ್ದು ಯಾವಾಗ ತಗೊಂಡ್ರದು ಕೊಡಿ ಅದು.
Along with memo, I filed.
ಸೈನ್ ಮಾಡಿದಾರಾ? ತೊಗೊಳ್ಳಿ. The appellant council has filed memo for retirement. And the very appellant himself has signed in the memo. And the same is dated 25/3/24 and hence permitted to retire.
Much.
And council is permitted to retire. The papers were taken back on 25/3/24 and till date not engaged any council. However, another 2 weeks time granted to engage the council. If appellant fails to engage the council, appeal will be dismissed in the next date of hearing. The registry is directed to show the name of the appellant in the cause list. List this matter. Next week, madam, another 2 weeks, sir. Engage the council. List this matter after 4/7. 4/7.
Lord, earlier, my lord, IA1 is pending. My own affidavit has been filed, my lord, to recall the dismissal order.
Pending for consideration ಅಂತಿದೆ. ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಇದು ಅಪೀಲು.
Dismiss ಆಗಿತ್ತು.
ಆಯ್ತು, ಅದು ಯಾರು ಬರ್ತಾರೋ ಅವ್ರು ಬಂದು ಹೇಳಿ.
My own affidavit is filed.
ಆಯ್ತು, ಇರ್ಬೋದು, ನಿಮ್ದು ಇರ್ಬೋದು.
Please.
ಬಂದು ಹೇಳಿ ಅವ್ರು.
Obvious.
ಏನ್ ಹೇಳ್ತಾರ ಹೇಳಿ. ನ್ಯೂ ಕೌನ್ಸಿಲ್. ಶಂಕರ್ ನಾರಾಯಣ್ ಭಟ್, ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ 4th time. Sorry, the appellant counsel is absent and not paid the cost and the matter is also listed for 4th time for non-compliance. And appellant is not showing any interest in pursuing the matter. And in spite of weeks time was granted to comply with office objections. With order dated 31/24, not complied and not paid the cost and hence appeal is dismissed. Non-compliant. Second time after recalling, ಏನ್ರಿ ಇದು? ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ರಿಕಾಲ್ ಆದ್ಮೇಲೂ ಮತ್ತೆ 2 ಸರಿ ಕಾಲ್ ಮಾಡಿದ್ರು ನೀವು ಕಂಪ್ಲೈ ಮಾಡಲ್ವಾ?
2 weeks.
ಕೊಡಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ.
2 weeks time.
ಮತ್ತೆ 2 weeks ರೀ. 2019 ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಆಮೇಲೆ ರಿಕಾಲ್ ಮಾಡಿದ್ಮೇಲೂ ನೀವು ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಹೇಳಿ? ಒಂದ್ಸರಿಲಾರು ಅಟ್ಲೀಸ್ಟ್ ಡಿಸ್ಮಿಸ್ ಆದಾಗ್ಲಾರು ಬುದ್ಧಿ ಬರ್ಬೇಕು, ಆಗ್ಲೂ ಬರಲ್ಲ ಅಂದ್ರೆ ಏನು? 10 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕೊಡಿ. ನಿಮ್ ಆರ್ಡರ್ ಶೀಟ್ಗೆ ಒಂದು ಫೈಲ್ ಆಗಿದೆ ನೋಡಿ. ನಿಮ್ ಅಪೀಲ್ ಹಾಕಿದ್ಮೇಲೆ ಆರ್ಡರ್ ಶೀಟ್ಗೆ ಒಂದು ಫೈಲ್ 19 ಅಲ್ಲಿ ಒಂದ್ಸರಿ 2 ಸಲ ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ, ಕೋರ್ಟ್ ಮುಂದೆ ಮತ್ತೆ ಫೇಲಿಂಗ್ ವಿಚ್ ಅಪೀಲ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಅವತ್ತೊಂದು 29/5 ಅಲ್ಲಿ 29/5 ಅಲ್ಲಿ ಬರಲೇ ಇಲ್ಲ, ಡಿಸ್ಮಿಸಲ್ ಆಯ್ತು. ಆಮೇಲೆ ಮತ್ತೆ ಅಲೋ ಆಗಿದೆ ಅದು. Order is recalled, restored to the registry and payment of cost of ₹500. ಏನ್ ಲೀನಿಯನ್ಸ್ ತೋರಿಸಿದ್ರು ಇದೆ ಹಣೆ ಬರ. This appeal was earlier dismissed and thereafter the same was recalled. And even after the recalling of the order also, office objections are not complied and matter listed on 13/12/23. And once again, 4 weeks time was granted to comply with the office objections. And in spite of it, even after lapse of 6 months, office objections are not complied. And council again seeks time and no reasons are made out to once again grant time. However, on cost of ₹1,000, 2 weeks time granted to comply with office objections. If not complied, list the matter for dismissal on 4/7. Cost payable at registry hakbudist. Dismissal of appeal for non-compliance of office objections, non-payment of cost. ಏನಾಯ್ತು? ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ರಾ? ಕಾಸ್ಟು ಕಟ್ಟಿಲ್ಲ, ಕಂಪ್ಲೈನು ಮಾಡಿಲ್ಲ. ತೋಳ್. This court wide order dated 25/1/24 granted 3 weeks time to comply with office objections subject to payment of cost of ₹1,000. failing which appeal shall stand dismissed. ಮತ್ತಾಕ್ ಬರ್ಬೇಕು ಮೇಡಮ್ ಇದು ಕೋರ್ಟ್ ಮುಂದೆ? ಸ್ಟ್ಯಾಂಡ್ ಡಿಸ್ಮಿಸ್ಡ್ ಅಂದ್ರೆ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಅಂತಿಲ್ಲ. ಫೇಲಿಂಗ್ ವಿಚ್ ದಿ ಅಪೀಲ್ ಸ್ಟ್ಯಾಂಡ್ ಡಿಸ್ಮಿಸ್ಡ್ ಅಂತ ಇದೆ. ಮತ್ತಾಕ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬರ್ಬೇಕು ಇದು? ಅವತ್ತೇ ಆರ್ಡರ್ ಇದೆ ಡಿಸ್ಮಿಸ್ಡ್ ಅಂತ. And in spite of it, not paid the cost and also not complied, and hence in terms of the order dated 25/1/24, appeal is dismissed. ಜಡ್ಜಿ ಕೆಲ್ಸ ಇಲ್ಲ ಮಾಡಕ್ಕೆ ಅಂತ ಇಂಥವೆಲ್ಲ ಹಾಕೋದು.
ಕಾಸ್ಟ್ ಕಟ್ಟಿದೆ.
ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹೇಳ್ರಿ.
ಕಾಸ್ಟ್ ಕಟ್ಟಿದೆ ಇವತ್ತು.
ಅಪ್ಲೈ ಮಾಡಿದ್ರಾ?
ಒಂದು ವಾರ.
ಕಾಸ್ಟ್ ಕಂಪ್ಲೈನ್ಸ್ ಎರಡೂ ಇರೋದು. ಮಾಡಿದ್ರೆ ಇಲ್ಲ ಹೇಳಿ.
ಅಲ್ಲ ಕಾಸ್ಟ್
2019 ಮ್ಯಾಟರ್ಸ್ 5 ವರ್ಷದ ಮೇಲೂ ಕಂಪ್ಲೈಂಟ್ ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಏನ್ರಿ ನೀವು?
ಒಂದು ವಾರ ಟೈಮ್.
11 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ, ಒಂದು ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿಲ್ವಾ? ನೋಡಿ, dismissed. This matter was listed before the registry for compliance on 6/6/22 and once again on 13/1/23 and 5/7/23, 3 times before the registrar, and also listed before the court on 13/12/23, and this court granted time to pay the cost and comply with office objections by granting 2 weeks time. And today counsel submit that he has paid the cost but not complied with office objections. On verification, there are, yes madam, there are 9, 10, 11 office objections, and none of the office objections are complied from 2019 to 2024 for a period of 5 years. And hence, on further cost of rupees 1,000, another 2 weeks time granted. If the further cost is not paid and not complied, list the matter for dismissal on 4/7.
2 weeks time.
ಏನಕ್ಕೆ?
2 times ತಗೊಂಡಿದ್ದೀವಿ ಆಲ್ರೆಡಿ.
ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿರೋದ್ರಿ.
2 times.
Council 2 weeks time and 1 week time granted to pay PF and ascertain the correct address and furnish the same. And if the PF paid within 1 week, issue emergent notice against R2. And if the same is not paid within that period, appeal against R2 is dismissed. Perusal of received city civil court stating that R6 is dead along with death certificate.
I'll take necessary.
Council 6 2 weeks time to bring the LRs of R6. What about R5, R7, R8 and R9?
I'll take prescription.
Council 6 1 week time to pay the PF. To issue notice to R5, R7, R8 and R9. And if PF paid within 1 week, issue notice against them. If not paid within 1 week, appeal against them is dismissed. Modification of the order dated are filed by counsel for R1. Counsel for R1 ilwalla. Amel nodoಣ. Compliance of office in respect of IA 1 of 2 I3 for bringing LRs up.
Appearing for the appellant.
Yes, madam.
My lord, appearing for the appellant in serial number 40.
Yes.
The objection raised is with respect to providing the complete address. During the course of the day, this will be done, my lord.
The council submits that during the course. Alla re full cast rate ಹಾಕಿಲ್ಲ ಅಂತ. Full cast rate ಹಾಕ್ತೀರಾ ನೀವು?
ಹೌದು.
ನೋಡಿ. The council submits that during the course of the day, they are going to comply with the same. However, in another 3 days time is given to comply with office objections. And list this matter on 3 days ಆದ್ಮೇಲೆ ಕೊಡಿ ಮೇಡಮ್. ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ಐ ಮೇಲೆ 25/6.
Grateful, my lord.
I wait for 3 weeks time to file LR application to bring LRs.
ಯಾರು ಸತ್ತೋಗಿರೋದು ಯಾರು?
R6 and R8.
6 and 8. What about make payment of PF to R3, R7, R10?
We'll do it. We'll do it with.
Council 6 2 weeks time to bring the LRs of R6 and R8 and hence 2 weeks time granted. Directed to pay PF within 1 week to issue notice against R3, R4, R7 and R10 to 12. And if PF paid within 1 week, issue notice against them. If PF not paid within 1 week, appeal dismissed against them.
Respondent one
Appeal is dismissed against them. Respondent counsel
One
is
and
also
two.
present. 1 and 2 na?
Also,
1 and 2 is present.
great.
Non-arraying of defendant number 2 and 3A, not as parties before RA and RSA along with counsel submission ಅಂತ ನೋಡಿ. ಯಾರೀ ಲಾಯರ್ ಬರೋದೇ ಇಲ್ವಲ್ರಿ ಸೋಮಶೇಖರ KM ಯಾವಾಗ್ಲೂ ಬರೋದಿಲ್ಲ. ಇನ್ ಕೋರ್ಟ್ನವರೇ ಓದ್ಕೊಳ್ಳಿ ಅವ್ರ ಸಬ್ಮಿಷನ್ ಅಂತನ. 2020. Hmm. ಆಯ್ತು. The counsel submission is accepted in respect of defendant number 2. 3A ಗೆ?
Different number 3A and different number 5.
Hmm.
In OS number are one and the same. After his father's death, he has been brought on record again.
No need, inadvertently.
Different number of the same parties. 3A and 5 of the same parties.
ಆಯ್ತು. The counsel submission with regard to 3A is also accepted. Post the matter for admission on 4/7. Madhusudan Rao. R2 and R4.
1 week's time.
Counsel 6 1 week time to pay PF, and if PF paid within 1 week, issue notice against R2 and R4. Compliance of office objection on Wakalat filed by R. Lokanatha.
My lords, IAs are ready. I'll get the signature on Monday. I shall comply it on Monday, my lords.
Counsel submits that he is going
Just
to
1 week is enough.
objection within 4 days.
Within one.
for the appellants, ma'am.
Obliged.
Appellant, yes, counsel. Post the matter for
Interim order may be extended, ma'am.
admission on 5/4. Who filed this, the memo? Portal memo? Portal memo ಹಾಕಿರೋದು ಯಾರು? ಇಲ್ಲಿ ಹೋಗೇ ಬಿಟ್ರೇನ್ರಿ ಅವರು? ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ದಾರು? ನೀವ ಅವರ?
ನಾನೇ ಮೂವ್ ಮಾಡಿದ್ದು, my lords. ಅವರು
ನೀವೇನಾ?
ಬರ್ತಾರೆ ಅನ್ಕೊಂಡಿದ್ದೆ, ಚೆನ್ನೈ ಹೋಗಿದ್ದಾರೆ.
ಆಯ್ತು.
Monday I shall comply, my lords.
ಆಯ್ತು. List this matter on 5/4. Sorry, 5/7. GJ ಶಂಕಾಪುರ್, ಸುಂಕಾಪುರ್. 2 weeks ಯಾಕ್ರಿ PF ಕೊಡಕ್ಕೆಲ್ಲ? ಕೊಡ್ಬೇಕು, ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ಏನ್ ಮಾಡ್ತಾ ಇದೀರಿ ಇದುವರೆಗೂ? 6 days delay. Along with statement of objections filed by counsel for R1. Counsel for the appellant seeks 2 weeks time and 1 week time granted to pay PF and furnish correct address. And if the same is furnished, issue notice against R2, R3 and R4.
For the appellant, my lord.
R9, R13, 19.
My lord, we have paid the PF and needful done.
Today?
Yes, my lord.
Counsel submits that he has paid the PF today in the office and hence issue notice against R9, R13, R19 and R20. Furnishing of PF book, acknowledgement, etc. to issue notice to R1 and R2 for 3rd time. Nodi. Service, TI 22 service incomplete.
That's my number 3, my lord.
ಅದು ಆಮೇಲೆ ಬಂದೇ ಅಲ್ವಾ ಕೋರ್ಟ್ ಮುಂದೆ? ಆಮೇಲೆ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ. Appellant counsel is absent and counsel is directed to furnish the PF to issue notice against R1 and R2 within 1 week. If PF paid within 1 week, issue notice against R1 and R2. If not paid within 1 week, appeal against R1 and R2 is dismissed. And list the matter for admission on 5/4. 5/7. 48, Virupakshaya PH. Notice to R7.
Step down. 2 weeks time.
2 weeks ಹಾಕ್ಬೇಕು PF ಕೊಡಕ್ಕೆ, correct address furnish ಮಾಡಕ್ಕೆ. Counsel 6 2 weeks and granted 1 week time. Furnish PF and correct address. And if furnished within 1 week, issue notice against R7. And if the same is not furnished, appeal is dismissed against R7. Perusal of unserved cover of R8 and 20 returned with a shara deceased, and hence counsel is directed to take steps of against the LRs of R8 and R20 within 2 weeks. Shiva Kumar N. Notice to R3. Yarilva?
A week's time.
Weeks time, counsel 6 weeks time and weeks time granted to furnish the PF and correct address. And if furnished, issue notice against R2, R3, R5, R6 and R7. Complaints of office objections. Vacant Sharma, Adrian.
Notice has to go to the proposed LRs, my lord.
Huh?
Notice has to go to the proposed LRs.
But complaints ಇದೆ ನೋಡ್ರಿ.
Copy not served ಅಂತ.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕಲ್ಲ ಮತ್ತೆ.
ಮಾಡ್ತೀನಿ, ಸರ್ವ್ ಮಾಡ್ತೀನಿ. I will serve that, but notice has to
Council
go.
ಅದೊಂದೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
ಹೌದು, ಹಾಗೆ ಇದೆ. Copy not served on the other side ಅಂತ.
The council undertakes to serve the copy on the other side. ಒಂದೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನೋಡಿ ಮೇಡಮ್. And hence issue notice against the LRs of R4, R9, R17 on IA 1 of 23 to IA 10 of 23. ಹೌದಾ?
ಹೌದು.
ಮತ್ತೇನ ಮತ್ತೆ IA number 11 ಬೇರೆ ಏನೈತೆ?
ಅದು ಇನ್ನೊಂದು additional document. That also I will serve the copy, my lord.
The council also copy serve ಆಗಿಲ್ಲ ಅಂತಲ್ಲ?
ಮಾಡ್ತೀನಿ, ಹೌದು.
Council
Additional
also
document.
undertakes to serve the copy on IA 11 of 23.
And
Council has filed memo for treating R3 to R7 as LRs of deceased R1. The same is other side R ಇಲ್ವಾ?
ಇಲ್ಲ,
ಅಪೇರ್ ಆಗಿಲ್ಲಲ್ಲ ಇದ್ರಲ್ಲಿ R1 ಗೂ ಅಪೇರ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಆಗಿದ್ದಾರೆ, ಈಗ ಒಬ್ರು ಬಂದಿದ್ದಾರೆ.
In view of the memo and the memo is taken on record for the reason stated in the memo and treated R3 to 7 as LRs of deceased R1. Appellant council is directed to amend and file amended cast title within 2 weeks. Steps to be taken in respect of R18
I
is
will take steps, my lord.
2 weeks time granted to take steps against R18. Sufficiency of service of notice in respect of R2 to 8. ಏನದ್ ಮೇಡಮ್ ಏನಂತ ಎಲ್ಲಾನು notice issued against R2 to 8, 10, 11, 15 and 16 were returned with an endorsement as refused and hence held sufficient against them.
And
ಮತ್ತೆ
regarding
R19
R19 in weeks time, my lord, I will take
weeks
steps.
time granted to pay PF to issue notice against R19. If PF paid, issue notice against R19.
Please.
Nagendra T, notice to R8. Appellant counsel is absent and 1 week time granted to pay PF. And if PF paid within 1 week, issue notice against R8. If not paid within 1 week, appeal against R8 is dismissed. Acceptance of service of notice in respect of R3 to 7 were signed by some other persons antide. The notice issued against R3 to R7 are signed by some other persons and hence registry is hence the appellant counsel is directed to verify and submit whether the acknowledged person is an adult member of the family of R3 to R7. List this matter on 47. ಅಥವಾ ಮುಂಚೆನೇ ಹಾಕೋದಾರ ಹಾಕ್ಬಿಡಿ. 1 week. 28/6. PS Nagraj. Memo for having served the copy of appeal memo to R4 through executing court, that is name. ಏನಂತ?
ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಟೈಪಿಕಲ್ ಮಿಸ್ಟೇಕ್ ಮೇಲೆ ಮಾದೇವಂ ಅಂತ ಆಗಿದೆ, ರತ್ನಂ ಅಂತ ಹೇಳಿ ಆಗೋದು. ಆರ್ ಫಾರ್ಮ್ ಮಾದೇವಂ ಅಂತ ಟೈಪಿಕಲ್ ಮಿಸ್ಟೇಕ್ ಮೇಲೆ ಕಾಪಿ ಎಸ್ ಸರ್ವ್ಡ್ ಮೇಲೆ
ಶುರು ಮಾಡಿದೀರಾ?
ಎಸ್ ಮೇಲೆ ಲಾಸ್ಟ್ ಪೇ
ಯಾರಿಗೆ ಕರೆಕ್ಟ್ ಆಗಿ ಅವರಿಗೆ ಶುರು ಮಾಡಿದೀರಾ? ಮಾದೇವಮ್ಮನ್ ಅಲ್ವಾ?
ಅಲ್ಲ ಸಮ್
mistake mentioned ಮಾಡಿದಿರಿ. The counsel for the appellant would submit that copy is served on the ಯಾರಿಗೆ?
ಲಾಸ್ಟ್ ಆರ್ಡರ್
R4
R4 ಮೇಲೆ
R4.
yes
And while filing memo mistakenly it is mentioned as Srimati Mahadevamma instead of Ratnamma.
Yes.
And copy is served on the Ratnamma.
Yes.
Counsel ಯಾರಿಗೆ?
ಇಲ್ಲ
Executing court ಅಂತಿದೆ.
ಮೆಮೊ yes my lord, issued notice to RSA 20/23 on
And hence held sufficient against R4, correct?
Yes.
Right. What's the matter for admission on 547?
R2 disease R2 delete
ಏನು ಇದೆ ಮೇಡಮ್ ಇದರಲ್ಲಿ?
R2 delete disease
R2 na?
yes my lord.
Given 2 weeks time to take steps against LRs of R2.
Already on record my lord.
ಯಾರು?
ಅವರು
ನಮ್ಮ ಕೊಡಿ ಅವರೇ. Furnishing of PF doesn't arise since this court held sufficient against R4. ಯಾರು ಇದ್ದಾರೆ?
ಇಲ್ಲ R2 ಮೇಲೆ ಡಿಲೀಟ್ ಮಾಡ್ತೀನಿ ಸರ್.
IFP for R1 and R3.
ಉಮೇಶ್ ಸಣ್ಣ ಸ್ವಾಮಿ ಮಗ.
R2 LR ಯಾರ್ರಿ?
R2 ಗೆ LRs ಇಲ್ಲ ಸರ್, ನೋ ಇಶ್ಯೂಸ್, ನೋ LRs ಮೇಲೆ.
ಈಗ ವಾಪಸ್ ಬಂದಿದೆ R2 is no more ಅಂತ. LRs ಇದಾರ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ತೀರಾ ಇಲ್ವಾ?
ಇಲ್ಲ ಸರ್, R2 ಗೆ LRs ಇಲ್ಲ.
LRs ಇಲ್ವಾ? ನಮ್ಮ ಹಾಕ್ಬೇಕು.
I filed
ತಗೊಳ್ಳಿ ಹಾಗಾದ್ರೆ 2 weeks time ಬೇಡ ಮೇಡಮ್ ಅದರಲ್ಲಿ. ತಗೋಬಿಡಿ. Council seeks time to file a memo. Since he submits that, R2 is not having any LRs. And hence 1 week time given to file such memo. ಅಷ್ಟೇ ಅಲ್ಲ? PF ಇನ್ ಬೇಕಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ. Held sufficient ಅಂತ ಮಾಡಿದ್ವಲ್ಲ. ಯಾರಿಗ ಸರ್ವ್ ಮಾಡಿದಾರಲ್ಲ. ರತ್ನಮ್ಮನ್ಗೆ.
Date may be fixed, my lord, ಅದಕ್ಕೆ here for admission list ಮಾಡೋದು.
List this matter. Admission ಗಿಂತ ಮುಂಚೆ ಅವ್ರು ಇನ್ನೂ ಏನೋ ಕಂಪ್ಲೀಟ್ ಮಾಡೋದು ಇದೆಯಲ್ಲ.
ಇಲ್ಲ, ಮೆಮೊ
ನೋಟಿಸ್ ಬರ್ಬೇಕಲ್ಲ. ಇಲ್ವಾ? ಆಯ್ತು, list this matter on 4/7. Memo ಹಾಕಿ ಅಷ್ಟೇ. 53.
Appearing for the appellants in this matter. Lords, with respect to R3 and R7, may be permitted to take notice, 1 week time may be granted.
1 week time granted as sought to pay PF to issue notice to R3 and R7. And hence, and if paid, if PF paid, issue notice against R3 and R7.
With respect to R5, it is mentioned as unclaimed.
Unclaimed, ನೋಡಿ madam ಅದು. Very absent, intimation delivered ಅಂತಿಲ್ವಾ? But ಒಂದ್ಸರಿ intimation delivered ಅಂತ ಇದೆಯಾ? ಅಷ್ಟೇ ಸಾಕು. On perusal of postal Shara, there is a endorsement, delivery of endorsement that the intimation is delivered and hence held sufficient against R5.
That's paper book, I may be permitted to take 2 weeks, my lords.
ಆಯ್ತು, ಎಷ್ಟು ದಿವಸ ಬೇಕು?
2 weeks, my lords.
Council says 2 weeks time to file paper book and hence 2 weeks time granted as sought.
Lords, and IA 2 of 23 and 3 of 23, it requires to be considered along with the merits of the appeal itself.
ಇದಾರ್ ನೀವೇ ಹಾಕಿರೋದಾ?
Yes, my lords, we have only
IA 2
filed.
of 23 and IA 3 of 23 can be considered along with main appeal.
Yes,
And counsel for the appellant submission is taken on record.
Lords, with
Non-filing of fresh valuation slip as per operative portion of RA court.
yes, my lord,
Counsel submission
before- in the OS, my lords, we sought for the declaration that the alleged mortgage deed which is executed as a security by the mother of the plaintiff before the trial court, my lords. It is fabricated and fraudulent document, and it is not binding, null and void, and not binding on the plaintiff.
Once you says that it is for a security.
No, my lords,
then
but the fact,
to contend that it is a fraud and.
no, my lords, the fact is that, my lord, case is that the mother of the plaintiff who has executed,
Fabricated ಬರಲ್ಲ, but fraudulently maybe.
she was already dead prior to the execution.
ಹೇಳಿ non-filing of fresh valuation slip ಹಾಕ್ಬೇಕಲ್ಲ, ಹಾಕಿ ನೀವು.
My lords, that requires, we have challenged the order portion of the RA court also, my lord, with respect to fresh valuation.
RA order ಏನು?
RA order itself, my lords. The regular appeal number so and so, so and so, and so and so, so and so, challenging the judgment and decree dated in OS number 83/2004 dated so and so, file of the court of the additional cities will that so and so Ramnagara is allowed. Consequently, judgment and decree passed in OS number so and so, so and so, hereby set aside. And in the last portion of the order, my lords, further it is ordered that the plaintiff have to file a fresh valuation slip with reference to market value of the suit property, and the deficit court fee remains to be paid by the plaintiff within 3 months from today, even if the suit is dismissed, failing which the amount shall be recovered as arrears of land revenue, my lords. Our contention itself, my lords, prior to the execution itself is the executee is already dead. We have produced the death certificate also, and based on that only substantial question of law is also framed by the Honorable Court in the last date of hearing, my lords. And the trial court ultimately in its judgment has pointed out that when the executant is already dead, the question of execution doesn't arise. Even the financial corporation or the person who has kept the mortgage deed as a security, they failed to establish that it was executed by her only and she was alive at that time, my lords. In my case, I have already produced death certificate.
Counsel submission with regard to the non-filing of fresh valuation slip as per operative portion of RA court order is kept open.
Please, my lords.
I'm a proxy counsel appearing for appellant in this case, my lord. Kindly adjourn the matter, my lord. Reason being is,
Discrepancy in the name, father name of defendant number 2 in trial court and respondent number 2, along with counsel submission.
kindly adjourn the matter, my lord. Reason being is, counsel for appellant is no more. He passed away today morning. I'm a proxy counsel for appellant, my lord.
Yes, first matter.
Father, he is not shown in RA.
ಸರಿ, ಅವ್ರೇನೋ ಕೌನ್ಸಿಲ್ಸ್ ತೀರ್ಕೊಂಡ್ರು ಅಂತಾರಲ್ಲ.
ಇವತ್ತು ಬೆಳಿಗ್ಗೆ.
ನೋಡಿ. Proxy counsel seeks time on the ground that proxy counsel, the counsel on record is passed away and hence 2 weeks time granted.
Grateful, my lord.
Yes, first.
May I please, your lordship? It was not well, my lord. and
ಏಜ್ ಆಗಿತ್ತು.
ಪ್ರಮೀಳ್ ಅವ್ರ ಹತ್ರ ಕೊಲೀಗ್ ಆಗಿದ್ರು. ಪ್ರಮೀಳ್ ಅವ್ರ ಹತ್ರ ಕೊಲೀಗ್ ಆಗಿದ್ರು.
ಗೊತ್ತಾಯ್ತು.
Because he was not well for some time.
Earlier he appeared in through VC also. Yes,
No, the
55.
for appellants. No, this is a matter, my lord, where I was not a party in the proceedings both before the trial court as well as before the first appellate court. I purchased the property, my lord, way back in the year 2006. Subsequently, the suit was filed. That was a second suit filed during the pendency of the first suit. So that suit was dismissed.
Now the objection is non-arraying of
Yes.
respond number 6, 7, 8 are not
Yes.
made party in
Because
array and
I am not
array.
seeking any relief against them, my lord, therefore. Notice.
Note
them.
ಇದೆಯಾ? Appellant is not a party and so we are not aware of status of parties ಅಂತ ಹೇಳ್ತೀರಿ ನೀವು.
ಅಲ್ಲ, status. Yeah.
That is the council submission. Well, office note not made a party in RA and OS not filing of necessary application, hence office objection is raised ಅಂತಿದೆ.
So I'll just look into that. means.
ನಿಮ್ submission ಇರೋದು ಹಾಗೆ.
I'll
You
just.
are
look
not
at-
aware of status of
ಅಲ್ಲ,
parties.
no, that's not correct. I'll just look into.
Discrepancy in the schedule column of appeal and ಏನೇನಿದೆ ನೋಡ್ಬಿಟ್ಟು compliance ಮಾಡಿ.
I'll just look into.
5B also.
So far as
The
he's
Muga is
concerned, my
not
lord,
made
no,
party in
he
RSA
passed away,
along
my
with,
lord. He is reported to have,
Appellant is not made a party in OS and RA, hence does not have any death certificate.
so far as Muga is concerned, so far as Muga is concerned, he. passed-
ಆಯ್ತು, you are not a party and hence you have no death certificate ಅಂತೆಲ್ಲ ಬರೆಯಕ್ ಆಗಲ್ಲ.
ಅದು ಬರ್ದಿದ್ದೀರಲ್ಲ.
ಹಾಗಾದ್ ಬರೆಯಕ್ ಆಗಲ್ಲ ಅಂದೆ. ಹಾ. ಎಲ್ಲದಕ್ಕೂ ಆ ತರದ objections. Appellant is not a party in OS and RA, hence does not have any death certificate. ಹಾಗಾದ್ರೆ ಹೆಂಗೆ?
We cannot.
Does not have any death certificate ಅಂದ್ರೆ you have to obtain the death certificate of death of so and so. ಅಷ್ಟೇ. Office, the council submission is not accepted and given 1 week time to comply with office objections.
So far as notice to, these respondents may be dispensed with. I am 16 to 21.
ಹಾಕಿದಿರಾ ನಿಮ್ಮ ಅಮ್ಮ ಹಾಕಿದಿರಾ?
ಇದರಲ್ಲಿ ಬರ್ದಿದೆ, submission, page 11 ಅಲ್ಲಿ ಬರ್ದಿದ್ದೇನೆ.
Page 11 ಅಲ್ಲಿ.
Page 11 ಅಲ್ಲಿ.
ನೋಟ್ ಹಾಕಿದಿರಾ?
ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಆದ ತಕ್ಷಣ submission ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಕೊಡಿ.
14 to 21 ಅಂದ್ರೆ 14 and 15 ಇರ್ಲಿ, 16 to 21.
First office objections comply ಮಾಡಿ
ಅದು ಮಾಡ್ತೀನಿ.
note ಎಲ್ಲ ಮಾಡೋಣ. ತಗೊಳ್ಳಿ. The appellant in the cast title itself made a mention that not seeking any relief against respond number 14 to 21 and hence notice may be dispensed against them. And hence notice against the respond number 14 to 21 dispensed in view of the submission below the cast title at the risk of the appellant.
Please, Miller, there is one more submission. There is one RSA 1851 of 23 against the very same orders. Miller, that's also before your lordship filed by another.
The council submits that RSA 1851 of 23 is also pending arising out of the same judgment and hence list the same along with this appeal.
Your lordship may post it on.
You
8th
comply
of-
ಮಾಡ್ಬೇಕು first.
ಅದೇ
Comply
8th of-
ಮಾಡಿದ್ಮೇಲೆ ಬರುತ್ತದೆ.
ಅದೇ 8th of July.
If office objections are complied, list this matter on 8/7.
Please.
Memo dated 25/4/24 filed by advocate for appellant. What is that memo?
Lord, acceptance of
Well,
notice.
respondent number 190.
Lord, sir has filed wakalat.
Please.
For responding.
I am for the respondent 190.
ಮೆಮೊ ಏನ್ರಿ ಅದು? ನೀವು ಫೈಲ್ ಮಾಡಿರೋದು? ಮೆಮೊ ಫಸ್ಟ್ ತೆಗ್ದಿಟ್ಕೋಬೇಕು. ನೀವು ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ತೋರಿಸಿದ ತಕ್ಷಣ ಮೆಮೊ ತೆಗ್ದಿಟ್ಕೋಬೇಕು ನಿಮ್ ಜೊತೆ.
Death of appellant number 1. Maybe.
Death of appellant number 1.
Lord, he is representing some
Regarding service of
some other
notice by
case.
hand ಅಂತ
I am
ಏನಾಗ್ತದೆ?
appearing for the respondent.
24/4 ಎರಡು ಮೆಮೊ ಇದೆ ಮೇಡಮ್ ಇಲ್ಲಿ. ಯಾರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ರು ಅವರು? ಕವರಿಂಗ್ ಲೆಟರ್ ಅಡ್ರೆಸ್ ಟು ದಿ ಮಿಸ್ಟರ್ ಹತ್ವಾರ್.
Please, that I have filed wakalat, Lord, in so far as respondent number 1 and 2 I have filed wakalat. already.
ಹಾಕಿದ್ದೀರಾ?
ಹೌದು, already ಹಾಕಿದ್ದೀವಿ.
Sorry, the counsel for the appellant has filed memo having served the notice. ಯಾರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ರಿ ನೀವು?
Before the trial court counsel, my lord. Earlier.
ಯಾರಿಗೆ ಹೇಳ್ರಿ? ಸರ್ವ್ ದಿ counsel for the plaintiffs in OS.
Yes, my lord.
Plaintiffs in
ಯಾರು
OS.
respondents ಯಾರು ಅಂತ ಹೇಳ್ಬೇಕು ಈ
Respondent
RSA ನಲ್ಲಿ.
Respondent number 1.
No, 192.
Sushma Priya and Sumant.
1 and 2 ನಾ?
Yes, my lord.
1 and 2 and counsel Sri ಯಾರು ಈಗ ಹತ್ವಾರ್ ಹಾಕಿದಾರ
ಅಲ್ಲ ವಕಾಲತ್
ಪ್ರಸನ್ನ ಶೆಟ್ಟಿ ಹಾಕಿದ್ದಾರೆ. And counsel Prasanna Shetty already filed wakalat for R1 and R2.
My name is
ಅದು ಮತ್ತೆ ಇನ್ನೊಂದ್ ಮೆಮೊ ಇರ್ಬೇಕು ನೋಡಿ ಮೇಡಮ್ 25/4 ಇಲ್ಲೊಂದು 25/4 ಇನ್ನೊಂದೇನೋ ಇದೆ. ಕಾಪಿ ಆಫ್ ದಿ ಕವರಿಂಗ್ ಲೆಟರ್ ಅಡ್ರೆಸ್ ಟು ದಿ ಹತ್ವಾರ್ ಅಡ್ವೊಕೇಟ್ ಅದು ಶುರು ಮಾಡಿರೋದಾ? ಆಯ್ತು ಅದೇನು ಈಗ ಮತ್ತೆ ಬರೋದಿಲ್ಲ. ಅಲ್ಲಿಗೆ ಏನಾಯ್ತು ಈಗ ಸರ್ವಿಸ್ ಶುರು ಆಯ್ತಾ?
Yes, my lord. My lord,
ಮೆಮೊ ಡೇಟೆಡ್ 25/4/24 is taken on record.
my lord, kindly pass.
Complete ಆಯ್ತಾ?
Yes, ma'am.
Maintainability of this appeal in view of section 100 of CPC, a suit is ordered to be restored ಅಂತೇನ ಇದೆ? ಮೇಂಟೈನ್ ಆಗಲ್ಲ ಅಂತ ಅಪೀಲ್.
ಅಲ್ಲ, second appeal is maintainable. There is no other, because order 7 rule 11 application came to be allowed, against which an appeal.
Order 7 rule 11 allowed.
Application, yes,
Allowed.
yes.
Plaintiff
After the,
ಆಮೇಲೆ ಏನಾಯ್ತು? ಅಪಲೇಟ್ ಕೋರ್ಟ್
ಅದ್ರ ಮೇಲೆ appeal ಹಾಕಿದ್ರು.
ಅಪೀಲ್ ಅಲ್ಲಿ ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್.
Appeal and divergent finding and appeal, ಅದ್ರ ಮೇಲೆ appeal, second appeal. There is, and this was, by the earlier bench also, this was heard and court expressed it. I don't know why again this.
ಅದರಲ್ಲಿ
ಯಾಕೆ ತೋರಿಸಿದಾರೆ ಇದು?
ಅಲ್ಲಿ ರಿಮಾಂಡ್ ಅಂತ ಬಂದ್ರೆ ಮಾತ್ರ CRP ಬರುತ್ತೆ, ಬಟ್ ಇದರಲ್ಲಿ ಅಪೀಲ್ ಇಸ್ ರಿಸ್ಟೋರ್ಡ್ ಟು ದಿ ಫೈಲ್ ಸೂಟ್. RSA is
ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್.
RSA is maintainable.
RSA is
maintainable.
And RSA was admitted.
It was admitted also.
ಅಡ್ಮಿಟ್
ಹೌದು, admit
ಆಗಿದೆ.
ಆಗಿದೆ.
That was on
ತೋರಿಸ್ತಾರೆ.
25/4/2020.
ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಮತ್ತೆ ತೋರಿಸ್ತಾರೆ. ತೊಗೊಳ್ಳಿ. ಇರೋದ್ ತೋರ್ಸಲ್ಲ, ಇಲ್ಲೂ ತೋರಿಸ್ತಾರೆ ನಮ್ಮ ಆಫೀಸಲ್ಲಿ ಹಂಗೇನೆ. This is already admitted.
Admitted.
ಮತ್ತೆ ಏನಕ್ಕ ಬರ್ಬೇಕು ಈಗ ಮ್ಯಾಟರ್? ಮತ್ತೆ ನಾನ್ ಫೈಲಿಂಗ್ ಆ ಪೇಪರ್ ಬುಕ್ ಇದೆ ಅಷ್ಟೇ.
ಅಲ್ಲ, ಅದಕ್ಕಲ್ಲ ಇದು
ಪೇಪರ್ ಬುಕ್ ಏನಾಗಿದೆ?
my lord,
ಆ ಪೇಪರ್ ಬುಕ್ ಯಾಕ್ರಿ ಬೇಕು? ಆರ್ಡರ್ 7 ರೂಲ್ 11 ಮೇಲೆಲ್ಲ
ಬೇಡ.
my lord, more than
ಆಯ್ತು, ಫೈಲಿಂಗ್ ಆ ಪೇಪರ್ ಬುಕ್ ಇಸ್ ಡಿಸ್ಪೆನ್ಸ್ಡ್.
my lord, more than, sorry,
ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆನ್.
my lord, one submission, my lord. The person before the court is about 87 years old or so. He got the property from his.
ಆಯ್ತು, ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮಾಡೋಣ.
ಅಲ್ಲ, ಏನಾಗುತ್ತೆ, he is already on the deathbed. He got only one.
ಹಾಕ್ತೇನ್ರಿ.
One second. I will not waste the time of the court. He got 6 cents of land in the partition, which belonged to his wife. His wife died, and his sons and himself, he got 6 cents of land. On that, after his wife died, his son kicked him out of the house, and his son is the instrumental in getting the suit for partition filed by his son. That is a grandson. It's the property, section 14 is attracted, and the trial court went into this matter. Order 7 rule 11 said that the plaint should be rejected.
Next week final hearing ಮಾಡೋಣ. If you succeeds.
My lord, by this application he has sought.
ಏನಂತಿದೆ ಆರ್ಡರ್ ಅಲ್ಲಿ? Dispose of the matter afresh in accordance with law. ಅಷ್ಟೇ. Original suit was restored.
Please.
ನಿಮ್ಗೆ ಕನ್ಫ್ಯೂಷನ್ ಬಿಟ್ಬಿಡಿ. ಆಲ್ರೆಡಿ ಮ್ಯಾಟರ್ ಇಸ್ ಅಡ್ಮಿಟೆಡ್.
My lord,
ರೆಸ್ಟೋರೇಷನ್ ಇಸ್ ಡಿಫರೆಂಟ್ ಫ್ರಮ್ ರಿಮಾಂಡ್.
ರಿಮಾಂಡ್ ಆದ್ರೆ MSA ಬರುತ್ತೆ.
ರಿಮಾಂಡ್ ಆದ್ರೆ MSA ಬರುತ್ತೆ. ರೆಸ್ಟೋರ್ ಆಗಿರೋದ್ರಿಂದ that order 7 rule 11 application was allowed. That amounts to a decree. That has been challenged in RA. RA ನಲ್ಲಿ ರಿವರ್ಸ್ ಆಗಿದೆ. That has been challenged. RSA is maintainable. No doubt.
My lord, only one submission, my lord. That 6 cents of land he wants to settle in favor of his daughter who is taking care of him. Now, he is not seeking stay of the entire idu. ಆ 6 cents ಗೆ permission ಕೊಡಿ ಅಂತ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು. Only that 6 cents. ಇಲ್ಲಿ. And the court also felt that
2 for 24 for direction ಅಂತೇನ ಇದೆ.
ಅದು then when the matter was heard, court also felt because of his inability and the age, let him also seek.
ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿರೋದು ಏನಕ್ಕೆ ಮ್ಯಾಟ್ರು?
ಲಿಸ್ಟ್ ಆಗಿರೋದು on these two. No.
For service ಗೆ.
ಅಲ್ಲ, I moved the matter to hear on this application IA 1 and 2. And that time court also expressed
IA 1 of 24 for stay, IA 2 bar 24 for direction.
To the children to maintain him. He has nowhere to go. He is, yes, that is, and the my lord said he will.
Instead of my lord hearing on it could be disposed of. I am ready, my lord, at any date
finally, because my lord, they want to, my lord, stay of, my lord, 6 cents of land to execute a settlement in favor of his daughter. If settlement is executed, my lord, my suit will become infructuous.
My lord, there are other lands. There are other
That is why,
lands.
my lord, rejection of.
Council
ready, ಮಾಡಿ ಯಾವ ದಿವಸ ಹೇಳಿ ನಾನು ready ಇದ್ದೀನಿ.
ಆರ್ಡರ್ 7 ರೂಲ್ 11A D ನಲ್ಲಿ ಅದನ್ನೇ ಮೇನ್ ಮೇಲ್ ಕನ್ಸಿಡರ್ ಮಾಡೋಣ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲೇ. I will fix the date instead of considering these two IAs.
I am highly obliged to this honorable court for this expression. At least top of the list, if it, and the orders list, if it is heard,
Please, my lord, therefore,
I will be, yes, he is also.
Please.
List this two matter, this matter for hearing IA 1 of 24 and 2 of 24. Next week alla kodi madam ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್.
With an
IA ಅಂತ ಹಾಕಿರ್ತೀನಿ ಅವತ್ತು ಹಿಯರ್ ಮಾಡೋಣ. ಎರಡು
please.
ಮೇನ್. Order 7 rule 11D apply ಆಗುತ್ತಾ ಇಲ್ವಾ ಅಷ್ಟೇ?
Yes, yes, that's the only.
Date ಕೊಡಿ madam next week. 28/6.
I am obliged, my lord.
Please. Oblige, my lord.
8 days delay. ಏನ್ರಿ?
For the respondent number 1 and 2.
Heard on IA 1 of 18 and there is a delay of 8 days in filing the appeal and for the reasons stated in the accompanying application, IA delay of 8 days is condoned.
As per my knowledge, my lord, appellant number 1 is no more now. He is died in the year 2020.
Appellant ಇಲ್ವಾ?
Appellant number 1.
Appellant number
ಎಲ್ಲಾರ್ಸ ಅವರೇ ತಂದಿದ್ದೀವಿ ಸ್ವಾಮಿ.
ತಂದಿದಾರಂತ?
ಚೌಡಯ್ಯ ಇಲ್ಲ.
Already ಎಲ್ಲಾರ್ಸ already on record.
Chodaya is no more. Chodaya is no more. His parties have been brought on record.
Already on record. ಮೆಮೊ ಹಾಕ್ಬಿಡಿ ಇಲ್ಲ ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ.
ಇಲ್ಲ
appellant number 2 is no more and LRs are brought on record. Appellant number 1 is also no more.
ಈಗ ನಾವು ಈಗ ಒಂದು appellant number 1 ಇಲ್ವಂತ ನೋಡಿ.
ಅದೇ ಸ್ವಾಮಿ ಚೌಡಯ್ಯ ಏನಿದ್ದಾರೆ ಅವ್ರು ಸತ್ತೋದ್ಮೇಲೆ ನಾವ್ ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ವಿ.
Appellant number 1 and 2 both are Chaudaya
73 years. ಚೌಡೇಗೌಡ ಸನ್ ಆಫ್ ಚೌಡೇಗೌಡ ಅವನ್ ಬೇರೆ. ಚೌಡಯ್ಯ ಇದಾನಲ್ಲ
ಅದಾದ್ಮೇಲೆ 2A 2B ಅಂತ ಮಾಡಿ.
ಸರಿ ರೀ, ಈಗ ಚೌಡಯ್ಯನು ತೀರ್ಕೊಂಡವ್ರೆ ಅಂತ ಅವ್ರ ಸಬ್ಮಿಷನ್.
ಸರಿ ಸ್ವಾಮಿ
ಅಪಲೆಂಟ್ ನಂಬರ್ 1 ಎಲ್ಲಾರ್ಸ್ ತಂದಿದಿರಿ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಆಯ್ತು. ಸಿನ್ಸ್ ಡಿಸೀಸ್ಡ್ ಬೈ ಹಿಸ್ ಎಲ್ಲಾರ್ಸ್ ಅಂತಿದೆ. ಈಗ ಅವ್ರ ಪ್ರಕಾರ ಇವರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ.
Then I will bring it here. I will.
Counsel for the respondent would submit that appellant number 1 is also no more, and hence appellant counsel seeks time to verify and take necessary steps if he is no more. List this matter on 5/4. So 47.
ಅಲ್ಲ 5/7.
5/7 ಆಯ್ತು. 5/7. Dated 11/11/21. ಹೇಳ್ರಿ ಏನು?
It was been dismissed for dismissed, my lord. 3 office objections, the minor office objections, my lord. A week's time may be granted. I'll comply with the office objection.
ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದು
11/11/21, my lord.
ನೀವು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ದು ಯಾವಾಗ?
18, my lord.
18 3 ವರ್ಷ.
No, my lord, 3 minor in respect of substantial question of law, my lord. A week's time may be granted
to do the needful in 2019.
Those office objection has been complied, my lord.
21 2 weeks time granted.
Again, there is a new office objection in respect of substantial question of law.
Dismissed.
Previous date alle office objections are comply agide swami. Again, there was a new office objection.
How previous date ಅಲ್ಲಿ?
It was when listed, it was in February 21.
Pending consideration ಅಂತ ಏನಾರ ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
No, my lord.
ಇಲ್ಲ. ಮತ್ತೆ ನೀವು ಯಾವಾಗ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದಿರಿ?
No, after 16/3, my lord, it was dismissed. Then we couldn't.
ನೋಡ್ರಿ, ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ 25/9/18 ಹೋಯ್ತು, ನೀವು ಆಬ್ಸೆಂಟ್ ಹೌದಾ? ಕೋರ್ಟ್ ಮುಂದೆ 2019 ಫೆಬ್ರವರಿಯಲ್ಲಿ ಬಂತು 22.
That has been complained, my lord. That has been complained. Even I've stated in my application.
4 weeks time is granted to do the needful.
Again, it was listed in February 21. Again, the office objection were complained, my lord.
ಎಲ್ಲಿ ಮಾಡಿದಾರೆ ಮೇಡಮ್? ಇಲ್ಲಿ ಇಲ್ವಲ್ಲ.
Now there is 3 minor office objections, my lord.
ಫಸ್ಟ್ 11 ಇತ್ತು. ಹನ್ನೊಂದರಲ್ಲಿ ಇನ್ನೂ 3 ಇದೆ.
3 minor office. I'll comply with a week's time, my lord.
ಎಸ್ ಸರಿ, ಕೋರ್ಟ್ ಮುಂದೆ ಬರ್ಬೇಕ್ರಿ ಕಂಪ್ಲೇಂಟ್ಸ್ ಗೆ. 5 ಸಾರಿ ಬಂದಿದೆ.
A week's time. Next week 20th we will listed, my lord.
Dismissed ಅಂತ 2 ಸಲ. ನೋ ಕೌಂಟ್ಸ್. ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮರ್ಯಾದೆನೇ ಇಲ್ಲ ನಿಮ್ಗಳಿಗೆ. Alva.
Lord, in March, it was pre-empty,
Appeal
auto was given. my lord.
2018, Toli, this matter was listed before the registrar on 25/9/2018 and counsel was absent. And again, matter was listed on 22/2019 and 4 weeks time was granted. At that time, there were 11 office objections.
That has been complied.
And again, matter was listed on 16/2/2021.
Those office objections were complied.
The very office objections are remained and not complied, even after lapse of 2 years.
Lord, now there is a
And
3.
once again, matter was listed on 16/3/21 and 3 weeks time granted to comply with office
Lord,
objections,
thereafter,
failing which the appeal stand dismissed.
Lord,
Then some of the office objections are complied and again 3 office objections are remaining. And hence, on 11th day of November 2021, this court has
Lord, in
dismissed
March,
the
there was a,
appeal for non-compliance. Having taken note of some of the office objections are complied and remaining office objections are not complied on cost of ₹2,000. Another 1 week time granted to comply with office objections pending consideration of this IA for recalling. Just to say the date of 2 weeks, list this matter on 4/7. ಅಷ್ಟೊಳಗೆ ಕಂಪ್ಲೈ ಮಾಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಆಗ್ತದೆ. 1 week ಹೇಳಿದಿರ್ಬೇಕು.
ultimately,
2 weeks
4/7.
2 weeks,
Please, please.
59.
I am for the
filing.
respondent, my lord. 10 days delay is there. Suit for specific performance. I am for the respondent.
On IA 1/18 and there is a delay of 10 days in filing and counsel and our respondent also appeared and not filed any objections and for the reasons stated in the accompanying application and affidavit. IA is allowed and delay of 10 days is 18 days, 10 days is condoned. List this matter for admission on 4/7.
Please.
Janardana GN, recalling the order dated 24/1/23. ಹೇಳ್ರಿ ಏನು
ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆ ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್
18 ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು 5 ವರ್ಷದ ಮೇಲೆ ಏನ್ ಹೇಳಿ
ಮೆಡಿಕಲ್
ಕೊಡಿ ಫೈಲ್ ಕೊಡಿ ಫಸ್ಟ್
ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆ ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್
ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಆಗಿದೆಯಾ ಕಂಪ್ಲೈ ಮಾಡಿದಾರಾ
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೀಟ್
comply with office objection raised on IA 1/23. If office objections are not complied within 1 week, IA 1 will be dismissed on the next date of hearing. 12/6 ಮಾಡಿದೆ. The counsel submits that he has complied with office objections and on verification, office objections are complied. And hence list this and hence IA for recalling the order 1/23 dated 24/1/23 is allowed in view of compliance of office objections as directed by this court on 12/6/2024. List this matter for admission on 5/4. Sorry, 5/7, 4/7. Bringing LRs of deceased R7 as R7 A to C. Notice ಹೋಗಿದೆಯಾ? Notice ಹೋಗಿಲ್ಲ. Issue notice on IA 1/24 against the LRs of R7 A to C. Next, 62. Ilva, there is heard on IA 1/18 and there is a delay of 20 days in filing the appeal and for the reasons stated in the accompanying application and affidavit. And also not filed objections to IA and having taken only 20 days delay of 20 days is condoned. List this matter for admission on 4/7. Kumar JC. 81 days delay in filing the LR application. Notice ಹೋಗಿದೆಯಾ?
ಹೋಗಿದೆ ಇಶ್ಯೂ ನೋಟಿಸ್ ಆಗಿದೆ. ನೋಟಿಸ್ ಆಗಿತ್ತು.
ನೋಟಿಸ್ ಆಗಿದ್ರ ಬಗ್ಗೆ ಇಲ್ಲೇನು ಇಲ್ವಲ್ಲ? ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ ಇದೆ. A3 bringing LRs of deceased R2 ಅಂತಿದೆ.
On 6/5 my lord 6/5/2023 issue notice to the IA 123.
ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
Please.
PF ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಏನಾಯ್ತು ನೋಡಿ ಮೇಡಮ್. 5/6/23
23.
ಏನಾಯ್ತು? ಪುಟಪ್ಪೆ ಮಾಡ್ಲಿಲ್ವಾ ಆಫೀಸ್ನವರು? ಇಶ್ಯೂ ಆಗಿದೆಯಾ ಹೋಗ್ಲಿ? ಇಶ್ಯೂ ಅಂತ ಆಗಿದೆ. ಆಮೇಲೆ ಆಫೀಸ್ನವ್ರು ನೋಡಿ ಹಾಕ್ಬೇಕಲ್ಲ ಏನಾಗಿದೆ ಅಂತ. ಒಂದೂವರೆ ಗಂಟೆ ದಿನ ಬರೀ ರಿಪೇರಿ ಕೆಲಸ. ಬೆಳಗ್ಗೆ 10:30 ಇಂದ 12 ಗಂಟೆವರೆಗೆ ಬರೀ ರಿಪೇರಿ ಮಾಡೋದು. ಯಾರಿಬ್ರಿಗೆ ತೋರ್ಸಿಲ್ಲ. ಇಬ್ರೇ ಇರೋದಾ?
Please.
ಯಾವಾಗ ಸರ್ವಿಸ್ ಆಗಿದ್ ನೋಡಿ. Told. This court has issued notice against the LRs of R2 and IA 1 of 23, 2 of 23 and 3 of 23 and notice issued against them have been served on respond number 2 A and B. And in spite of it, they have not appeared before the court and engaged the counsel, and for the reasons stated in the accompanying application and affidavit, delay of 81 days is condoned and abatement is set aside and permitted to bring the LRs of R2 on record. The registry is directed to show the name of R2, A and B in the cause list. The appellant counsel is directed to amend the cause title and file amended cause title within 2 weeks.
Paper
book ಯಾವಾಗ ಆಗಿರೋದು ಅಡ್ಮಿಷನ್ ಆಗಿದ್ದಾವೆ ಆಮೇಲೆ
2 weeks ಮೇಲೆ
ಆಮೇಲೆ ಬರ್ಲೇ ಅಲ್ವಾ?
ಬಂದ್
ಟೈಮ್ ಕೊಟ್ಟಿದ್ಯಾ?
ಇಲ್ಲ, ಅದು ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಬಂದಿತ್ತು ಅದು.
ಆಮೇಲೆ matter was admitted
ಮೇಲೆ on 14/11/2019
and 8 weeks time granted and subsequently no reference with regard to the non-filing of paper book and hence 2 weeks time granted as sought for filing of paper book.
Much.
CD of 22 days.
Objection to all.
Heard on IA 1 of 19 and there notice has been ordered and represented through counsel and no objection is filed. And for the reasons stated in the accompanying application and affidavit, and there is a delay of 22 days and hence a delay of 22 days is condoned. List this matter for admission on 4/7.
It is a covered against me, my lordship has disposed a similar matter and next date I will produce the order copy.
ಕೊಡಿ ಅದೇನಿದೆಯಾ ಕೊಡಿ.
The fragmentation act.
Matter.
I tried to get the copy today and next date I will produce.
ಆಯ್ತು ಕೊಡಿ. 4/7 ಬರ್ಲಿ. ನೀವು ನೋಡ್ಕೊಂಡು ಹೇಳಿ ಅದೇನೋ ಕವರ್ಡ್ ಅಂತ.
ಅಲ್ಲ ನಾನೇ ಹಾಕಿದ್ದು similar matter. I must be having copy.
ಆಯ್ತು. 237 days delay. Issue notice on IA 1 of 19 and also on main. Bringing LRs of deceased sole respondent R1 notice ಹೋಯ್ದೆ ಇಲ್ಲ. Issue notice against the LRs of R1 and also on main ಅಂತ ಹಾಕ್ಬಿಡಿ. ಮೇನ್ ಗೂ ನೋಟಿಸ್ ಹೋಗ್ಲಿ. LRs and main. ಮೇನ್ ಅಂತ ಫಸ್ಟ್ ಅವರು ಇವರೇನ ಆಯ್ತು. ಮೇನ್ ಹೋಗ್ಲಿ ಅದಕ್ಕೇನು ಅದ್ರಲ್ಲಿ ಬಂದು ಹೇಳಂಗಿರ ಹೇಳಿ. Further orders regarding IA 1 of 20 for CD of 24 days in filing the appeal.
My lord, appearing for the respondent in this case.
Yes, counsel.
Original respondent Bailamma ತೀರ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ. So
ಈಗ ರೆಸ್ಪಾಂಡೆಂಟ್ ತೀರ್ಕೊಂಡಿದ್ದಾರಾ?
ಹಾ ಸ್ವಾಮಿ.
Respondent counsel submit that respondent is also
Bailamma.
and hence appellant counsel is directed to take steps for bringing LRs of respondent and hence 2 weeks time granted. List this matter on 5/4/7. 68 direction. Banaprakash HV. ಹೇಳ್ರಿ
ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರು.
Time fix
ಅವ್ರೇನ್
ಮಾಡಿ-
ಹೇಳ್ತಾರೆ ಬೇಗ ಮುಗಿತಾ ಇಲ್ಲ.
ಏನಕ್ಕೆ ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡೋದು?
In 3 months ಅಲ್ಲಿ
Remand
disposal
ಆಗಿದೆ.
ಮಾಡಿ. 3 months ಆದ್ರೂ ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಮಾಡೋದೇ ಮಾಡಿ ಅಂತ ಲಿಬರ್ಟಿನೂ ಕೊಟ್ಟು ನಾವು ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ವಿ. ಅದರ್ ಸೈಡ್ ಇಸ್ ನಾಟ್ ಇಡ್ ಎವಿಡೆನ್ಸ್. ಡಿಸ್ಪೋಸಲ್ ಏನಿಲ್ಲ.
ಈಗೇನ್ ಡೈರೆಕ್ಷನ್ ಏನು ಅಯ್ಯ ಹಾಕಿರೋದು ಯಾರು?
ನಾನೇ
ಅವರೇ ಹಾಕಿವ್ರೆ.
ಏನ್ ಡೈರೆಕ್ಷನ್? ಆಲ್ರೆಡಿ there was a direction ಅಲ್ವಾ?
ಇದನ್ನೇ ಕಂಪ್ಲೈ ಮಾಡಿ ವಿಡಿ ಮಾಡಿ ಅಂತ ಹೇಳಿದೆ ಸ್ವಲ್ಪ. ಅವ್ರು ಸುಮ್ಮನೆ ಡೇಟ್ ಕೊಟ್ಕೊಂಡು ಎಷ್ಟೇ
ಕೆಳಗಿನ ಕೊಟ್ಟ
ಏನಕ್ಕೆ ಅಂತ ತಿಳ್ಕೊಂಡು ಹೇಳ್ತೀನಿ ಬೇಕಾದ್ರೆ.
ಕೆಳಗಿನ ಕೊಟ್ಟಲ್ಲ.
ಐ ವಿಲ್ ಎಕ್ಸಾಮಿನ್ ಅಂಡ್ ರಿಪೋರ್ಟ್ ಯಾಕೆ ಲೇಟ್ ಆಗ್ತಿದೆ ಅಂತ ನನಗೇನು ಮಾಹಿತಿ ಇಲ್ಲ.
ಅದ್ರಲ್ಲಿ ಅವರು ದೇ ನಾಟ್ ಲೀಡ್ ಎನಿ ಎವಿಡೆನ್ಸ್.
Session judge at Thampur to comply with the order dated 5/10/23 passed in the above appeal and disposed.
ಅದರ್ವೈಸ್ ಒಂದು ಲೆಟರ್ ಹಾಕಿರ ಅವ್ರು ಏನ್
ಆರ್ಡರ್ ಏನಂತ ಇದೆ ಕೊಡಿ ಮಾಡಿ
ಇನ್ಫಾರ್ಮ್. To dispose within the stipulated time, matter has been remanded.
3 months from 9/11/23, parties are directed to appear. And the first appellate court do not venture to issue notice and proceed with the matter and consider the same in accordance with law. Registry is also directed to send the application and the documents produced along with so and so. along with main appeal. First appellate court shall give opportunity to both parties to lead evidence. Evidence ಆಯ್ತಾ ಇಲ್ಲ?
ನಮ್ದು ಮಾಡಿಬಿಟ್ಟು ಅವ್ರು ಯಾರು ಮಾಡಿ ಅದರ್ ಸೈಡ್ ನಾಟ್ ಲೀಡ್ ಎನಿ ಎವಿಡೆನ್ಸ್
ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ.
ಏನಕ್ಕೆ ಪೋಸ್ಟ್ ಆಗಿದೆ ಈಗ?
ಈ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೊರಡು ಹಾಕಿರೋ ನಾವು ಫೈಲ್ಡ್ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಒಂದು ಜನವರಿ ಮಂತ್ ಅಲ್ಲಿ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿ.
ಜನವರಿ?
ಹೌದು.
ಹಾ.
ಆದ್ರೂ ಏನಿಲ್ಲ, ಸುಮ್ಮನೆ ಡೇಟ್ ಕೊಟ್ಟು.
ಜನವರಿ ನಂತರ ಏನು ಮಾಡಿಲ್ವಾ? The counsel for the respondent, the counsel for the respondent submits that he has reduced the evidence and matter is posted for arguments. Until date, all matter is, heard or reserved, ಏನು?
ಹೊರಡ್ ಅಂತ ಅದರ್ ಸೈಡ್ ಕೇಳ್ತೀವಿ ಅಂತ ಹಂಗೆ ಹೋಗ್ತಾ ಇದೆ.
Respondents ನ ಹೇಳಿಲ್ಲ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಾವೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಲ್ಲಿ.
ನೀವೇ respondent, but other side are appellant.
ಹೌದು, ನಮ್ದು ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್.
ನೀವೇ ಮೊದಲೇ argument.
ಅವ್ರು ಮಾಡಿಲ್ಲ, ನಾವೇ ಮಾಡೋದು, ಫಸ್ಟ್ ಹಾಕ್ಬಿಟ್ಟೆ ಸುಮ್ಮನೆ.
And arguments was also addressed on behalf of the respondent before the trial court.
Respondent 1 and 2.
Respondent number 1 and 2.
Defendant number.
And not yet disposed of the same. And hence the registry is directed to get the information from the trial judge. Appellate court ಗೆ refer ಆಗಿರೋದಲ್ಲ?
ಹೌದು.
First appellate judge.
ಒನ್ ಮೋರ್ ಥಿಂಗ್ ಈಸ್, ನಿನ್ನೆ ಏನಾಗಿದೆ ಅದು ಅಂದ್ರೆ ಫಸ್ಟ್ ಅಡಿಷನಲ್ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾವ್ದನ್ನ?
ಇದೇ ರೀ ಅಲಾಟ್ ಮಾಡಿಬಿಟ್ಟು
ಕೇಸ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ.
ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿ ಫಸ್ಟ್ ಅಡಿಷನಲ್ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್.
ಅಲ್ಲಿ ಹೋಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅಷ್ಟೇ.
ವಿತಿನ್ ವೀಕ್ ಅಲ್ಲ ಏನಾರ ಡಿಸ್ಪೋಸಲ್.
ವಿತಿನ್ ವೀಕ್ ಅಂದ್ರೆ ಅವ್ರು ಹೊಸಬ್ರು ಒಂಚೂರು ನೋಡ್ಬೇಕಲ್ಲ, ನೀವು ಹೋಗಿ ಅಡ್ರೆಸ್ ಮಾಡ್ಬೇಕಲ್ಲ.
ನಾವು ಹೋಗಿ ಹೇಳಿದ್ವಿ ನನಗೆ
ತೋಳಿ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ತೊಳಿದ ಅಷ್ಟೊಳಗೆ ಏನೋ ನೋಡೋಣ. ದಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಅಪಲೆಂಟ್ ಇಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ನ ಮೇಡಮ್? And also submits that now matter has been transferred to the family court.
ಫಸ್ಟ್ ಅಡಿಷನಲ್ ಫ್ಯಾಮಿಲಿ
First additional family court.
renumbered as 81/20 ಅದೇನಾ?
And appeal is also renumbered.
81/24.
And hence the first additional
ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್.
Family court judge is directed to dispose of the matter within 1 month. ಅವ್ರು ಹೇರ್ ಮಾಡ್ಬೇಕಲ್ಲ, ನಿಮ್ಗೆ ಆಪರ್ಚುನಿಟಿ ಕೊಡ್ಬೇಕಲ್ಲ, ಅಥವಾ 45 days ಅಂತ ಹಾಕ್ಬಿಡೋಣ. Within 45 days from today. ನೀವಿಬ್ರು ಹೋಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ಅಲ್ಲಿ. And both the counsels are directed to assist the first appellate court in disposal of the appeal within the stipulated time, and accordingly IA 1/24 is disposed of.
For the respondent, my lords.
Appellant, my lord.
ಏನು?
But side number 1 is for delay, my lords. It's 55 days delay.
My lord.
Respondents ಇದಾರಲ್ಲ?
Please, my lords.
ನಿಮ್ಗೆ
No objection for the continuation.
Heard on IA number 2/23, and there is a delay of 55 days in filing the appeal, and counsel for the respondent also not seriously opposes the same and orally opposes the same, and for the reasons stated in the accompanying application of affidavit, IA is allowed and delay of 55 days is condoned. List this matter for admission on 4/7.
My lord, stay is required, my lord, because FDP is
delay
pending.
condone ಆಗಿದೆ, ಲಿಸ್ಟ್ ಮಾಡಿಸಿದೀವಿ, admission ಗೆ 4/7 ನೋಡೋಣ.
26th it is coming up, my lord.
ಏನಕ್ಕೆ?
26th FDP commissioner has also filed his report, my lord.
ಇದುವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ 23 ಇಂದ ನೀವು?
It's a concurrent finding, my lord.
Appeal was filed in 23. Why you kept quiet?
My lord, the
ನಾನು
notice
ಯಾವ
was,
ಕೇಸಲ್ಲೂ ಸ್ಟೇ ಕೊಡೋದಿಲ್ಲ ವಿತೌಟ್ ರೀಡಿಂಗ್ ದಿ ಪೇಪರ್ಸ್. ಅಡ್ಮಿಷನ್ ಬಂದ್ರೆ ಮಾತ್ರ ನೋಡ್ಕೊಂಡು ಬಂದಿರ್ತೀನಿ ನಾನು, ಆಮೇಲೆ ಕೊಡ್ತೀನಿ ಸ್ಟೇ. ಆಯ್ತಾ?
I may be given only 2 minutes time, my lord. I will
2 weeks
demonstrate.
ಕೊಟ್ಟಿರೋದು, 4/7 ಕೊಟ್ಟಿದ್ದೀನಿ.
Now, my lord, 2 minutes time, my lord, not 2 weeks.
2 minutes ನಾನು ಓದ್ಬೇಕಲ್ಲ ಪೇಪರ್ಸ್. ನೋಡಿದೀರಾ? 70ರಿಂದ ಅಡ್ಮಿಷನ್ಸ್ 90 ಇದಾವೆ.
I'll point out only one point,
ಮ್ಯಾಟರ್ಸ್
my lord.
ಅಡ್ಮಿಷನ್ಸ್ ಗಿದೆ, ನಾನು ಓದ್ಕೊ ಬಂದಿದ್ದೀನಿ.
I'll point only one. I'll point out only one.
You kept quiet for a period of 1.5 years. Now you cannot insist for the court to grant an order. That's all. ಮಾರ್ಕ್ ಮಲ್ಕೊಬಿಡೋದು, ಈಗ ಬಂದು ಇನ್ಸಿಸ್ಟ್ ಮಾಡೋದು ಕೋರ್ಟ್ಗೆ. ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. ಲಾಸ್ಟ್ ಟೈಮು ಪ್ರೆಸ್ ಟೈಮು, ಈ ಸರಿ ಇಲ್ವೇ ಇಲ್ಲ. Learned counsel for the appellant seeks time. Appellant counsel seeks time to place the document before the court. ನಮ್ಮ ಮುಂದೆನೆ ಟೈಮ್ ತಗೊಂಡಿದಾರಲ್ಲ ಯಾವಾಗಲೂ 29/3/23 Third, the appellant counsel is absent. And in the previous occasion on 19/4/23, appellant has sought time. ಇವತ್ತೆಲ್ಲ ಅಡ್ಮಿಷನ್ ಬಂದಿರೋವೆಲ್ಲ ಕಳೆದ ವರ್ಷ ಮಾರ್ಚ್ ಏಪ್ರಿಲ್ ಅಲ್ಲಿ ಅರ್ಜನ್ ಆದವು ಒಂದು ವರ್ಷದ ಮೇಲೆ. And also council sought time on 29/3/23 also to place the documents before the court. And appellant counsel is not pursuing the matter diligently. And this is the appeal of the year 2018. On cost of rupees 2,000, one more opportunity is given if appellant counsel doesn't appear. In the next date of hearing, appeal will be dismissed for non-prosecution. List this matter on 4/7. ನಾವು ಬರೀ ಓದ್ಕೊ ಬರೋದು, ಇವರೆಲ್ಲ ಬರಂಗಿಲ್ಲ ಕೋರ್ಟ್ಗೆ. ನೆಕ್ಸ್ಟ್ ಇದು ಕೂಡ ಏನೋ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅಂತ ಇದೆ ನೋಡಿ, SA ಮೊಹಮ್ಮದ್ ರಫಿ. ಎಸ್ ಮೇಡಮ್.
ನಾವು ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೊ ಹಾಕ್ತಿದ್ದೀವಿ.
ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೊ ಹಾಕಿದ್ದೀರಾ? ಯಾವಾಗ? ಹಾಕೋದಿಲ್ಲ, ಇವತ್ತು ಇಟ್ಟಿರೋದೇ ಡಿಸ್ಮಿಸಲ್ಗೆ. ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪಲೆಂಟ್ ಇಸ್ ಆಬ್ಸೆಂಟ್. ಅಪೀಲ್ ವಾಸ್ ತೊಗೊಳ್ಳಿ. This appeal was filed in the year 2018. And in the previous council, previous date, first time ಬಂದಂಗಿದೆ ಅಲ್ಲ ಅವಾಗ ಯಾವಾಗಲೂ. So notice to the respondent both main appeal. Third. This matter, this appeal was filed in 2018 and counsel was absent on 21/4/23. The same is noted in the order sheet and this court made it clear that if appellant counsel doesn't appear on the next date of hearing, the appeal will be dismissed for non-prosecution. Notice ಕೊಟ್ಟಿದ್ದೀರಾ? ಇಲ್ಲಿದೆ ದಾಖಲೆ ಕೊಡಿ.
ಇಲ್ಲ.
ಇವತ್ತವರೆಗೆ ಏನಾರು ಮಾಡಿದಿರೇನ್ರಿ?
ಇಲ್ಲ, ಅವ್ರಿಗೆ
6 ವರ್ಷದಿಂದ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಹೋಗ್ಲಿ ಅಪಲೆಂಟ್ ಗೆ?
ಅವ್ರಿಗೆ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡ್ತಾ ಇದೀವಿ.
ಕಾಂಟ್ಯಾಕ್ಟ್ ಬಿಟ್ಬಿಡಿ, ನೀವೇನು ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೊ ಹಾಕ್ಬೇಕಾದ್ರೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿರ್ಬೇಕು. ಎಲ್ಲಿದೆ ನೋಟಿಸ್?
ನೆಕ್ಸ್ಟ್ ಮಾಡ್ತೀವಿ.
ನೆಕ್ಸ್ಟ್ ಮಾಡ್ಬೇಕು. ಇವತ್ತು ಇದುವರೆಗೆ ಏನ್ ಮಾಡಿಲ್ಲ, ಡಿಸ್ಮಿಸಲ್ಗೆ ಇಟ್ರು. ತೊಗೊಳ್ಳಿ, ಏನಾಯ್ತು ಮೇಡಮ್? And counsel for the appellant today appeared before the court and make submission that going to retire from the case. Until that not issued any notice also, even in spite of matter is listed for dismissal for non-prosecution. And on cost of rupees 1,000, another 3 weeks time granted either to address the argument for admission or retire from the case. List this matter on 3 RFs kodi. 11/7. Yes.
Last time your lordship
Letter dated report issued not settled ಅಂತ ಬಂದಿದೆ. ಹೇಳಿ.
ನಾಟ್ ಸೆಟಲ್ಡ್ ಅಂದ್ರೆ ಇದರಲ್ಲಿ
lordship ಅದೇ ಒಂದೇ ಒಂದು ಐಟಮ್ಗೆ item so far as item number 1 is concerned, my lords, we have tried to settle the matter. ಅದರಲ್ಲಿ there is a lot.
2 ಎಕರೆ 6 ಗುಂಟೆ ಇದೆ, ಅದ್ರಲ್ಲಿ ನಾವು 1 ಎಕರೆ 6 ಗುಂಟೆ ನೀವೇ ಇಟ್ಕೊಳ್ಳಿ, 1 ಎಕರೆ ನಮ್ಗೆ ಬಿಟ್ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ವಿ.
ಅವ್ರ ಅದಕ್ಕೆ ಹೋಗ್ತಾ ಇಲ್ವಾ?
ಅದಕ್ಕೆ
My lords, ಇದರಲ್ಲಿ
ರಿಮೈನಿಂಗ್ ಐಟಮ್ಸ್ ಅವ್ರವ್ರ ಪೊಸಿಷನ್ ಅವರು
remaining so far as remaining properties are concerned, my lords, there is no much dispute.
2 ಎಕರೆ ಚಿಲ್ಡ್ರನ್ ಅಲ್ಲಿ ಈಗೇನು ಅವ್ರ ಅರ್ಧ
2 ಎಕರೆ 6 ಗುಂಟೆಯಲ್ಲಿ 1 ಎಕರೆ 6 ಗುಂಟೆ ಅವರೇ
ಅಂದ್ರೆ ಒಂದು 43 ಗುಂಟೆ 43 ಬರುತ್ತೆ. 3 ಗುಂಟೆ ನೀವೇ ಇಟ್ಕೊಳ್ಳಿ, 40 ಆದ್ರೂ ಬಿಡಿ ಅಂತ ಅವ್ರು ಹೇಳೋದು.
ಹಾಗಲ್ಲ, ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು
ಅಷ್ಟೇ
2 ಎಕರೆ 6 ಗುಂಟೆನಲ್ಲಿ 1 ಎಕರೆ 6 ಗುಂಟೆ ನೀವೇ ಇಟ್ಕೊಳ್ಳಿ, ನಮ್ಗೆ 1 ಎಕರೆ
ಬಿಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ನಮ್ಮವ್ರ my lords ನೆಗೋಸಿಯೇಷನ್ಸ್ ಆಯ್ತು, ಎಲ್ಲ ಆಯ್ತು. ಅವ್ರು 40 ಗುಂಟೆಗೆ ಬಂದ್ರು, ನಮ್ಮವ್ರು 15 ಗುಂಟೆ ಅವ್ರಿಗೆ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು.
15 ಗುಂಟೆನ
15 they are in possession of the property since 1998.
ಆಯ್ತು, 2 ಎಕರೆ 6 ಗುಂಟೆನಲ್ಲಿ ಬರೀ 15 ಗುಂಟೆ ಕೊಡ್ತೀವಿ ಅಂದ್ರೆ ಹೆಂಗಾಗ್ತದೆ?
ಅಲ್ಲ, even my lords, if they get even if it is to be distributed 1/4 share ಆದ್ರೂ ಕೂಡ ಅವ್ರು 20
ಈಗ ಒಂದೇ ಐಟಮ್ ಮಾತ್ರ ಡಿಸ್ಪ್ಯೂಟ್ ಇರುತ್ತೆ.
ಒಂದೇ ಐಟಮ್
much dispute
ಯಾವ್ದಕ್ಕೂ ಇಲ್ಲ.
ಬೇರೆದಕ್ಕೆಲ್ಲ my lords nobody.
ಅನದರ್ 1 ವಾರ ಕೊಡ್ತೀನಿ, ಪರ್ಸು ಮಾಡಿ, ಆಗುತ್ತಾ? ಅಥವಾ ಅಡ್ಮಿಷನ್ ಹೇಳ್ತೀರಾ? ಹೇಳಿ.
ಅಲ್ಲ, ಅಡ್ಮಿಷನ್ your lordship has heard and it was about to be admitted. ಆ ಟೈಮ್ ಅಲ್ಲಿ ಇದು ಮೀಡಿಯೇಷನ್
ಆಯ್ತ್ರಿ, ಈಗಲೇ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿ. ಅಟ್ಲೀಸ್ಟ್ ಮೀಡಿಯೇಷನ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೋಡೋಣ. ನೀವು ಮಾಡಿ, ನೀವಿಬ್ರು ಮಾತನಾಡಿ ಪಾರ್ಟಿ ಹತ್ರ.
ನಾನೇ ಹೇಳಿದೆ ಸರ್, ಲಾಸ್ಟ್ ಟೈಮ್ ನಮ್ ಪಾರ್ಟಿ ಹೇಳಿದ್ರೆ ನಾನೇ 3 ಗುಂಟೆ ಕಡಿಮೆನ ಕೊಡಿ, ಹೆಚ್ಚು ಕಡಿಮೆ ಮಾತಾಡ್ತೀನಿ ಅಂತ ಅವ್ರು ನಾನೇ ಒಪ್ಪಿಸಿದೆ.
10
ಅವ್ರು 8 ಗುಂಟೆ 15 ಗುಂಟೆ 12 ಗುಂಟೆ
15 ಗುಂಟೆ I can persuade my client my lords to up to 20 ಗುಂಟಾಸ್ more than ಆದ್ರೆ ನಮ್ಮನ್ನ lords Or if your lordships were to
ಅಲ್ಲ,
direct,
20
I'll
ಗುಂಟೆ
keep the parties
ನಾವ್
present.
ಹೇಳೋದಕ್ಕೂ ಇದಾಗುತ್ತೆ, ಯಾಕಂದ್ರೆ ನಮ್ಮವರು ಏಜ್ ಆಗಿದ್ದಾರೆ, 6 ಜನ ಇದ್ದಾರೆ. ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡ್ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ, ಅವ್ರ ಮಕ್ಳು 6 ಜನ ಇದ್ದಾರೆ. ಅವ್ರು ನಾವು 20 ಗುಂಟೆ ಅಂತ ಹೇಳೋದು ಕಷ್ಟ ಆಗುತ್ತೆ.
ಅಲ್ಲ,
ಅವ್ರಿಗೆ
even-
ನಾನು ಫೈನಲ್ ಆಗಿ 40 ಅಂದ್ರೆ ಒಪ್ಕೊಂಡ್ರು, ಅವ್ರು ಏನು ಮಾತಾಡ್ಲಿಲ್ಲ.
ಒಪ್ಕೊಂಡ್ರು ಅಂದ್ರೆ
ಅಲ್ಲ ಅದ್ರ ಮೇಲೆ ಅವರು 50-50 ಅರ್ಧ ಭಾಗ ಅಂತಿದ್ರು. ಇಲ್ಲ ಒಂದ್ ಸ್ವಲ್ಪ ನೀವೇ ಕಡಿಮೆ ಮಾಡಿ
ಒಪ್ಕೊಂಡ್ರೆ ಸೆಟ್ಲ್ ಆಗಿರೋದು.
ಸೆಟ್ಲ್ ಆಗುತ್ತೆ sir.
ಆಯ್ತು, ನೀವೊಂದ್ 10 ಗುಂಟೆ ಕೊಡಿ, ಅವ್ರೊಂದ್ 15 ಗುಂಟೆ ಬಿಡ್ಲಿ
ಅಂದ್ರೆ
ಮಾಡಿ. ಈಗ 15
ಅಲ್ಲ,
ನೀವು
ಅಲ್ಲ,
25 ಗುಂಟೆ ಮಾಡಿ, ಅವರು 40 ಗುಂಟೆ
35
40 ಗುಂಟೆ ಕೇಳ್ತಿರೋದನ್ನ ಅವ್ರು 25ಕ್ಕೆ ಬರ್ಲಿ.
I will talk to.
ಅಲ್ಲ 25 ಬೇಡ,
25 ಕೊಡ್ತಾರ್ರಿ.
30 ಗುಂಟೆಗೆ ಆದ್ರೆ ಒಂದೆಷ್ಟು ಕಡೆ ಮಾತಾಡ್ತಾರೆ. ಅಲ್ಲ ನಾಳೆ ಓಟ್ ಡಿಸಿಷನ್ ತಗೊಂಡ್ರೆ ಚೆನ್ನಾಗಿ.
Before this, ಅಲ್ಲ ಇನ್ 4-5 ಪ್ರಾಪರ್ಟಿಗಳು they were already sold
ಬೇರೆ
properties.
ಪ್ರಾಪರ್ಟೀಸ್ ಯಾವುದು
ಅದನ್ನ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ನಮ್ಮವರು
ಅದೆಲ್ಲ ಬಿಟ್ಬಿಡಿ. ಈಗ ನೀವು ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋದು only this
ಎಂಟೈರ್ ಕೇಸೇ ಕ್ಲೋಸ್ ಆಗುತ್ತೆ.
ಅದೇ ನಿಜ.
You talk to them also, let them also convince their parties. ನೋಡ್ರಿ,
ಆಯ್ತು ಸರ್, ನಂಗೆ
5 ಗುಂಟೆ ಅಂದ್ರು ನಾನೇ 10 ಗುಂಟೆ ಸೇರ್ಸಿದೀನಿ. 25 ಗುಂಟೆ
ಕರ್ಸಿ ಮಾತಾಡ್ತೀವಿ.
ಮಾತಾಡಿ ಇಬ್ರು. ತಗೊಳ್ಳಿ, both council submits that there is an element of settlement and hence
Also keep the parties present so that ತಾವೇ
ಒಂದ್ ಸ್ವಲ್ಪ ಚಾನ್ಸಸ್.
and hence keep the both the parties present before the court on ಯಾವತ್ತು ಲಿಸ್ಟ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ. 47
ಪ್ಲೀಸ್
47
ಅದ್ರಲ್ಲಿ ನಮ್ಮ ಪಾರ್ಟಿಗೆ is aged. ಅವ್ನ್ ಕರ್ಸಿ
ಪರವಾಗಿ ಯಾರು ಬರ್ತಾರ
ಅವ್ರ ಮೊಮ್ಮಗ ಇದಾನೆ, ಬಟ್ he can also ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಬರ್ತಾರೆ ಸ್ವಾಮಿ ಆಮೇಲೆ, ಬಿಕಾಸ್
ನೇಚರ್ಗೆ ಆಮೇಲೆ ಬರ್ಲಿ, ಫಸ್ಟ್ ಮಾತನಾಡಕ್ಕೆ. ಹಾ, ಎಷ್ಟು ನಿಮ್ ಪಾರ್ಟಿಗೆ ಏಜು?
ಅವ್ರಿಗೆ
ಆಮೇಲೆ ಬಂದ್ಬಿಟ್ಟು ಇಲ್ಲ ನಾನು
ಇಲ್ಲ ಸರ್, ಇಲ್ಲಿ ಗೆಟ್ ಇನ್ ಮೆಲಾಡ್ಸ್ ಇದು ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಸೈನ್
ಕರ್ಸ್ಬಿಡಿ ಪಾರ್ಟೀಸ್ ನ.
ಕರೆಸ್ತೀನಿ.
ಅವತ್ತೇ ಸೆಟ್ಲ್ ಆಗ್ಬೇಕಾರೆ ಅವತ್ತೇ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡೋಣ, ಮಧ್ಯಾಹ್ನ ಹಾಕಿ ಮೆಮೋ ಹಾಕಿ ಕ್ಲೋಸ್ ಮಾಡಿ ಕಳ್ಸೋಣ. ದೇ ನೀಡ್ ನಾಟ್ ಕಮ್ ಒನ್ಸ್ ಅಗೇನ್. ಆಯ್ತಾ? ಚಂದ್ರನಾಥ್ ಅರಿಗ ಕೊಡಿ. At the request of the council for the appellant, list this matter after summer vacation. ಯಾವಾಗ ಆಗಿರೋದು? 23 summer vacation. So the appellant council is absent. And matter was adjourned at the request of the appellant council on 10/4/23. And today council is absent. And this is the appeal of the year 2018. And appellant council is not pursuing the matter diligently. However, in the ends of justice and cost of rupees, ಹಿಂದಿಂದ ಎಷ್ಟು ಹಾಕಿದ್ವಿ ಕಾಸ್ಟ್? ಅದು 1,000 2,000 ಇರ್ಲಿಲ್ಲ ಅಂತ ಯಾವ್ದು 2,000 ಹಾಕಿದ್ವೋ 1,000 ಹಾಕಿದ್ವೋ ನೋಡಿ. ಅವ್ರೇನೋ ಲೆಟರ್ ಬರಿತೀವಿ ಅಂತಂದ್ರು, ಅದಲ್ಲಲ್ಲ ಇನ್ನೊಂದು 2,000 2,000. Adjourned on cost of rupees 2,000. List this matter on 4/7. Hand over the possession within 3 months.
Amended cost rate. Amended cost rate.
ಆಯ್ತು ಹಾಕಿ ಅಡ್ಮಿಷನ್ ಹೇಳಿ. ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿಲ್ವಾ? ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ದಲ್ಲ ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ರೇಟ್ ಹೆಂಗ್ರಿ ಹಾಕ್ತೀರಿ ನೀವು?
ಮಾಡ್ಬಿಡ್ತೀನಿ ಸರ್.
ಯಾರು ಮಾಡಿಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಯಾರು ವಕಾಲತ್ ಹಾಕಿದಾರ?
ವಕಾಲತ್ ಅಂಡರ್ಟೇಕ್ ಟು ಫೈಲ್ ವಕಾಲತ್ ಅಂದ್ರೆ ವಕಾಲತ್
ಹಾಕಿದಾರಲ್ಲ. ಇವೆಲ್ಲ ಅಮೆಂಡೆ ಮಾಡಿಲ್ಲ ಏನು?
ಮಾಡ್ತೀನಿ ಸರ್.
ಕಾಸ್ಟ್ ರೇಟ್ ಹಂಗೆ ಇದೆ. ಹೇಳಿ ಏನು ಹೋಗ್ಲಿ ಹೇಳಿ.
ಈಗಲೇ ಮಾಡ್ತೀನಿ ಸರ್. But in this case, Brad. Earlier, Brad, I have filed suit for declaration and injunction. Well, actually, kindly turn to my paper book which I have filed along with him.
Paper book?
For reference, Brad, I have filed.
Separate ಏನಾದ್ರು ಕೊಟ್ಟಿದಾರೇನ್ರಿ ಪೇಪರ್?
Separate ಕೊಟ್ಟಿದ್ದೇನೆ. Put up ಮಾಡಕ್ಕೆ ಹೇಳಿತ್ತು. ನೆನ್ನೆ ಫೈಲ್ ಮಾಡಿ ಆಫೀಸಲ್ಲಿ ಡೇಟ್ ಇದೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ನೆನ್ನೆ ಮಾಡಿದ್ದೀನಿ.
ನಮ್ಗೊಂದು ಕಾಪಿ
ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ ಹೋಗ್ಲಿ.
ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಎರಡೆರಡು ಮಾಡಿಸ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ನೀವು ಡಿಫೆಂಡೆಂಟ್ ಇಲ್ಲಿ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ ನೀವೀಗ?
ಹೌದೌದು.
RSA ನಲ್ಲಿ?
RSA ನಲ್ಲಿ.
ಆಯ್ತು.
Earlier, suit was filed by the defendant here in Malad, OS 326.
OS
326
of
93.
93.
Yes, madam.
Suit for what?
Suit for injunction, madam.
Injunction?
Yes, madam.
Where injunction?
Declaration and
Declaration and injunction, my lord.
ಆಯ್ತು.
The
Declaration
said
by
suit
adverse-
came to be decreed party.
Declaration and injunction.
Yes, ma'am.
The said suit, adverse position ಮೇಲೆ ನಾನು suit for plaintiff is partly decreed. The suit of the plaintiff is decreed for the relief of permanent injunction, restraining the defendants from interfering with the plaintiff peaceful possession and enjoyment of the scheduled property. My lord, it is decreed on 1/4/2005, my lord.
1/4/2005.
5, wherein the present appellants are plaintiff
Ah.
and respondent Nagaraja is the respondent number 1, defendant number 1, my lord. Against which, my lord, both of them preferred appeal before the appellate court, my lord. In RA, in RA 198 of 2007 and 244 of 2008. They said appeal, my lord, which came to be allowed by setting aside the judgment decree made in favor of the appellants here in Mala. I may permit it to read.
ಅಲ್ಲಿಗೆ permanent
Judgment
injunction,
decree passed by that.
permanent injunction granted was set aside.
Set aside and the judgment decree.
And
passed by
your appeal filed
claim
by
of
you
the
was
plaintiff for
dismissed.
declaration for adverse position was dismissed and confirmed accordingly. The title of the plaintiff suit is dismissed in entirety. Accordingly, RA 244 by 2008, IA 1 filed under Article 41 Rule 27 both dismissed. And RA 198 is hereby allowed with cost. ಅದು 198 ಹಾಕಿದ್ದು ಅವ್ರದ್ದು.
ಆಯ್ತು.
ನಮ್ದು 244.
ಆಯ್ತು, ನಿಮ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
Against which, my lord, both of them preferred RSA before the Sam court, my lord.
RSA.
RSA. RSA ನಲ್ಲಿ
RSA ನಂಬರ್ ಹೇಳಿ.
RSA 436 of 2011 filed by the appellants here in Mala. RSA 437 filed by the respondent number 1. ಅದು ನಂದು ಸೂಟು ಅಲೋ ಆಯ್ತು.
ಅವ್ರ ಯಾಕೆ ಹಾಕಿದ್ರು RSA ನ? ಅವ್ರಿಗೆ ಆರ್ಡರ್ ಫೇವರ್ ಆಗಿದೆಯಲ್ಲ. ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್ ಗ್ರಾಂಟ್ ಆಗಿದ್ ಸೆಟ್ ಅಸೈಡ್ ಆಯ್ತಲ್ವಾ
ಅವರ
ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಅವ್ರದ್ದು ಆರ್ಡರ್ 41 ಡಿಕ್ಲರೇಷನ್ ಇದ್ ಮಾಡಿರ್ಲಿಲ್ಲ. ಡಿಕ್ಲರೇಷನ್ ಅವ್ರದ್ದು.
ಬಟ್ ನೀವು ತಾನೇ ಕೇಳಿದ್ದು ಡಿಕ್ಲರೇಷನ್.
ಅವರು ನಾವು ಓನರ್ ಅಂತ ಬಂದಿದ್ರು ಅವರು.
ಇಲ್ಲ ನಾವು ಕೇಳಿಲ್ಲ.
ನೀವು OS 326 ಫೈಲ್ ಮಾಡಿದ್ ನೀವಲ್ಲೇನ್ರಿ?
ಹೌದು, ನಾವು ಮಾಡಿದ್ವಿ.
ಅದ್ರಲ್ಲಿ 93 you have sought for the relief of declaration and injunction. Declaration not
that I am perfected my title by of adverse position and for injunction.
ಯಾರು?
ನಾವು ನಮ್ದು ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ ಇದ್ ಪಾರ್ಟ್ಲಿ ಡಿಕ್ರೀ ಮಾಡಿ ನಾ ಎಂ ಸ್ವಾಧೀನದಾಗಿದ್ದೀನಿ.
ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್ ಗ್ರಾಂಟ್ ಆಯ್ತು.
ಹೌದು,
ಹೌದಲ್ಲ?
ಬಟ್ ಇನ್ ಸೋ ಫಾರ್ ಆಸ್ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ ಡಿನೇ
ಆಯ್ತು. ಅದ್ರ ಮೇಲೆ ನೀವು ಅಪೀಲ್ ಬಂದ್ರಿ. ಆ ಅಪೀಲು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
ಅವ್ರ ಅಲ ಆಯ್ತು, ನಮ್ದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಇಂಜಂಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕು.
ಆಯ್ತು,
ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕುದು. ಅಪೀಲ್ ಅಲ್ಲಿ ನಮ್ದು ಅಲೋ ಮಾಡಿ.
ಯಾಕೆ ಅಪೀಲ್ ಹಾಕಿದ್ರು ಅಂತ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಅವ್ರ ಅಪೀಲ್ ಬರಲ್ಲ. RSA ನಿಮ್ದೇ ಮಾತ್ರ ಬರ್ಬೇಕು.
ಅವ್ರದೇ ಬಂದಿರೋದು. 2 ಅಪೀಲ್ ಅವ್ರೇ ಹಾಕಿರೋದು.
2 ಅವ್ರೇ ಹಾಕಿರೋದು.
2 ಅವ್ರೇ ಹಾಕಿರೋದು. ಒಂದು ವೇರ್ ಇನ್ ದಟ್ ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್ ವಾಸ್
dated 1/7/2011 made in RA 198 of 2007.
ಕನ್ಫರ್ಮ್ ಆಯ್ತು ಅಲ್ಲಿಗೆ.
244 of 2008 passed by the first additional district judge Tumkur and the judgment decree dated 1/4/2000 in OS 326 of passed by the insofar as related to adverse position.
ಅದೇನಾಯ್ತು? ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ ಏನಾಯ್ತು?
ಅದು ಅಲೋ ಆಯ್ತು.
ಅಲೋ RSA ಅಲೋ ಆಯ್ತಾ?
ಹೌದೌದು. RSA 436
ಅಲೋ ಆಗಿಲ್ಲ, ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿರ್ಬೇಕು ನೋಡಿ.
The appeal in RSA 436/2011 is allowed.
ಅಲೋಡ್ ಆಮೇಲೆ ಏನಾಯ್ತು?
Allowed the common judgment decree passed in so far as RA 198 of 2007 in relation to dismissal of suit is hereby set aside.
ಆಯ್ತು.
Set aside ಮಾಡಿ the judgment decree in trial OS 326/93 is restored on its file. Reserve liberty to the defendant number 1 to initiate proceedings against the plaintiff for recovery of possession.
ಲಿಬರ್ಟಿ ಕೊಟ್ರು ಅವರಿಗೆ.
ಅವರಿಗೆ ಲಿಬರ್ಟಿ ಕೊಟ್ಟು.
ಆಯ್ತು.
On that basis, now the suit has been filed for recovery of possession. Now the point for consideration, whether such liberty cures the defect of limitation. My lord, your lordship, earlier to that, my lord, they have filed suit for declaration and injunction that has been dismissed as unconditional.
ಅವರೊಂದು ಡಿಕ್ಲರೇಷನ್
Our attended.
ಅದೇ ಯಾವ್ದು OS
ಅದು OS 70 of 2002. OS 70 of 2002 filed before the civil judge, senior division and CJM Tumkur.
ಡಿಕ್ಲರೇಷನ್
For the relief of decree and permanent injunction. Declaration of title to the suit scheduled property and for permanent injunction restraining the defense from interfering with the peaceful possession and enjoyment of the scheduled properties. ಅದು the respondent hearing, my lord, KBS files memo dismiss the suit as not pressed. In view of the memo, suit is dismissed as not pressed.
ಆಯ್ತು ನಾಟ್ ಪ್ರೆಸ್ ಮಾಡ್ಕೊಂಡ್ರು
Not press ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು. Now, my lord, they have filed suit for recovery of possession. The possession, that suit came to be decreed. The my country
RSA 436 of 2011 ಅಲೋ ಆಯ್ತು
restorative file ಅಂದ್ರೆ ಅದು ಮುಂದಕ್ಕೆ ಮುಂದುವರಿಲಿಲ್ಲ.
ಯಾವತ್ತು ಡೇಟ್ ಯಾವಾಗ ಅಂತ ಕೇಳಿದ್ರು.
ಅದು ಡೇಟ್ ಈಸ್ ದಟ್ RSA 2011.
On the very same year,
2011.
on the very same year, they have filed the suit for recovery of possession.
ಅದನ್ನ whether limitation, whether granting liberty cures the limitation.
ಅಷ್ಟೇ. So now subject.
ಅದು my country, your lordship grant unto the appeal memo, the OS ಅಲ್ಲಿ date of cause of action. The cause of action for this suit arose when he has purchased the property from 57, when the stipend 124 filed the suit, and subsequently when the Honorable High Court of Karnataka passes the judgment within. So whether when he says the cause of action is on the date when he purchases the property is on the 93. So therefore, my lord, section 64, article 64 ಕೆಳಗಡೆ limitation runs 12 years from the date of disposition. When he has disposed, that is not forthcoming in the plaint. Whether restoring liberty when will cure the is it is a matter of question of law arises for consideration. Whether granting liberty cures the limitation. According to me, my lord, 12 years from the date of knowledge, from the date when he disposes. In nowhere in the plaint he states when he has disposed. Averment in the plaint, only the averments 326 suit ಹಾಕಿದ್ವಿ, RA ಹಾಕಿದ್ರು, RS ಹಾಕಿದ್ರು, liberty ಕೊಟ್ರು. Therefore, I have filed the suit for recovery. Therefore, my lord, unless there is a pleading, when he has disposed, the suit is, the limitation starts from the date when he says, specifically states, from the date of purchase, when he has purchased the property from 50%. Well, I may permit it to pass on that. Plaint. Yes. ಅಲ್ಲ ಅದೇ ನೆಕ್ಸ್ಟ್ ಬರ್ತೈತೆ ಅದೇ ಆ ಪೇಜ್ ಓಪನ್ ಮಾಡ್ಕೊಂಡು ಪ್ಲೈಂಟ್ ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ.
ತರ್ಸ್ಕೊಳ್ಳಿ ಮೇಡಮ್, ಅದೇನು ಆಫೀಸಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದಾರಲ್ಲ ಅದನ್ನ ತರ್ಸ್ಕೊಳ್ಳಿ.
ಇದು ನಿಮ್ದು ಕೊಡಿ. ಇನ್ನೊಂದಿದೆ ಪೇಪರ್ ಬುಕ್, ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 5 ಮೇಲೆ, ಪೇಜ್ ನಂಬರ್ 5 ಅದ್ರಲ್ಲಿ ಈಗ ಪೇಪರ್ ಬುಕ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದ್ರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 5. ದಿ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಫಾರ್ ದಿಸ್ ಸೂಟ್ ಅರೋಸ್ when he has purchased the property from 50% and when the defendant 124 filed the suit, and subsequently even when they filed the defendant filed the suit under 93. 93 ತಗೊಂಡ್ರು 2003 ನಲ್ಲಿ ಹಾಕ್ಬೇಕಾಯ್ತು. ಆ 2002 ನಲ್ಲಿ ಒಂದು ಸೂಟ್ ಫಾರ್ ಡಿಕ್ಲರೇಷನ್ ಇಂಜಂಕ್ಷನ್ ಹಾಕೊಂಡು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದೆ. ವೆದರ್ ಗ್ರಾಂಟಿಂಗ್ ಲಿಬರ್ಟಿ cures the defect limitation, that is the question of law, has to be decided by the sum. Therefore, my lord, both the courts are heard in coming to the conclusion the suit is within time in view of the observation made by the sum. Therefore, my lord.
Yes, what is the finding of trial court?
Trial court, my lord, at your lordship, with regard to that, my lord, OSLA, para 19 of the judgment, issue number 4, page number 37. It is one of the defense of the dependent number 1 to 4 that the suit is barred by time. The arguments of the learned counsel for the defendant is that the sale deed is dated 11/2/93 and after lapse of 18 years, the plaintiff has filed the suit for recovery of possession. Therefore, the suit is barred by time. Under Article 64 of the Limitation Act, under Article 64 of the Limitation Act for possession of immovable property based on previous possession and not on title, when the plaintiff, while in possession of the suitable property, has been dispossessed, the period of limitation is 12 years, and the time from which the period belongs to run is from the date of disposition. In the present case on hand, the plaintiff herein has already filed a suit OS 70 of 2002 for recovery of possession of the suitable property, which has been withdrawn by the plaintiff during the pendency of the previous proceedings. The pleadings of the plaintiff and oral evidence PW1 is that the cause of action arose to the plaintiff to file the suit is when the plaintiff has purchased suitable property from the defendant, and when the defendant number 1 to 4 have filed the suit, and subsequently when the Honorable High Court of Karnataka passed the judgment, admittedly the Honorable has reserved liberty to the plaintiff initiate proceedings against the plaintiff for recovery of possession of the present suit. The observation of the Honorable High Court of in para 10 of the judgment that withdrawal of OS is not legal impediment for the plaintiff to initiate proceedings for recovery of the plaintiff proceedings from the defendant number 1 to 4. The present suit has been filed by the plaintiff within the period of limitation from the date of such liberty is reserved to the High Court. Honorable, under the the suit is filed is not barred by. So this observation is content. Therefore, my lord, here the court has
Here there is an observation by the trial court while answering issue number 4 with regard to the limitation is concerned.
limitation at the High Court liberty ಕೊಡ್ತಂತೆ. Whether that liberty cures the limitation ಅಂತ.
High Court order observation ಇದೆಯಾ?
ಇಲ್ಲ.
The observation of the Honorable High
Observation
Court of
ಏನು?
Karnataka
Liberty is reserved to the respondent to initiate appropriate
ಅದೇ ಸ್ವಲ್ಪ
proceedings.
ಕೇಳೋವರೆಗಾರು ಬಿಡ್ರಿ
Please,
ನೀವು.
please, ma'am.
ಇಲ್ಲಿ there is an observation in the order. The
ಹೌದು.
observation of the Honorable High Court of Karnataka
ಹೌದು.
in para 10 of its judgment that the withdrawal of OS number 70 of 2002 is not a legal impediment for the plaintiff herein to initiate fresh proceedings for recovery of the plain scheduled properties from the defendant number 1 to 4 herein anti the observation. No, this is an observation made by this court. Now you cannot urge that ground. This is the reasoning given by the trial court.
Para 10, ma'am.
Ink page number 78 ಹೋಗಿ ನಿಮ್ದೆ ಈಗೇನ ಪೇಪರ್ ಬುಕ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ. Now again you cannot argue against that observation made by the High Court.
1 minute.
The present suit has been filed by the plaintiff within the period of
Correct.
limitation from the date of such liberty
Correct.
reserved by
Since
the
both
Honorable
the
High Court of
courts
Karnataka.
have held that the defendant number 1 to 4 of the property, plaintiffs have failed to establish their title of law of adverse possession, then they cannot resist the suit for recovery of possession of the plain scheduled property. But unfortunately, this suit.
Last observation ಹೋಗಿ counsel.
ಅದೇ
ನಾಲ್ಕು ಲೈನ್ ಓದ್ರಿ.
ಹಾ.
ಅದರಲ್ಲೇ ನಿಮ್ page number 77
for defendant to initiate proceedings for recovery of the plain scheduled property. In such an event, court which is defendant number would file suit to decide the same in accordance with law within the time frame from 1 year. Whether such liberty cures the limitation. Even assuming.
ಈ observation ಇದೆಯೇನ್ರಿ ಆರ್ಡರ್ ನಲ್ಲಿ?
Observation ಇದ್ರೂ
ಆಯ್ತು.
he has to state when I have dispossessed it from the property. Even
Sir.
if that observation is there, he has to mention the date when he has dispossessed, whether during the pendency of OS 70 of 2002 or in the pendency of the OS 326 up to 93. Nothing is forthcoming.
Yes.
I have produced the plain copy, my lord. Therefore, my lord, both the courts are held in dismissing allowing the suit of the respondent. Confirmed by the appellate court.
Yes, that's all.
That's all.
Yes, counsel ಹೇಳಿ.
Rely on the judgment reported in AR 2000 Supreme Court.
AR 2000?
Supreme Court 1099. I may permit it.
AR ಯಾವ year?
AR 2000.
2000?
SC 1099.
1099. Kodi.
Case of Sachin Ahmad versus YK Sabarwal.
ಒಂದು ಕಾಪಿ ಕೊಡ್ರಿ.
ಕೊಡ್ತೀನಿ.
Paragraph.
Paragraph melod. Para 1. A Limitation Act, Article 65. Possession has taken under void document suit for recovery for discipline can be filed. Therefore, there is no need to seek about the invalidity of the, even if the declaration is sought along with the recovery suit would be governed by Article 65 and not under. When possession has been taken by the appellants pursuant to the void, ignoring the suit for possession could be filed in that course of suit. It could be contained that these documents are.
ಯಾವ ಪ್ಯಾರಾ ಓದ್ತಾ ಇದ್ರಿ ನೀವು? ಪ್ಯಾರಾ ಒಂದಲ್ಲ ಅದಿಲ್ಲ.
Yeah.
Head note.
Head note. Apply and limitation to file suit would be 12 years, even if relief of declaration that the documents are nullity is sought along with the possession, that would be inconsequential. So within 12 years, specific relief act 47, section 6, suit for recovery of equitable consider urban property within the ceiling possession taken by the state by denying the owner permission for transfer of urban under section 27 of the urban landing and by exercise option for order denying permission, consequential purchase, state becoming void was declared unconstitutional. Suit by the owner for recovery for relief of possession cannot be denied on the ground that the owner has executed sale and was paid and sale of state was not proper. Owner cannot be said to have been suffered any prejudice loss. So it would be paragraph 6, my lord. This has been discussed. Has already noticed in Bhima Singh's case, Supra, insofar as it imposes restriction on transfer of any urban or so building which is within the ceiling has been held to be. Thus, it has to be not been and cannot be disputed with the order of dated so and so. Was without judicial nullity. Sale deed executed pursuant to the said order would also be null. It was not necessary to speak about the invalidity. The fact that the plaintiff has sought for declaration is optional. When possession has been taken by the appellants pursuant to the document Article 65 limitation will apply and the limitation to file suit would be 12 years. So therefore, my lord, he has to exactly state the on which date the respondent has been dispossessed. See the court finding that I am in possession in the OS 326 of 93, court has held that I am in possession of the property. When that is taken into consideration, he should have been filed the suit within even if it is that 93 suit is taken, 2003 nalla hakbekayitu. So therefore, the observation of this court will not cure the point of limitation. Therefore, you should have been filed the suit within a period of 12 years from the date of knowledge. He has also not stated, there is no pleadings with regard to nor in the evidence, nor in the pleadings. Therefore, my lord, I press some court to.
Where is the order of this court will passed in RSA?
My lord. My lord.
Number. Hundred and 5, my lord, 104. Adalli.
Para 10, my lord.
Para 10.
Para 10, my lord.
Para 10, page number 113. Para 9 indale ಬರ್ತದೆ. OS 70.
Since both the courts below
Both the
held
courts
that
below
defendant number
notice
1
that
is the
defendant
owner
number
of the plain scheduled property.
And permanent injunction.
And
And
plaintiffs
ultimately
have
for-
failed to prove and
ultimately for
establish
recovery
their
of possession
title
anta
to
ಇದೆ.
adverse possession. Then the plaintiffs cannot resist the suit for recovery of possession of plain scheduled property by defendant number 1.
Correct.
But unfortunately, the suit filed by defendant number 1 is OS number 70 is now withdrawn in view of the judgment and decree of the first appellate court. The withdrawal of OS number 70 of 2000 is not a legal impediment for defendant number 1 to initiate press proceedings for recovery of plain scheduled property from the plaintiffs. In such an event, the court in which defendant number 1 would file a suit shall decide the same in accordance with
With
law
law.
within time frame of 1 year from the date of institution of suit. Yes.
In accordance with law, 12 years from the, when the court has observed,
No,
I am in possession, 93 in the possession.
Yes.
my lord, kindly go to the
24,
judgment,
20 years.
my lord. Judgment in OS 326 of 1993, my lord. Lord, if I may, my lord.
Yes.
This is the original suit filed by the other side, my lord, for adverse possession and declaration
I
and
produced the plain copy also.
Earlier suit,
earlier suit, first suit, my lord.
ಅದನ್ನ
My lord,
produce
ಅದರಲ್ಲಿ
ಮಾಡಿದ್ದೀನಿ, paper book ಅಲ್ಲಿ.
ಅಲ್ಲ ಆಯ್ತು ಒಂದ್ ನಿಮಿಷ ಅದ್ರಲ್ಲಿ kindly go to my lord page my lord, there's a issue, my lord, regarding my lord, page 5, my lord, internal page 5, my lord, of the judgment, my lord.
Issues.
Issues ಅಲ್ಲಿ issue 3, my lord. Whether the first defendant, that is me, my lord, proves that he is the absolute owner in possession and enjoyment of suitable property by virtue of sale deed dated 11/2/1993, purchased from second defendant.
This is held affirmative.
Yes, my lord. So,
And the same is also confirmed by the appellate court.
my lord, yes, my lord.
Even High Court also confirmed the same in paragraph number 10 of the judgment.
Yes, my
Ah,
lord.
next.
Once I am held to be the owner, my lord, only my possession was not was in question, my lord. So for that, I filed a suit for possession, my lord. In any case, he will not become the owner of the property, my lord. I am the true owner of the property, my lord.
Yes.
My lord, now once, my lord, even in the, this one it is held partly that I am the owner. Only possession is a question, my lord. In view of the liberty of this honorable court in RSA, my lord, I have filed the suit, my lord, within time, my lord. And my lord, they have rightly held that, both courts have rightly held that I am entitled for possession from him, my lord, who was nothing but a trespasser, my lord, to my property, my lord. As per law, I got possession back from him. Your lordship goes to the RSA para 10 also, my lord, it very clearly says that the suit was withdrawn by me because in the appeal I had succeeded.
Yes.
And my lord, I did not want to, my lord, once I had succeeded, I had got the possession also. I had withdrawn the suit for declaration.
Date of withdrawal yavattu nim suit, earlier suit.
Earlier suit dismissed as withdrawn on 17/2/2011.
17?
Oh, 17/2/2011.
Supreme, ನಮ್ಮ RSC order ಯಾವಾಗ?
RSA order
Subsequently.
subsequently 2011. ಅದು 2011.
ಅದೇ ಯಾವಾಗ ಡೇಟ್?
ಅದು 8/6/2011.
8/6/2011. Yes.
Because it's observed, my lord, that I had withdrawn the suit.
This matter is listed for admission. And I heard the counsel appearing for the appellant as well as the counsel appearing for the respondent. The factual matrix of case of the plaintiff oblique respondent before the trial court in OS number 1509 of 2011, while seeking the relief of recovery of possession from the appellant herein, he has specifically pleaded that the appellants herein have filed the suit in OS number 326 of 1993 for the relief of declaration and for the declaration of title on the suit scheduled property by adverse possession and permanent injunction. After contest, suit was decreed partly for permanent injunction and dismissed for declaration of title. The plaintiff has challenged the said decree in RA number 198 of 2007. And also, the defendants have also filed the appeal before the appellate court in RA number 97 of 2005. Maybe 97 antena ondide. RA 198 of 2007 ಆಯ್ತಲ್ಲ, and also
244 of 208,
248. 2008. The judgment and decree passed in OS number 326 of 93 was set aside. By dismissing the suit for declaration of title was confirmed. And suit was also dismissed in its entirety, even setting aside the judgment of granting of permanent injunction. The same has been challenged by the appellant herein before this court in RSA number 436 of 2011 and 437 of 2011. The said appeal was also dismissed, confirming the judgment and decree passed by the first appellate court. And while disposing of other RSA 436 of 2011, liberty was reserved to the plaintiff herein for recovery possession of the suitable property, and if such proceedings are initiated by the plaintiff herein, the court shall dispose of the matter in accordance with the law within a period of 1 year from the date of institution of the suit. Hence, the plaintiff has filed the suit. It is also the claim of the plaintiff before the trial court that the property belongs to the fifth defendant, and he has sold the suitable property to the plaintiff under registered sale deed dated 11/2/1993. The cause of action also stated for the date of purchase as well as defendant initiating of the suit and also the disposal of the RSA. The defendant in pursuance of the suit summons appeared and filed a written statement taking several contentions in the written statement. That suit for possession without seeking the relief of declaration of title is not maintainable, and the sale deed is also not in accordance with law, and no possession is delivered on the date of sale. Most of the possession was within the further, with the father of the defendant by name Siddhayya Siddhayya. The plaintiff is not having title. Sadhaya. The plaintiff is not having title on the social property. Based on the pleadings, the trial court has framed the issue with regard to whether the plaintiff had purchased the property with sale deed dated 11/2/1993, and whether the fourth defendant proves that without the possession alleged sale deed dated 11/2/23 is not an absolute sale deed, and whether the fourth defendant proves that possession without seeking for relief of title is not maintainable. And parties are allowed to lead evidence before the trial court, and accordingly plaintiff examined himself as PW1 before the trial court and also examined two witnesses as PW2 and 3 and got marked document exhibit B1 to 4. On the other hand, the fourth defendant is examined himself as DW1 and also examined two witnesses as DW2 and 3 and documents exhibit D1 to D31 are marked. The trial court, having considered both oral and documentary evidence available on record, answered the issue number 1 as affirmative, and defense which has been taken by the four defendants are answered as negative, and granted the relief of the recovery of possession to hand over the possession. Being agreed by the said judgment and decree of the trial court and an appeal is filed in RA number 139 of 2013, and first appellate court, having considered the grounds urged in the appeal memo and also the material on record, formulated the point whether the appellant defendants made out sufficient reasons to interfere with judgment and decree passed by the trial court. And having reassessed the material available on record, first appellate court also confirmed the judgment of the trial court and dismissed the appeal with cost of ₹5,000 and confirmed the judgment of the trial court. Being agreed by the concurrent finding of both the courts, the present second appeal is filed before this court. The main contention of the appellant counsel before this court is that giving liberty in RSA, whether the same cures the point of limitation and whether both the courts have committed an error in entertaining the suit, even though suit is barred by limitation. The council also vehemently contend that both the courts have failed to apply law to the admitted facts and circumstances of the case. And also, lower appellate court has not framed proper points for consideration while disposing of the appeal. The council also vehemently contend that both the courts failed to take note of the factual aspects of the case. And suit is also filed for the recovery of possession without seeking any relief of declaration of title and without seeking the relief of declaration of title is not entitled for the relief of possession. And this court has to frame a substantive question of law that without seeking the relief of declaration of title, whether suit is maintained only for the recovery of possession. The council also vehemently contend that the perverse finding is given by both the courts, ignoring the material available on record, and fails to take note of the fact that earlier withdrawal of suit in OS number 70/2002, and the said suit is also filed for this same relief. Without obtaining the permission of the court, the same was withdrawn. And hence, the very suit itself is not maintainable, and both the courts failed to take note of the said fact into consideration. The counsel appearing for the respondent brought to notice of this court the judgment passed by this court in RSA, particularly paragraph number 10, wherein this court has made an observation that since both the courts have held that defendant number 1 is the owner of the plain scheduled property, that is plaintiff, and plaintiffs have failed to prove and establish their title by way of law of adverse possession, then the plaintiffs cannot resist the suit for recovery of possession of the plain scheduled property by defendant number 1. But unfortunately, the suit filed by defendant number 1 is in OS number 70/2002 is now withdrawn in view of the judgment and decree of the first appellate court. The withdrawal of OS number 70/2002 is not a legal impediment for defendant number 1 to initiate fresh proceedings for recovery of plain scheduled properties from the plaintiffs, full stop. In such an event, if any suit is filed, the same has to be decided within a time frame of 1 year. And the same is in accordance with law. The counsel referring this observation made by this court while disposing of earlier RSA filed by the appellants herein. A specific observation is made with regard to the title as well as adverse possession, and only liberty is given to recovery of possession since plaintiffs have proved the title as well as the appellant has not succeeded in getting the relief of declaration by way of law of adverse possession. And hence, the very contentions raised by the appellant is not sustainable under law, and hence there are no grounds to admit and frame substantive question of law. Having heard the appellant counsel and also the counsel appearing for the respondent, and no dispute with regard to the fact that earlier this appellant has filed a suit for the relief of declaration and for permanent injunction in OS number 326/93. It is also not in dispute that the trial court granted the relief of permanent injunction and rejected the relief of declaration by way of adverse possession. And the same has been challenged in RA number 198/2007. And the defendant in the said suit also challenged the same in RA 244/2000. No. Defendant filed RA number 198/2007. And appellant here filed RA number 244/2008 against the dismissal of the declaration. And the said appeal was dismissed, and appeal filed by the plaintiff in the present suit was allowed and set aside the judgment of the trial court. And ultimately suit was dismissed. The said order of setting aside the judgment of permanent injunction and declining to grant the relief of declaration were challenged before this court in RSA number 436 of 2011 and 437 of 2011. And admittedly, RSA, both the RSAs are disposed of by order dated 8th day of June 2011. The operative portion of the second appeal is very clear that RSA number 437 of 2011 is hereby dismissed, confirming the common judgment and decree dated 7/1/2011 in RA number 198 of 2007 and 244 of 2008, passed by the first additional district judge Tumkur, and the judgment and decree dated 1/4/2005 in OS number 326, passed by the third additional civil judge, insofar as it relates to adverse possession. The appeal in RSA 437/6 of 2006 is hereby allowed. And while allowing the same, common judgment and decree of the first appellate court insofar as it relates to RA 198 of 2000 is hereby set aside, wherein the permanent injunction order granted by the trial court, which was set aside by the appellate court, was set aside, and judgment and decree of the OS passed in 326 of 93 restored on file. That means the permanent injunction was granted by the trial court was restored. However, liberty is reserved to the defendant number 1 to initiate proceedings against the plaintiffs for recovery of possession of plain scheduled property. And if such proceedings initiated, and the same has to be disposed of in a time-bound period of 1 year. And hence, the judgment of this court is very clear with regard to the title is concerned. An answer is made that the plaintiff is the absolute owner of the suit scheduled property, and with regard to the seeking of the relief of declaration by way of adverse possession by the appellant herein also declined to grant the relief, and only permanent injunction is granted, and liberty is given to recover the possession in accordance with law. The main contention of the counsel appearing for the appellant that the liberty given by this court is not inure the benefit of curing of the law of limitation. And the very issue of law of limitation is also taken note of by the trial court and framed an issue, that is issue number 4. And trial court also, while considering the issue of the limitation, specifically made an observation in paragraph number 19 that the observation of the Honorable High Court of Karnataka in paragraph number 10 of its judgment that the withdrawal of OS number 70/2002 is not a legal impediment for the plaintiff herein to initiate fresh proceedings for recovery of the plaintiff schedule properties from the defendant number 1 to 4 herein. The present suit has been filed by the plaintiff within the period of limitation from the date of such liberty reserved by the Honorable High Court of Karnataka. Having considered the order passed by this court in paragraph number 10 of the judgment passed in both the RSS is very clear that even withdrawal of the earlier suit filed by the plaintiff in OS number 20 of 2002, wherein sought for the relief of declaration and permanent injunction, a specific observation is made that it is not a legal impediment for the plaintiff herein to initiate the press proceedings for the recovery of plain scheduled property. And hence the trial court rightly taken note of observation made by this court in RSA, giving of the liberty to seek for the relief of recovery of possession. The observation in paragraph number 10 is also very clear that with regard to the title is concerned, no dispute, and the property is purchased by the plaintiff, and the specific issue also framed before the trial court in earlier suit in OS number 326 of 93. And the same has been answered as affirmative that property was purchased, and when the adverse possession claimed by the appellant herein was also declined to grant the same, and only issue is with regard to the recovery of possession is concerned. When the specific liberty was given and making such an observation in paragraph number 10, and now the counsel appearing for the appellant cannot contend that it will not cure the point of limitation as contended by him. And the very order passed by this court in RSA, making an observation that earlier withdrawal of suit OS number 70/2002 is not a legal impediment for the plaintiff herein to initiate proceedings for recovery of the claimed scheduled property. And when such liberty is also given by making such observation, and the said order has attained its finality, and now he cannot contend that the suit is barred by limitation and ought to have filed the suit within 2003, within a period of 12 years from the date of purchasing of the property, and already parties have litigated the matter more than a decade in the earlier suit. And the argument canvassed by the appellant is against the observations made by this court in RSA while disposing of the matter, when the same has not been challenged and when the liberty is given has not been challenged and the same has been attained finality. Now he cannot raise such objection before the court. And hence I do not find any merit in the appeal to comes to a other conclusion. And apart from that, no substantive question of law arises for the consideration of this court. And both the courts have taken note of the observations made by this court in disposal of RSS, and also taken note of material on record. And with regard to the recovery of possession is concerned, when the liberty was given and accordingly possession is sought in accordance with law, and hence no merit to frame any substantive question of law by admitting the same. And hence question of invoking section 100 doesn't arise. Now the discussions made above, I pass the following order. Second appeal is dismissed.
My lord, I am appearing for the appellant. Appellant may not be interested to prosecute this matter. Next week I file the memo, and appellant may not be interested to pursue the matter.
Last time ಕೂಡ no representation ಇತ್ತು.
Representation ಇರ್ಲಿ.
The appellant
ಈ
counsel
ಬೆಳಿಗ್ಗೆ
said
ಫೋನ್
that
ಮಾಡಿದೆ.
appellant is not interested in pursuing the matter. However, he is going to file a memo in the next week, and hence this matter on ಯಾವತ್ತು ಬೇಕು?
Next week ಯಾವ?
Next week ಯಾವ್ದಾರು ಕೊಡಿ. Next Thursday?
ಹೌದು.
27/6. 76.
Appear for the appellant, my lord.
Yes, counsel.
Concurrent findings, my lord.
Ah.
Suit of the plaintiff decreed by the trial court, and my appeal came to be dismissed by the first appellate court. Challenging this appeal, my lord. The dispute is with regard to the open space that exists between the properties of the appellant and respondents, my lord. Now, for the kindly turn to page number 60, my lord. The schedule as stated by the plaintiff is this, my lord. House and adjacent vacant space towards the eastern side bearing accession must 169, measuring east to west 23 feet, north to south 69 feet, situated at Dismissal village so and so. That means 23 feet inclusive of open space, my lord. But the trial court and first appellate court, contrary to the claim, decreed the suit to the extent of 25 feet, my lord, to the eastern side. Page 50 of the judgment paper book may be kindly reported. Page 50.
Page
50, my lord. ಅದರಲ್ಲಿ ಮಿಡ್ಲ್ ಅಲ್ಲಿ therefore ಅಂತ ಬರುತ್ತೆ ನೋಡಿ ಸ್ವಾಮಿ. ಎಕ್ಸಿಬಿಟ್ P12 ಆದ್ಮೇಲೆ therefore ಅಂತ ಮಿಡ್ಲ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ. Middle of the
therefore it is very clear that plaintiff has
therefore it's very clear that plaintiff has got house property measuring east to west 20 feet and vacant space measuring 5 feet situated on the eastern side of the house property of the plaintiff. As that the vacant space measuring 5 feet situated on the eastern side of the plaintiff house is the exclusive property of the plaintiff. Nowhere the plaintiff says the how much is the extent of the vacant space. Now the commission report is also the observations made in the commission report is also marked reproduced at page number 15, my lord. Para 15. ಅಲ್ಲಿ the plaintiff and
report ಹಾಕಿದಿರಾ? Commissioner report
ನಾನು ಒಪ್ಕೊಂಡಿದ್ದೀನಿ, ನಾನು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. Only thing is 23
ಈಗ ಹಾಕಿದಿರಾ ಅಂದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಹಾಕಿಲ್ಲ.
ಅಲ್ಲಿ ಕಮಿಷನರ್ ಹೇಳೋದು
ನೀವ್ ಓದಿರ್ ನಾನ್ ಹೆಂಗೆ ನೋಡ್ಬೇಕು?
ಅಲ್ಲ,
Now
but
we-
ಇಲ್ಲಿ observation
we are
ಮಾಡಿದ್ದಾರೆ.
trying to read the commissioner report. That commissioner report is not before the court.
ಅಲ್ಲ, ಬಟ್ ಇಬ್ರು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿಲ್ಲ, ಕೋರ್ಟ್ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. ಇದ್ದಕ್ಷಣ ಹಾಗಾಗಿ ಅದನ್ನ ಅಪ್ರಿಷಿಯೇಟ್ ಮಾಡಿದ್ದಾರೆ ಕೋರ್ಟ್, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಂಡ್ ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್.
Any discussion in respect of commissioner report?
ಹೌದು, 15 para 15 maybe.
Para 15,
The plaintiff and defendants have not disputed the commission report. Admittedly, the plaintiff has got property measuring east to west 23 feet and north to south 69 feet. Similarly, defendants have got east to west 29 feet and north to south 69 feet. On the careful perusal of this case submitted by the court commissioner, it reveals that defendants have constructed a house property east to west measuring 28.2 feet, and the plaintiff has got a house property measuring 19.10 feet. Further, the said case reveals that there is a vacant space measuring 4.9 feet towards east northern side, in the middle 7.1 feet, and towards the southern side 8.4 feet. So exact 5 feet illa ಓಣಿ ಅದು. ಈ ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ಈ ಪ್ರಾಪರ್ಟಿ ಏನಿದೆ ಅಷ್ಟನ್ನು ಕೂಡ ಪ್ಲೇಂಟಿಫಿಗೆ ಡಿಕ್ರಿ ಮಾಡಿ ಮಾಡಿದ್ದಾರೆ. That is the error committed by the trial court and first appellate court.
But commissioner report is also very clear that you have constructed the house 28.2 feet. How you can construct 28.2 feet?
My case is the open space existing in between the properties of the plaintiff and
Counsel,
defendant.
it is very clear that you only constructed almost entire, your east-west is only 29 feet.
I'm not disputing it.
You have constructed 28.2 feet.
Yes, my lord, I'm not disputing it.
Almost entire measurement you have constructed.
Correct. Adre
how you can restrain the plaintiff by using of that property by constructing?
My case is the open space situated in between the properties of the plaintiff and defendants. They are both are using the same. Common passage anta ನನ್ನ ಕೇಸ್ ಅದು. It is not exclusive property of the plaintiff. But ಅಲ್ಲಿ ಮೆಜರ್ಮೆಂಟ್ ನೋಡಿದ್ರೆ ಒಂದ್ ಕಡೆ 5 ಅಡಿ ಬರುತ್ತೆ, ಒಂದ್ ಕಡೆ 7 ಅಡಿ ಬರುತ್ತೆ, ಒಂದ್ 8 ಅಡಿ ಬರುತ್ತೆ.
That's all.
ಅಷ್ಟೇ ಮಾಡೋದು.
This matter is listed for admission. I heard the counsel for the appellant. The factual matters of the case of the plaintiff before the trial court, that she is the absolute owner in lawful possession and enjoyment of the social property as on the date of suit. And defendant is interfering with the peaceful possession and enjoyment of the social property, and hence claimed the relief of permanent injunction. And defendant appeared and filed the written statement. That is defendant number 2 and defendant number 1 adopted the written statement filed by defendant number 1. The plaintiff's case is that social property is measuring 23 feet east to west and north to south 69 feet. And the claim of the defendant is that they are the absolute owners of the property measuring 29 into 69 feet, consisting of house property, vacant space. It is also their case that there is vacant space between the properties of the plaintiff and defendant number 1 and 2. The plaintiff and defendant number 1 and 2 have been using the said vacant space to reach the lavatory. Since the said lavatory was dilapidated condition, defendant number 1 and 2 have demolished the lavatory. Taking undue advantage of the same, the plaintiff has been claiming right over the vacant space. Further, the plaintiff and her husband have colluded together and tried to close the vacant space by putting fence. When the defendant number 1 and 2 have resisted the illegal act of the plaintiff and her husband, the plaintiff has filed the present suit with an intention to harass the defendant number 1 and 2. The parties are allowed to lead evidence before the trial court, and plaintiff examined himself as PW1 and got marked document exhibit P1 to 26. On the other hand, defendant number 2 got examined as DW1 and got marked document exhibit D1 to 7. The trial court, having considered both oral and documentary evidence, particularly considering the admission on the part of DW1 that he had constructed the house in respect of measurement of 29 into 69 feet, that is entire measurement of his property. And the same is also taken note of the trial court while considering the issue between the parties, particularly in paragraph number 11. And also taken note of the commissioner report. And in paragraph number 15 discussed with regard to the commissioner report. And an observation is made with regard to the plaintiff has got the house property measuring 19.10 feet. And sketch also taken note of that there is a vacant space measuring 4.9 feet towards northern side, in the middle 7.1 feet and towards southern side 8.4 feet existed between the property of the plaintiff and defendant. And having taken note of the construction of defendant house in the entire property measuring 29 into 69, comes to the conclusion that defendant is interfering with peaceful possession and enjoyment of the property of the plaintiff, and answered the issues accordingly and granted the relief of permanent injunction. Being agreed by the said judgment and decree of the trial court, an appeal is filed in RA number 46 of 2014. In first appellate court, considering the grounds urged in the appeal memo, formulated the point whether the impugned judgment and decree of the trial court probabilize the case of the plaintiff and whether it requires interference, and answered the point in confirming the judgment of the trial court, particularly taking into note of the admission on the part of the DW1 in paragraph number 18, and also taken note of the photographs which has been relied upon by the plaintiff in paragraph number 17, and confirm the judgment. Being agreed by judgment of the concurrent finding of trial court as well as the first appellate court, present second appeal is filed before the court. And main contention of the counsel that the plaintiff house property measuring 23 into 69 feet. And an observation is made that in a partition, her husband got the house property measuring 20 feet and vacant space of 5 feet towards east to west. And the said observation is erroneous, despite the plaintiff not claiming that her property east to west 25 feet. On the contrary, she had restricted the measurement east to west 23 feet as per the assessment extract produced by the plaintiff herself. And the same has not been considered by both the courts. And commissioner report is also clearly stated that there exists a vacant space in between the house of the plaintiff and defendant. And at the starting point, the same is measuring in giving details of 4.9 feet in width, 7.1 in the middle, and at the end it is 8.4 feet. And hence court has to frame the substantive question of law that both the courts have erred in decreeing the suit of the plaintiff despite the discrepancies in the measurements mentioned in the plaint. And hence this court has to interfere with findings of the trial court and frame substantive question of law. Having heard the appellant counsel and also on perusal of material and record, and suit is also filed for the relief of permanent injunction, particularly showing the schedule as house and adjacent vacant space towards the eastern side, bearing assessment number 169, measuring east to west 23 feet, north to south 69 feet, and also boundaries shown as east by property of the defendant, west by property of Ramaya, south by Iduvali land, north by road. And both the courts have also taken note of the evidence of both the plaintiff also defendant who have been examined before the trial court. And particularly the trial court taken note of the admission on the part of DW1. He has categorically admitted in the cross examination that he had constructed the building in respect of entire property which he has got. That is 29 into 69. And categorical admission is also there he had constructed the building in respect of the entire property measuring 29 into 69. And the contention of the plaintiff is also that the vacant space which has been left by him and the defendant is interfering. And when he had categorically admitted that he had constructed the house in respect of entire east to west 29 feet and north to south 69 feet, and he cannot cause any obstructions to the plaintiff, which he had left the vacant space towards the east of his, towards the east, wherein the defendant is having constructed the building to the entire extent. And both the trial court as well as the first appellate court extracted the admission on the part of DW1. Even appellate court also in paragraph number 17 and 18, taking into note of photograph exhibit P7. And also the admission in paragraph number 18 comes to the conclusion that the defendant is interfering with possession of the plaintiff in respect of his house as well as the vacant space. And though an observation is made that house is constructed 20 feet into 5 feet, space is available, but the commissioner report is also very clear that the house constructed by the plaintiff is only
1 feet.
And not to the entire extent of his 23 feet. And when such material is there available on record, when the defendant had already constructed the building in entirety, his measurement 29 into 69, he cannot cause any obstruction, and hence I do not find any error committed by both the trial court as well as the first appellate court in considering the material on record, and no perversity is found in the judgment of the trial court, and hence I do not find any substantive question of law has to be framed in second appeal.
One submission, my lord.
No,
29 one submission, my lord. 29 feet or 28.2. ಮತ್ತೆ ನಾಳೆ ಅದನ್ನು 10 ಇಂಚಿನೂ ಹೊಡ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ.
That is your admission, counsel.
ಅಲ್ಲ 28.2 feet ಕಟ್ಟಿರೋದು ಹೌದು ನಾನು.
Your admission extract ಮಾಡಿದ್ದಾರೆ judgment ಅಲ್ಲಿ.
ಅಲ್ಲ
ಎಂಟೈರ್ ಜಾಗ ಏನಿದೆ ಅಷ್ಟಕ್ಕೆಲ್ಲ ಕಟ್ಟಿದೀನಿ ನಾನು ಅಂತ ನೀವೆಲ್ಲ ಕಟ್ಕೊಬಿಟ್ಟು ಅವನ ಬಿಟ್ಟಿರೋ ಜಾಗಕ್ಕೆ ನೀವು ಅಬ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡೋದು.
ಅಲ್ಲ ಕಮಿಷನ್ ರಿಪೋರ್ಟ್ says 28.2.
Fair on your part also. You are enjoying the property to all extent 29 into 69 by constructing the house. Next. Yes, counsel.
My lord, I seek one accommodation, my lord. Because what happened was after compliance, on the file I have misplaced, I have to rebuild. I will look into the court file and make.
The counsel submits that he has misplaced the file and hence seeks time and hence list this matter on 4/7.
Please, I may be permitted to see court.
Nodi, court file nodi. Court.
Appearing for appellant, my lords. Lords, I seek 2 weeks time, my lords. Recently.
No, counsel, suit for partition in time.
No, my lord, appellant is expired, my lord.
2019 appeal.
Appellant death agide, my lords.
Appellant death agide.
Appellant death agide.
ಯಾವಾಗ?
ಅದು ಯಾವಾಗಂತ ಗೊತ್ತಿಲ್ಲ, my lords. Today morning we got to know. Even on respond number 1 is also expired, my lords.
Suit was dismissed and confirmed also. The appellant counsel submits that he came to know that appellant is no more and hence seeks time to verify and make necessary application and hence list this matter on 4/7. 80. Manjanna. Appellant counsel is absent. This appeal is of the year 2019. And records also discloses that even Appeal was filed in 2019. Compliance was made in 2024 in terms of the order dated 4/1/24. And even after lapse of 5 years, the council is not pursuing the matter diligently, and hence one more opportunity is given. If council doesn't appear in the next date of hearing, appeal will be dismissed for non-prosecution. List this matter on 4/7. Prabhakar. Vishwanatha Shetty.
Last of the respondent number 2, my lord.
My name is not shown in the cast title, my lord. This my lord. I filed the wakalat.
ಯಾರಿಗೆ?
Appellants.
ಯಾವಾಗ ಹಾಕಿದ್ರಿ ವಕಾಲತ್?
March ಅಲ್ಲಿ ಹಾಕಿದ್ರು sir, along with Prabhakar ಅಂತ.
ನಿಮ್ಮ ಹೆಸರೇನು?
MN Ramesh.
MN
Ramesh.
ರಮೇಶ್. ಪ್ರಭಾಕರ್ ಇಲ್ವ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ?
ಇದಾರೆ, ಬಟ್ ಮೈ ಕೊಲೀಗ್ ಅವ್ರ ನೇಮ್ ಕಾಲ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನಮಗೆ ಮೆಸೇಜ್ ಬರ್ತಾ ಇಲ್ಲ, ಪ್ರಾಬ್ಲಮ್ ಅದು ಸರ್.
ಅವ್ರು ನಿಮ್ ಕೊಲೀಗ್ ಅಲ್ವಾ?
ಅವ್ರು ನಮ್ಗೆ
ಬಂದೇ ಬರುತ್ತೆ.
ಅಲ್ಲ, ಅರ್ಲಿಯರು ಎಜಿ ಶಿವಣ್ಣ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇತ್ತು. ಇದನ್ನ ಕೊಲೀಗ್ ಆಫ್ ಎಜಿ ಶಿವಣ್ಣ. ದೆನ್ ಆಫ್ಟರ್ ಸೋಲ್ಸೋ ನಾವು ಇಸ್ ನೇಮ್ ಇಸ್ ಅಪಿಯರಿಂಗ್, ಬಟ್ ಅವ್ರ ಹೆಸರು ಬರ್ತಾ ಇಲ್ಲ ಕಾಲ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
ಯಾರ ಹೆಸರು ಬರ್ತಾ
ನನ್ನ
ಇಲ್ಲ?
ಹೆಸರು ಬರ್ಬೇಕು.
ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸ್ತಾ ಇಲ್ಲ ಅಂತನಾ?
ಹೌದು ಸರ್.
ನೀವು ಏನು ಅಲಾಂಗ್ ವಿತ್ ಹಿಮ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಅಲಾಂಗ್ ವಿತ್ ಹಿಮ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಎನಿ ಒನ್ ಆಫ್ ಅಡ್ವೊಕೇಟ್ ಇಸ್ ಶೋನ್ ಇನ್ ದಿ ಕಾಲ್ ಲಿಸ್ಟ್. ಯು ಫೈಲ್ ದಿ ವಕಾಲತ್ ಅಲಾಂಗ್ ವಿತ್ ಹಿಮ್.
ಹೌದು ಸರ್.
ನಾಟ್ ಇಂಡಿಪೆಂಡೆಂಟ್ ವಕಾಲತ್.
ಇಲ್ಲ ಇಲ್ಲ.
ಮತ್ತೆ
ಅವ್ರ ಹೆಸರು ನಮ್ಗೆ ಕಾಲ್ ಲಿಸ್ಟ್ ರೆಗ್ಯುಲರ್ ಬರ್ತಾ ಇದೆ.
ಹೇಳಿ ಏನಿದೆ ಹೇಳಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಆಲ್ಸೋ ಶಾರ್ಟ್ ಟೈಮ್. ಪ್ರತಿ ಸಾರಿ ಟೈಮ್ ಕೇಳೋದಲ್ಲ, ಹೇಳಿ ಏನಿದೆ ಮಾಡಿ.
ಸೆಟಲ್ಮೆಂಟ್ ಏನೋ
both the suits are dismissed confirmed by the appellate court.
ಸೆಟಲ್ಮೆಂಟ್ ಅದಕ್ಕೆ ಮೀಡಿಯೇಷನ್ ರೆಫರ್ ಮಾಡೋದು.
ಈಗ ನೋಡಿ ಇದು
ಅಲ್ಲ, both
Mediation refer within 1 week.
both counsel submit that there is an element of settlement, and hence ಯಾವ mediation ಬೆಂಗಳೂರು ಅಥವಾ ಹೊರಗಡೆ ಅಲ್ಲ? ಬೆಂಗಳೂರು mediation center, and hence parties are directed to appear before the mediation center on ಯಾವತ್ತು ಅಪಿಯರ್ ಆಗ್ತದೆ ನೀವು ಹೇಳ್ಬಿಡಿ, ನಿಮ್ ಡೇಟ್.
28 p.m.
28 ಬೇಡ ಲಾಂಗ್.
28 ವರ್ಕಿಂಗ್ ಡೇ. ಫ್ರೈಡೇ ಇದೆ.
27th 3 p.m.
27th at 3 p.m. The registry is directed to send the records to enable the mediation center to take up the matter.
Entry order may waste.
Entry order ಇದೆಯಾ?
ಅಂಡರ್ಟೇಕ್ ಕೊಟ್ಟಿರೋದು ಅಷ್ಟೇ. ಅಂಡರ್ಟೇಕಿಂಗ್ ನಾಟ್ ಟು ಪ್ರೆಸಿಪಿಟೇಟೆಡ್ ಅಷ್ಟೇ. ಎಂಟ್ರಿ ಮಾಡಿ
precipitate ಅಷ್ಟೇನಾ? The undertaking given not to precipitate is extended till next date of hearing. Appear ಆಗಿ without fail.
Allows the parties to settle the matter, filing a memo for withdrawal.
Settle ಆಯ್ತಾ? Counsel for the appellant has filed memo stating that ಇದೇನು ಎಷ್ಟೊಂದು
ಅವರು both the plaintiffs and the defendants together have alienated.
ಸೇಲ್ ಡೀಡ್ ಎಲ್ಲ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
ಹೌದು.
In terms of settlement.
Yes, my lords. Alienated to a third party, my lords.
So the appellant counsel has filed memo for withdrawal, and also the copy of the sale deed executed by the plaintiff and defendants in favor of one Sri Mohan Shankaran Kutti in terms of the settlement arrived between the parties. And hence the appeal doesn't survive for consideration, and hence memo is taken on record. Counsel for the respondent is also present before the court.
For the
Permitted to withdraw banta? Permitted to withdraw. Tarnath Shetty, ಹೇಳ್ರಿ.
My lord, I am for the appellants, my lord. My lord, the suit is filed by the respondent, my lord, seeking a declaration that she is the absolute owner of the suit schedule properties by virtue of the will dated, my lord. 17/11/2006, my lord. My lord, she has initially, my lord, my lord, the respondent has filed a suit for permanent injunction, my lord, in the year 2010, my lord. My lord, on the ground that, my lord, she is in possession of the suit schedule properties by virtue of the will dated 17/11/2006. Subsequently, my lord, the second appellant herein has filed a suit for declaration that he is the adopted son of one CH-12, who is the owner of the suit schedule properties, my lord. That suit is in OS number 163/2011, my lord. Subsequently, after filing of my suit, my lord, the same suits were pending before the same court, my lord, before the trial court.
Both the suits?
Both the suits were pending, my lord. My lord, after filing of my suit and after filing of my written statement in this suit, my lord, OS number 2009, sorry, my lord, 209/2010.
That is plaintiff suit.
Plaintiff suit, after filing of a written statement, in the year 2012, they have amended the plaint for the relief of declaration that, along with the permanent injunction, declaration that she is the absolute owner of the suit schedule properties. My lord, this plaintiff, the respondent Lingamma, is none other than the wife of my younger brother.
ಏನಾಯ್ತು ಅವ್ರ ಸೂಟ್ ಏನಾಯ್ತು?
Our suit is partly decreed, my lord, holding that she is the absolute owner. But as far as item number 5 is concerned,
1 to 4 ಮಾತ್ರ ಗ್ರಾಂಟ್ ಮಾಡಿದ್ರು, 5 ಕೊಡ್ಲಿಲ್ಲ.
5 ಕೊಡ್ಲಿಲ್ಲ. ಆದ್ರೆ ಇಂಜಂಕ್ಷನ್ ಎಲ್ಲದಕ್ಕೂ ಕೊಟ್ರು. She is in possession ಅಂತ. Swami, the fact is that the respondent Ningamma is none other than the wife of my younger brother. So the Chikkayajuraya is my paternal uncle, my lord. Chikkayajuraya had no issues. So he had adopted the second appellant when he was aged about 10 years, my lord. Subsequently, my lord, both appeals are filed by, my suit is dismissed. 163/2000 came to be dismissed on the ground that I have not proved the adoption. And my lord, I have preferred 2 appeals, my lord. Both appeals were clubbed. 2 appeals. One is against decretal of OS number 209/2010.
209.
209/10, my lord. And against dismissal of my suit, my lord. Both appeals were clubbed, and my lord, as far as first appeal in RA number 206/,
ಅವರು ಇನ್ ರೆಸ್ಪೆಕ್ಟ್
206/2
ಐಟಮ್ 5 ಕೂಡ ಡಿಗ್ರಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ, ಹೌದು, ಅದಕ್ಕೆ ಇಂಜಂಕ್ಷನ್ ಕೊಡಬಾರ್ದು, ಅವರ ಪೊಸೆಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದೆ. ಇಂಜಂಕ್ಷನ್ is rejected, partly allowed my appeal, my lord. Trial court had granted injunction, though declared that she is not the owner. But the appellate court, my lord, held that, my lord, she is not in possession, she has not proved, and she is not declared as the owner. So injunction has been, permanent injunction has been cancelled. My lord, the will, we have denied the execution of the will, my lord. Another point is that, my lord,
whether they have filed any RSA in respect of the allowing of the appeal in
no,
part.
they have not filed any appeals, my lord. Both appeals are filed by me only, second appellant.
Filed by you only.
Yes, my lord. My lord, as far as adoption is concerned, my lord, in the first suit, 2009/10 itself, we have taken a contention that I am the adopted son. I have produced all my original documents to show that I am the son of my adoptive father, Chikkayajuraya, to show that throughout I was living with him from the year 1976, my lord. I was adopted.
Maybe you are living along with him.
No, adoption deed is also produced, my lord.
The adoption?
Adoption deed is produced, my lord.
Adoption
deed ಇದೆ. ಅವರ scribe ಅನ್ನು exam ಮಾಡಿದ್ದೀನಿ. ನನ್ನ natural mother has given evidence as PW3, scribe is DW5, DW2 is my mother, natural mother. My brothers also supported, my lord.
The reasoning is that the very adoption has not been proved anta. Maybe there is a document of
ಇಲ್ಲಿ ಸ್ವಾಮಿ, ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ, ನಾವು ಕ್ಲಬ್ ಮಾಡ್ಲಿಕ್ಕೆ ಕೇಳಿದ್ರೆ ಮ್ಯಾಟ್ ವಾಸ್ ನಾಟ್ ಕ್ಲಬ್ಡ್. ನಮ್ಮ ಈ ಸೂಟ್, ಅವರ ಸೂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ there is no issue was not framed, my lord. When we requested to frame the issue regarding adoption, learned judge, may I take your lordship to page number, ink page number 90, my lord, para number 15 of the trial court judgment. The learned trial judge held that, my lord, since the issue is involved in other suit, I am not considering the adoption, my lord. In the other suit, he held that, my lord, we have not produced any because documents were produced here, my lord. Our request for clubbing also was rejected, my lord, on the ground that issue was seized in OS number. May I read para 15, my lord? The next aspect.
Where is the judgment passed by the trial court in respect of OS number 16311?
I have not, that separate appeal is filed, my lord, notice has been ordered.
Idi already.
ಹೌದು, ಇದೆ, pending ಇದೆ.
ಎರಡು ಒಟ್ಟಿಗೆ ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕಲ್ಲ.
ಹೌದು, ಅದರಲ್ಲಿ ನೋಟಿಸ್
ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್ has been considered by both the.
ಹೌದು, ಅದು ನೋಟಿಸ್ ಆಗಿದೆ.
26 32.
ಹೌದು, ಈಗ ಅದು RSA 1885 of 2022 ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆ. ಡಿಲೇ ಅಲ್ಲಿ, ಇದರಲ್ಲಿ 8 ದಿವಸ ಡಿಲೇ ಇದೆ ಸರ್.
ಆಯ್ತು, ಇದರಲ್ಲ ನೋಟಿಸ್ ಮಾಡಿ.
ಈಗ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿ, ಈಗ ನನ್ನ ಪೊಸೆಷನ್ ಅಲ್ಲಿ ಇದೆ ಥ್ರೂ ಔಟ್. ಅವ್ರೀಗ ಪರ್ಮನೆಂಟ್ ಇಂಜೆಕ್ಷನ್ ಗೆ ನಾನು ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತೀನಿ ಅಂತ ಪೊಸೆಷನ್ ಅನ್ನ ತಗೊಳ್ಳಿಕ್ಕೆ ಅವ್ರ
ಅದು ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿದ್ ನೋಟಿಸ್
ಹೇಳ್ತೀನಿ.
ಅದ್ರ ನಂಬರ್ ಏನು?
18 RSA 1885 of 22, my lord, on 19/7/23. 19/7/23.
ಆಯ್ತು, ಮೋಸ್ಟ್ ಸರ್ವಿಸ್ ಆಗಿರ್ಬೋದು. ಎರಡು ನೋಡೋಣ,
ಸರ್ವಿಸ್ ಆಗಿದೆ
ಆಗಿರ್ಬೋದು.
ಇಲ್ಲಿಗೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕ್ಬಿಟ್ಟು ಇಂಜೆಕ್ಷನ್ ನಾನು ವೈಲೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅಂತ ನನ್ನ ಪೊಸೆಷನ್ ಗೆ ತೊಂದರೆ.
ಅಪೆಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ ಈ RA 26 and 32 arising out of both the
Both the judgments.
judgments in OS number 163 of 11 and 209 of 2010.
ಹೌದು ಹೌದು ಎರಡಕ್ಕೆ
ಎರಡು
ಎರಡು
ಒಟ್ಟಿಗೆ-
separate appeal ಆಗಿದೆ.
ಎರಡು ಒಟ್ಟಿಗೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲೇಬೇಕಲ್ಲ?
ಹೌದು
both the
ಅವರು
appeals
ಒಟ್ಟಿಗೆ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಇದನ್ನು ಒಟ್ಟಿಗೆ ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು ಅಂದೆ. ನೋಡಿ. The counsel for the appellant would submit that other RSA 1885 of 22 is also pending. And already notice has been ordered on 19/7/23 and hence list both the matters on ಯಾವಾಗ ಬೇಕು ಹೇಳಿ.
Since they have already filed an execution seeking protection.
ಯಾವಾಗ ಬೇಕು ನೀವು ಹೇಳಿ ದಿವಸ ಕೊಡ್ತೀನಿ. ಅದು ಯಾವಾಗಿದೆ ಡೇಟ್?
ಅದು ಈ
Execution
month
date ಯಾವಾಗಿದೆ?
ಈ ಮಂತ್ ಎಂಡಿಗೆ ಇದೆ ಸುಮ್ಮನೆ.
ಈ ಮಂತ್ ಎಂಡ್ ಆದ್ರೆ 28 ಹಾಕಿರಲ್ಲ?
ಆಗ್ಬೋದು.
28.
Plaintiffs are the appellants. Suit for partition and separate possession. The trial court decreed, not the.
Equal 7 share was given.
Yes, the trial court will not decree the suit. On an appeal by the defendants will not, the appellate court will not reverse the finding insofar as item number 3 to 10 and 18 and 19 and suit for partition is dismissed to that extent and will not the.
Only item number 1 and 2 ಮಾತ್ರ
1 and 2 ಗೆ 1/7 share ಕೊಟ್ಟಿದ್ದಾರೆ. 11 to 17 ಗೆ 1/14 share ಕೊಟ್ಟಿದ್ದಾರೆ. Saying that blood item number 3 to 10 and 18 and 19 were self-acquired property, individual property by virtue of the grant of occupancy right. But as a matter of fact, blood the very DW1 Lord herself admits that Lord it is they were all jointly Lord cultivating the land as on the date of prior to the death of their father. And Lord, this that particular evidence has not been appreciated by the first appellate court, and there is no severance of status as freedom Lord as alleged by the defendant.
Counsel divergent finding ಇದೆ, that is also with regard to the more number of properties. Matter has to be admitted and it can be considered together.
My only submission to my lords is early hearing maybe because early hearing.
I will frame the substantive question of law, I will fix the date by dispensing the paper book.
Yes, because records are also. Records are.
Heard the appellant counsel and also the counsel appearing for the respondent. The factual matters of the case is that case of the plaintiff before the trial court while seeking the relief of partition contended that all the properties are belongs to the family and entitled for share. And the trial court also considering the material on record in OS number 87 of 2011 granted the relief, granting 7 fair and equal shares in respect of the suitable properties. The same has been challenged in RA number 13 of 2015. The first appellate court allowed the appeal in part and modified the judgment and held that plaintiff number 1 to 5 are each entitled for 1/7 share and plaintiff number 6 to 8 are together entitled for 1/7 share and defendants are together entitled for 1/7 share in respect of item number 1 and 2 of the plain schedule property. And held that plaintiffs have no right to item number 3 to 10, 18 and 19 of the plain schedule property. And hence their suit is dismissed in respect of those items. It is also held that plaintiff number 1 to 5 each entitled for 1/14 share and plaintiff number 6 to 8 together entitled for 1/14 share and defendants together entitled for 8/14 share in respect of item number 11 to 17. Being agreed by the modification of the judgment and decree of the first appellate court present. Appeal is filed by the plaintiffs questioning the same. Having perused the material on record, there is a divergent finding, particularly in respect of some of the items of the properties. And no dispute with regard to the relationship between the parties. And only entitlement of share is concerned, matter requires to be determined in this second appeal. And hence, this court has to frame the substantive question of law with regard to the issues involved between the parties. Admit. The following substantive question of law arises for the consideration of this second appeal. Whether the first appellate court has justified in reversing the judgment and decree of the trial court in respect of item number 3 to 10, 18 and 19 of the scheduled properties, ignoring the admission of DW1. Whether the first appellate court has erred in law disbelieving exhibit P11 by holding that there was no pleading relating to the said document. Whether that includes in first substantive question of law ನಲ್ಲಿ ಬರ್ತದೆ. ಇನ್ನೇನ್ ಬೇರೆ ಏನ್ ಬರೋದಿಲ್ಲ, that's all. Whether the first appellate court committed an error in modifying the judgment of the trial court as ಏನೋ ಅದೆಷ್ಟೋ 14th ಅಂತೇನೋ ಹೇಳ್ತಾರಲ್ಲ.
ಹೌದು.
In respect of
114th share.
114th share. In respect of item number 11 to 7.
17.
11 to 17 of the plain scheduled properties. Suit is for the relief of partition and hence filing of paper book is dispensed. Suit is also of the year 2011, almost decade has been elapsed. And hence this the matter for final hearing on. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ.
Any date, my lords, till then, my lords, final decree, my lords.
So and so, ಯಾವಾಗ?
Now, my lords, commission report has already been filed, my lords.
ಯಾವಾಗ?
ಲಕ್ಷ್ಮಿ, ಅದು ನಿನ್ನೆಗಿತ್ತು, ರಿಪೋರ್ಟ್ ಫೈಲ್ ಮಾಡಿದಾರೆ. ಹೌದು.
ಆಯ್ತು. Final drawing of final decree stay ಮಾಡೋಣ. ಏನಾಯ್ತು ಮೇಡಮ್? List this matter for final hearing on 18th of July.
ಆಗ್ಬೋದು.
Since already records are received.
Please.
Drawing of a final decree is state in a state of hearing.
Please, oblige.
Eighty-five. Madhyana 1:30 remaining matters are 2:30.
And for the appellant, the parted matter in the afternoon. Weeks accomplished. Life matter ನಡೀತಾ ಇದೆ.
Other side idara ಹೇಳಿದಿರಾ? Apparent counsel seeks time on the ground that there is a parted matter before portal number 30. 13 and already intimated the counsel for R3 na Balakrishna Shastri ಅವ್ರಿಗೆ ಹೇಳಿದಿರಾ? And R4 ಇವ್ರು ಯಾರು ಇದಾರಲ್ಲ ಬಾಲಸುಬ್ರಹ್ಮಣ್ಯ came for R3 ಅಂತ ಹೇಳಿದಿರಾ? And also counsel for R4 A to D. And hence list this matter on 4/7. Amended cast rate ಹಾಕಿಲ್ಲ, ಯಾರು ನೀವೇ ಇರ್ಬೇಕು ಮೇಡಮ್. Amended cast rate ಹಾಕಿಲ್ಲ. In the meanwhile, directed to file amended cast title.
Serial number
100, ಹೇಳಿ.
Intimated the other side also, is also here. May be taken up next week, madam, not feeling.
Apparent counsel seeks time. Partition suit ಅಲ್ಲೇನ್ರಿ? ಮತ್ತೇನು other side ಯಾರು? And also counsel, appellant counsel seeks time and counsel for the R1 and R2 is also present. There is no objection. List this matter on 4/7.
Serial number 95, my lord.
95. ಹೇಳಿ ಏನಾಗಬೇಕು?
My lord, senior is not available today, my lord, due to some. I'll inform, my lord.
Inform ಮಾಡಿದಿರಾ?
ಇನ್ನು ಮಾಡಿಲ್ಲ madam.
ಮಾಡಿಬಿಟ್ಟು ಮಧ್ಯಾಹ್ನ 2:30 ಹೇಳಿ, ಕೊಡ್ತೀನಿ ಟೈಮ್.
My lord, the serial number 97, my lord.
ಹೇಳಿ.
I am ready in 91. 97 pray for an accommodation, my lord.
97 ಅಲ್ಲಿ ಯಾರು ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲ, ಅದಕ್ಕೆ
ನೋಡಿ. The appellant counsel seeks time on the ground that he is ready in serial number 91.
Yes.
And hence.
ಅಲ್ಲ, ತಪ್ಪಾಗುತ್ತೆ ನಾವು ಹೇಳಿದ್ರು.
This matter on 4/7. ನೀವೇನ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಅದು ಬರ್ದಿದೆ.
ಅಲ್ಲ, my lord, instead of 4/7, my lord, may request for 11th, my lord. Also, ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ತಮ್ಮ ಮುಂದೆನೇ ಇದೆ ಅದಕ್ಕೆ.
ಆಗ್ಲಿ. 11th ಲಾಸ್ಟ್ ಲಾಂಗ್ ಡೇಟ್ ಆಗುತ್ತೆ. 5th ಕೊಡ್ತೀನಿ.
ಅಲ್ಲ, ಆ ವೀಕ್ ಇರಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
11th.
Serial number 85, next matter.
ಎಲ್ಲಾರು ಟೈಮ್ ಕೇಳಿದ್ರೆ ಹೆಂಗ್ರಿ? ಮಧ್ಯಾಹ್ನ ಏನ್ ಕೆಲಸ ಮಾಡೋದು?
85 ಅಲ್ಲಿ ಏನಾಗಿದೆ, ಅವರು ಅಪಿಯರ್ ಆಗಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಪಿಯರ್
85 ಅಡ್ಮಿಷನ್ ಗಿದೆ.
ಹೌದು, ಅವರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಅಪಿಯರ್
ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಹಾಕಿದಿರ ವಕಾಲತ್ತು?
ಹಾಕಿದ್ದಾರೆ.
ಯಾವಾಗ ಹಾಕಿದಿರಿ? The counsel Sri Ramakrishna BA. Counsel BA Ramakrishna submits that he has filed wakalat on 13/6/2024 and hence registry is directed to put up the wakalat and show the name of the counsel for respondent, ella respondent ga
Sole respondent.
sole respondent.
Hold on, sir.
And hence list this matter on 4/7.
ಮೂರನೇ ತಾರೀಕು
85, serial number 85.
ಮೂರನೇ ತಾರೀಕು
ಮೂರ್ ಬೇಕಾ? ಆಯ್ತು, ಮೂರು.
appellant to file a furnish a copy of the
ಇವತ್ತೇ ಕೊಡ್ತೀನಿ,
ಏನು?
ಇವತ್ತೇ ಕೊಡ್ತೀನಿ.
appellant to file furnish a copy of the appeal.
ಕೊಟ್ಬಿಡಿ, ಕಾಪಿ ಕೊಟ್ಬಿಡಿ. The appellant counsel is directed to furnish the appeal memo to counsel for the respondent.
Serial number 92 ಮೇಲೆ
90? ಹೇಳಿ ಏನಾಗ್ಬೇಕು? 92.
appeal for
ಎಸ್
appellant.
ಎ ಸುಧೀಂದ್ರ ಜ್ವಾಲಕುಮಾರ್.
Please,
ಹೇಳಿ.
respondent also is
Huh?
present.
ಇಬ್ರು ಕೇಳ್ತಾ ಇದ್ದೀರಾ? Both counsel seeks time. List this matter on 4/7.
5/7
ಆಯ್ತು, 5/7.
entry ಮಾಡ್ರಿ ಮೇಲೆ.
Entry ಮಾಡಿದ್ಯಾ?
Yes.
IO extended till next date of hearing.
ಏನಾಯ್ತು? 70. ನಂದೇ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಮೇ ಬಿ 85, 86 ಅರ್ಜುನ್ ಆಯ್ತು. ನಂದು 88, ಅಕ್ಕೆ 87 ಇದೆಯಾ ಅಂತ ಕೇಳೋಣ. ಅದೇ
Madam,